Hello, court officer.
Contempt for same matter which I had moved earlier also. It appears that in their connected writ appeal, the office objections are still pending. But this one matter, my lord, the last pay protection during the first week of this roster, my lords were pleased to hear it for some time. Next week antagitu, but it is not posted since then. Kindly, my lord, please. Idu on the portal 3.
LIC matter, my lord. Appeal by the Karnataka name. Appeal by the Karnataka Nera name. Attachment warrant issue ಮಾಡಿದ್ದಾರೆ. LIC matter, my lord. Tomorrow, my lord.
LIC matter. Covered by judgment. This honorable court has already disposed of some matters.
Please give that. We'll see the dates and then they will arrange.
Yep. Next week.
ಎಲ್ಲ ಇಸ್ಕೊಳ್ಳಿ. ಎಲ್ಲ ಇಸ್ಕೊಂಡು ಅಷ್ಟು ರೀಚ್ ಆಗತ್ತೆ ಅಂತ ಇಟ್ಕೋಬೇಡಿ. ನಮ್ಮ ಪ್ರಯತ್ನ ಮಾಡ್ತೀವಿ ಬಟ್ ಬರಲಿ ಲಿಸ್ಟ್ ನಲ್ಲಿ. ಓಲ್ಡ್ ಮ್ಯಾಟ್ರಸ್ಸಿಗೆ ಪ್ರಿಫರೆನ್ಸ್ ಕೊಡಬೇಕು.
Serial number 38, Your Lordship. Appear on behalf of R2, Your Lordship. Senior is out of town, some personal inconvenience due to Your Lordship. Kindly next week, Your Lordship, I pray to.
ನೆಕ್ಸ್ಟ್
R2.
R2. Have you informed him?
No, Your Lordship.
Then he will be waiting. No? Waiting. Madam is there. Just inform.
ಹೇಳಿ.
39, Your Lordship.
39?
39, sorry, 39.
LIC
39. LIC matter.
Old matter. No.
Please,
2000.
date may be fixed, Your Lordship.
No problem.
Next week, date may be
Based on
fixed.
some earlier releases, order is passed.
Please, date is may be fixed, Your Lordship. Due to some personal inconvenience, he is not
Sir,
out.
why there is no justification to adjourn?
ಕೇಳಿದ ತಕ್ಷಣ ಕೊಡಲ್ಲ. ಮದರ್ ಡೇ
We'll see.
the honorable president of India has said. You
Please,
know that.
please.
Then
No, 13 matters.
Please,
22,
11 years ಆಗಿದೆ.
please,
Wait.
please.
Wait ಮಾಡಿ.
37.
Put on that mic.
I'm for respondent number 8, my lord.
Serial number
37, my lord.
13
37, my lord.
37.
Res-
These are claimants.
RR Mane sir is out of station, my lord. Kindly have it on any other.
Yes. No time granted because he is opposing. Not.
Lord, I am a proxy counsel.
He is opposing. We are not giving.
Lord,
time. Yes. You sit.
I'm proxy counsel, my lord.
Whatever we tell, whoever made you proxy, tell them. Yes.
Orders, serial number 1, Y. Lakshmikant Reddy.
My lords, I have published it on 19/8, my lords.
Taken
Yes, my lords, it was
Taken.
taken.
within the date.
Yes, my lords.
Call out ಮಾಡಿಬಿಟ್ರೆ.
The parent file the memo along with the copy of the paper publication for having taken the solicited service by way of paper publication.
In terms of court order.
In terms of the order dated so and so. Names of the respondent.
Very.
V. Chandra Nayak, Rajshekhar Nayak.
Names are called out. They remained absent. Service on so and so. There is no response.
Service as
Service as against so and so is sufficient. Registered reflect their name. Fast.
2, Srikanti Patil.
Comply the office objection and file necessary application, my lord. Will comply the office objection in regarding the LR's application.
Order? No, this is response number 2. Somebody has appeared, whether he can accept. No, R2, somebody is earlier filed with Bharat, whether he can accept, otherwise we have to issue notice.
Notice ಮಾಡಬೇಕಾಗುತ್ತೆ.
Notice on I, 1/24. A week's time is granted to take step. Already it is abated, when it is purple. Notice on I, 1/24. Insofar respond number 5, the appeal stand dismissed statutorily.
Will file necessary application to the.
You do that, we can recall now.
Abatement happens by operation of law. Where is the liberty to the court to say otherwise?
No, my lord.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ?
This.
You can file application.
3, SM Kalbat.
ಅದರಲ್ಲಿ ಸೆಕೆಂಡ್ ಸೆಟ್ ಆಗ್ಬೇಕು ಡ್ಯೂರಿಂಗ್ ಕೋರ್ಸ್ ಆಫ್ ಡೇ ಐ ಆಮ್ ದಿ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಮೇಡಮ್.
Password, otherwise we will not.
ಪಾಸ್ ಅವ್ರು ಅಷ್ಟೇ. ಸ್ವಲ್ಪ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಹಾಕ್ತಾರೆ.
5 line 10 report. ಇದರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾಟರ್ನ್ ಪ್ಯಾರಿ ನೋಟಿಸ್ ನೋಡಿ ಹಾಕೊಳ್ಳಿ. ಈ ಕೋರ್ಸ್ ಹೇಳಿ ಅದು ಸೊ ಅಂಡ್ ಸೊ ಅಲ್ವಾಡ್ ಎಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಫಾರ್ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ನಲ್ಲಿ ಕ್ರಾಬ್
4, Ashokar Kalyan Shetty.
ಹಾ ಏನಿದೆ?
To refix the pay in terms of the government order dated 15/2/1999. In terms of that, we are trying detailed affidavit refixation.
ಮಾಡಿದ್ದೀರಾ?
Affidavit ಬಾಜು ಸಹ ಹಾಕಿ ಅವರು 2 ಸಲ ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರು, ಅದಕ್ಕೆ ನಾವು ಇದು ಹಾಕ್ತೀವಿ.
ಮೊನ್ನೆ ಅನೆಕ್ಸರ್ ಡಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸರ್ ಸೆಪ್ಟೆಂಬರ್ 3ನೇ ತಾರೀಕಿಗೆ ಅನೆಕ್ಸರ್.
ಹಾಕಿದ್ರಾ?
ಹೌದು, ಕಾಂಟ್ರೋವರ್ಸಿ ಡೀಟೇಲ್.
ಏನಂತ ಹೇಳ್ತಾರೆ ಅವರು? ಅಲ್ಲ ಈಗ ಗವರ್ಮೆಂಟ್ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಮಾಡಿ ಹೇಳಿ.
May I make submission, my lords?
ಎಸ್
Yes, my lord. My lord, the order may kindly be seen at annexure A, my lords. Page 36. There is positive direction to revise and fix the pension in terms of GO dated 15/2/1999, which I have produced at annexure D along with my counter affidavit.
ಹಾ
Clause 2 of the said GO at annexure D, my lords. First page itself.
ಮೊನ್ನೆ ಅಫಿಡವಿಟ್ SOB ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸರ್ ಅದರಲ್ಲಿ.
ಕೌಂಟರ್ ಅಫಿಡವಿಟ್.
ಹೌದು, ಅನೆಕ್ಸರ್ ಡಿ ಪೇಜ್ ನಂಬರ್ 6 ಮೇಲೆ.
ಪೇಜ್ 2.
Clause 2, my lords.
Revised pension and family pension.
Yes, my lord, it says basic pension plus DA. This DA has to be read along with clause 2.4. 2.4 might go down below, my lords.
Consequent upon revision of pension with.
Yes, 16% from 1/4/1998 and 22% from 1/7/1998. And the third additional is 32.5 of basic pension. So this is the.
No, this GO itself is not applicable to you, is their contention.
Pardon, my lords?
Is it? This GO is not applicable to him. ಹೆಂಗ್ ಮಾಡಿ ತೋರಿಸಿ.
No, this is applicable to us.
1 second.
This is applicable to us.
1 second.
What their contention is, my lord,
ತೋರಿಸಿ.
this is applicable, but to the learned
Let us
single
read the mandate of the
order.
order.
Yes. Yes.
Response state is directed to fix and pay revised pay. Fix and pay also.
Yes, my lord.
To the patient in
online,
terms
the
of.
government order
Consequent
dated
benefits with
1 second.
interest.
You are disturbing, Mr. Shetty. You are disturbing the court when we want to be with you. Yes.
Government order
Sorry, my lord.
15/2 annex C in writ petition number 10351 and 23 and government order dated 15/2/99 in writ petition number and other government order issued from time to time in furtherance of the government order dated 15/2/1999, which is made applicable to similar situated employee and grant all consequential benefits that will flow from he grant of the revised pension along with the interest only for a period of 3 years prior to filing of the present petition and not for the permanent date.
What,
Their
you-
contention is.
What you have done to other similarly circumstanced people?
My lord, admittedly, we have fixed 15. What done happened, my lord?
One
With
second.
res-
Answer.
Yes,
What you have done to other similarly
Similarly,
circumstanced retirees?
retired, my lord.
ಎಲ್ಲಿದೆ list?
In the mentioned in the writ petition, they, my lord, similarly persons who are mentioned in WP connected matters.
Second matter.
ಅಲ್ಲಿದೆ
103519.
3.1 ಅದರಲ್ಲಿದೆ and 1016 similar
101673.
ಅಲ್ಲ ಅಂದ್ರೆ similarly situated person ಗೆ ಮಾಡದಂಗೆ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು. Lord, what happens? There is some mistake was happened for us.
We do not know.
ಅಲ್ಲ ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ ಅದನ್ನ ಹೇಳ್ತೀನಿ.
One second.
Yes.
Step by step ಹೋಗೋಣ.
Please.
ನೀವು ಹಾಗೆ ಹೇಳ್ಕೊತ ಹೋದ್ರಲ್ಲ. ಇದೇ ರೀತಿ ಇರುವಂತ ಎಂಪ್ಲಾಯೀಸ್ ನಿಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ
ಇದ್ರು ಬೇರೆ
ಅವರಿಗೆ ನೀವು ಏನು ಮಾಡಿದ್ದೀರಿ?
ಮಾಡಿದ್ವಿ 15/2 ಪ್ರಕಾರ ಅವ್ರಿಗೆ ದಿಸ್ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ರಾಂಗ್ ಆಗಿ ಫಿಕ್ಸ್ ಮಾಡಿದ್ವಿ ನಾವು 15/2/1990 ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ದಿಲ್ಲ. ಅದಕ್ಕೆ ಈ ಆರ್ಡರ್ ಆಗಿಂದ ಇವರಿಗೆ 15/2/1990 ಪ್ರಕಾರ ಆರ್ಡರ್ ಮಾಡಿ ಅವ್ರಿಗೇನ್ ರಾಂಗ್ ಆಗಿ ಮಿಸ್ಟೇಕ್ ಆಗಿ ಕೊಟ್ಟಿದ್ವಲ್ಲ ಅವ್ರನ್ನ ನಾವು ವಾಪಸ್ ತಗೊಂಡ್ಬಿಟ್ವಿ. ಹೌದು ಅದನ್ನು ಆರ್ಡರ್ ಹಚ್ಚಿದ್ದೀನಿ ನಾನು. ತಾವು ಆಮೇಲೆ ಅವ್ರದ್ದು ಏನ್ ಕೇಸ್ ಅಂದ್ರೆ R4 ಮಿಲೋಡ್ 15 R4
ಅದನ್ನ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಇವ್ರ ಕೇಸ್ ಏನಂತಂದ್ರೆ ಮಿಲೋಡ್, they are not disputing that we have fixed in terms of 15/2/1999. What their case is, since that was applied, my lord, applied wrongly to other person, giving more weightage, adun kodi anta. Then
So you have withdrawn that order.
we have noticed that this order 15/2 is wrongly, my lord, fixed in so far them. So what we have done, we have fixed here in terms of 15/2, but alli fix wrong fix madidna withdraw ಮಾಡ್ಕೊಂಡು, because we have noticed that, my lord, some mistake was happened. The order dated 6/7/24. Running phase R4, running phase
So
15.
what is given to others is now given to him adanಗ ಆಗ್ತದೆ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್. ಅದೆಲ್ಲಿದೆ ಅದು?
ಅದು ರನ್ನಿಂಗ್ ಫೇಸ್ 15 ಅಲ್ಲಿ ಹಾಕಿದೀನಿ ನೋಡಿ ಆರ್ಡರ್ ನಾವು
15.
ಎಸ್ ನೋಡಿ.
Para 6
ಎಸ್
of your affidavit.
ಎಸ್ ನೋಡಿ ಅದನ್ನ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹೇಳಿದೀನಿ. Assembly submitted in order to clarify the authorities, the comply the direction, the state going to issue a further direction on to the appropriate authority.
ಕಲ್ಯಾಣ್ ಶೆಟ್ರೆ,
Yes, my lord.
ಅವರು ನಿಮ್ಮ ಬೇರೆಯವರಿಗೆ ಎಕ್ಸೆಸ್ ಕೊಟ್ಟಿದ್ರು ಅದನ್ನೆಲ್ಲ ರಿಕವರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿಬಿಟ್ಟಾರ.
My lord, that is, my lord, independent of that order, my lord, the
Call after 2 weeks. ನಾವ್ ಯಾಕೆ ಪರ್ಸನಲಿ ಇಲ್ಲಿ ಬರ್ರಿ ಅಂತ ಹೇಳ್ತೇವೆ ಅಂದ್ರೆ ಈ ರೀತಿ ಹಿಂಗಾಗಿ ಇಂಜಸ್ಟಿಸ್ ಆಗ್ತದೆ ಕ್ಲೈಂಟ್ಗೆ ಆಗ್ಲಿ.
Next week ಅಲ್ಲಿ one date.
ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ.
Next week ಅಲ್ಲಿ one date.
2 weeks. Next.
5. Gayatri, sir.
Please, madam. Let's we have filed this appeal challenging the order passed by the honorable single bench of this honorable court. It's a GST matter, my lords. There is a delay of 17 days in filing the appeal, my lords.
ಏನು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ, ಮುಂದೆ ಡಿಲೇ ನೋಡೋಣ.
My lords, there are 3 contentions which were not even considered, which pertains to the jurisdiction of the authorities, my lords.
Jurisdiction of the authorities.
Yes, my lords. The goods were confiscated under section 130 of the CGST Act. What happens is that
Who is that authority who ought to have passed the order?
Ultimately the question pertains to goods in transit. So 130 is not invocable with respect to goods in transit. That's what we have contested. That
Repeat slowly.
We are the supplier of the goods. The goods were being stock transferred. While the goods were in transit, they were detained, seized, and confiscated by the authorities.
Yes.
Karnataka GST authorities. What happens is that from 2021 year onwards, due to the amendment in Finance Act 2021, the law has been amended, my lords. what, due to that amendment, what has happened is, my lords, that section 130, which pertains to confiscation, is not applicable with respect to goods in transit. So
Not applicable to
goods in transit. So if any contravention is, my lords,
goods in transit are exempt from confiscation.
my lords,
Which is that section?
let's may kindly have section 130 and section
30.
1. Let's may kindly have the,
How prior to amendment it was?
I have stated in the memo. I have also reproduced the relevant sections also.
Which paragraph?
My lords,
Which page?
Page 18.
18.
my lords.
Similar matters are pending.
Pending ಏನಿಲ್ಲ.
Any similar matter is pending?
No.
I'm not aware about this code, but in Bangalore it is pending. my lords.
It is pending?
My lords.
That's what, then. That is.
Because 129 or 30.
129, 130 issues pending before honorable.
The Supreme Court decisions are not there on that.
Let's, what happened is that on the similar point,
What do you wanna
They say that if it is in transit,
Is
this
exempt from
confiscation will
confiscation, not applicable.
Because that is not the objective. Otherwise, authorities' powers are restrained.
So the emergent notice on. Emergent notice.
my lords,
Delay ಇದೆ ಅದಕ್ಕೆ.
my lords.
Delay ಇರ್ತದೆ.
Yes.
Huh?
Yes.
Learned HCGP is requested to accept notice for
1 and
1 and 2, respondents 1 and 2, full stop. The appeal is filed after booking a delay of,
17 days.
a short delay of 17 days, and an application supported by affidavit seeks its condonation. Full stop. Learned counsel, HCGP appearing for the respondent, although opposed the application, comma, we are convinced that delay needs to be condoned because of its shortness and also because it would not add any extra merits to the case of appellant. First, application allowed and delay is condoned. We are next paragraph. We are told at the bar that almost identical matters have been admitted in the Bangalore bench
My lords.
and are pending. Full stop. That is a sufficient ground for granting admission in this matter as well.
Remedy has to be kept open.
Keeping open the issue of availability of alternate remedy. Okay.
Let's, this one small request I have, the goods are still in their custody. So if whatever security they may.
What orders they have made in bench?
It is on page number 193.
193.
193, it is of Andhra Pradesh High Court, same contention on the same grounds.
In Bangalore bench.
Same they have followed. Same order.
193.
193.
What is that?
Let's, similar contention was raised before Honorable Andhra Pradesh bench, which was then taken to Supreme Court, and the matter was, let's, admitted in that regard.
Because of the proceedings within 193 says,
Let's, page 194 is the operating part of the order.
ನೀವು ಒಂದು objection ಹಾಕಿ.
Right.
Let them file objections.
Right.
Okay.
Then we'll consider
Yes.
this game.
Yes.
Very simple. What are the goods?
Let's, Ariga nuts, Ariga nuts, my lords. My lords.
All these cases, standard.
Let us see.
Please.
Let's, Bangalore bench has taken 25% of the disputed amount and the rest the personal bond. I'm
Let us
just
see, let us
requesting.
see. Let them file objections.
My lords, my lords.
After all, Areca net, that its expiry date is very long, although it causes expiry of.
I am not commenting on
Yes.
it. Please. Oblige, my lords.
6. Vidyavati, what to shift?
In this contempt matter, my lord, we have prepared a writ appeal and my lord has also already connected other contempt matters with.
Call this matter along with writ appeal number so and so next week.
Please, please.
7. H.N. Gul Reddy.
I am undertaking to produce that copy, certified copy of that, that is NOC for regarding that Muskie, my lords, that order by the honorable single judge. Day after tomorrow, it maybe I will produce it, my lords.
We are producing it.
Yes, I complete it, please.
Learned DSG. Venkatesh appears for accused ಅಲ್ಲ?
ಅದು ಒಕ್ಕಲತ್ ಹಾಕಿದ್ದೀನಿ, read ಆಗಿಲ್ಲ.
Okay. Accused.
Day after tomorrow,
He says that he has already filed power.
please.
Day after tomorrow. After next week ಬರ್ಲಿ ಅದೇ ಹೊತ್ತು ಬರುತ್ತೆ ಮ್ಯಾಟ್ರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ. ನೆಕ್ಸ್ಟ್ ವೀಕ್.
8, Sukumar Padwadi.
8 and 9, that's it.
But in this matter, my lord, I have filed wakalas for all the accused. But I'll file my counter affidavit my next week.
No, that way. Read the notice of format of contempt. Wakalati one date avela now gothilla avela. Wakalati is a matter between you and your client.
Yes.
We are not concerned with that. Yes. Yenidu what is the
Page
order?
13 is the direction issued by the lower single judge.
13.
Page 13. Para 7. May I read?
Take a decision on representation.
Yes, ma'am.
Any other specific mandate is there?
Let's see, in the light of direction issued by this court in WP number so and so, with
Yes.
connected matter disposed of 11/4/2023 in accordance
All
with
right.
the.
What is the endorsement you have given now?
Let's till date, let's no endorsement.
Lord, one endorsement have been given.
ಕೊಡಿ.
Copy is only one copy.
ಅವೆಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಕೋರ್ಟಿ ಬರುವಾಗ. ಜೆರಾಕ್ಸಿಗೆ ಒಂದು ಡೇಟು, ವಕಾಲತಿಗೆ ಒಂದು ಡೇಟು, ಅದನ್ನೆಲ್ಲ ಆ ರೀತಿ ನಾವು we cannot launder the time of the court.
Tomorrow, my lord, at
No,
least.
no question. We'll read that. You should have kept it ready. You know that 2 judges are sitting here and so many advocates will be seeing your performance.
Please.
ಮತ್ತೆ ಅವಾಗ ಇದ್ಕೊಂಡು ಸೆನ್ಸಿಬಲ್ ಇಲ್ಲದ್ರೆ ಏನ್ ಮಾಡು?
Lord, their claim is, Lord, regarding the differential, my lord, from.
What is the representation?
Let's, here is a case where let's the petitioner is a contractor, class 1 contractor, entered into an agreement in the.
No, how you say that no decision is taken from your side?
Let's still.
But he says decision is taken already. Why that so much gap between you and your client?
So communication is, let's see, he has
My
not.
lord, I have been told, my lord, that is issue.
This is communicated to him.
Otherwise ಹೆಂಗ್ ಬರ್ತದೆ ಅವ್ರ ಕೈಗೆ?
Lord, I've been told, my lord, that communication is 8/9.
Representation is considered.
Please, my lord, consider, my lord, some more documents have been summoned. But my lord, the issue is, my lord,
In your favor only,
He
they
said
are
it
asking
is
documents.
issued on 8/9.
So documents ಕೇಳಿದಾರೆ, ಆ documents ಅನ್ನು ಕೊಡಬೇಕು ಅವರಿಗೆ.
that's why, 1 or 2 days time, my lord.
No, he has to furnish.
Let's, we have furnished all the documents.
ಅವ್ರಿಗೆ ಕೇಳಿದಾರೆ, ಇಂತಿಂತ document ನೀವು ಕೊಡಬೇಕು. ಇವ್ರ claim.
Pursuant to single judge orders, let's, I have furnished entire documents to the respondents.
Again, demand is made.
Let's,
ಏನೋ documents ಬೇಕು ಅಂತ ಕೇಳಿ.
let's, I will furnish it. Let's, there is no impediment
Lord, the
for me to
decision is
produce all
taken,
those
my lord, that is entitled for refund. The calculation, my lord, there is some discrepancies.
Let's,
But
we
for
have
that,
furnished the
documents
entire
have been
documents.
summoned.
If
Can you furnish?
It's not that it's not
any
considered.
other documents they required, I will furnish it. I will
Counsel
furnish it. There is no impediment.
appearing for the respondent submits that an endorsement has been sent to the complainant on 3/9/2024 soliciting certain documents for information. First off, if that is complied with, there would be no difficulty for complying with the order of the learned single judge. First off, counsel appearing for the complainant agrees to furnish the documents. Documents. First off, call this matter next week.
Please.
Immediately.
Let,
Documents immediately, furnish documents immediately ಕೊಡ್ಬೇಕು ಅವರಿಗೆ.
let's, today only, let's, I will instruct my party to furnish them.
Yes.
Let him make a copy of.
First off, on furnishing such document or information, the respondent shall comply with the writ and report compliance. Call next, for this purpose, call this matter next week.
Please.
Okay.
9 is also same.
Same.
Next also same. Common. ಎರಡು ಸೇರ್ಕೊಂಡು ಒಂದು document. Yes,
10, Sunita P. Kalsu.
yes.
This, your lordships, my 2 submissions are your lordships.
Yes.
One office objection stage al file ittu, same file I have produced. So the compliance agilla ant helbittu, that is an objection, your
You
lordship.
tell on merits ಏನಿದೆ ನೋಡ.
Please, merits, your lordships, annexure G is the order, your lordships.
What is that?
Impugned order, annexure G is the page 59. The-
District Caste Verification Committee, 1990 Act.
Please.
Ah.
As per the order of this honorable court and the same being confirmed in the writ appeal and in the Supreme Court, your lordships.
But order is appealable under 4D. Under 4D, there is an appellate authority.
Please, your lordships, even that objection was raised by the government before the learned single judge, before the division bench, and the Supreme Court in Chandrakant's case has confirmed that for this reason, the appeal is not necessary. The court, the order,
Do that.
I shall pass on, your lordships. Kindly pass over,
See, you are the appellant.
please.
You know the law. And still you have not kept the file ready.
Your lordships, I apologize, my sincere apologies.
What is that apology? You are having rich experience.
Kindly
not a
pass over,
fresher.
your lordships, kindly pass over. I will produce it within 15
Reluctantly
minutes.
passed over. Time waste ಮಾಡ್ತಾ.
11, MB Kanu.
Please. My lord, there is a delay of 879 days in filing the review.
879 days.
Yes, ma'am.
Your order.
For taking the legal opinion on the railways matter.
ಅಥವಾ ಅವರು ಆ ಜಡ್ಜಸ್ ರಿಟೈರ್ ಆಗಲಿ ಆಮೇಲೆ ಹಾಕೋಣ ಆ ರೀತಿ ಏನೋ ಇದೆ ಇದ್ರಲ್ಲಿ.
No, not.
ಎಷ್ಟು ಆಲ್ಮೋಸ್ಟ್ ಮೋರ್ ದೆನ್ 2.5 3 years nearly. 2.5 years. ಏನು explanation? Explanation for the delay.
My lord, since the opinion
that opinion of Attorney General was necessary. Which is that? You show that. Your opinion, ಯಾವಾಗ ತೊಗೊಂಡ್ರಿ? Why you need to take an opinion arose? Where have you explained in your application?
Yes.
I'll just retire ಆದ್ಮೇಲೆ ಹಾಕುವಂತದ್ದು ರಿವ್ಯೂ ಬೇಕಾದಷ್ಟು ಬರ್ತಾ ಇದಾವೆ. ಅಂತವನ್ನೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಯಾವುದು? Application.
I'll produce that document because the date is not mentioned.
No time will be given that way. Court affidavit ನಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ?
Only
Back ಇದೆ ನೋಡಿ, ಎರಡು ಇದೆ ನೋಡಿ.
Page 118.
yes.
ರೈತರು ಹೊಲಕ್ಕೆ ಹೋಗುವಾಗ ಏನೆಲ್ಲ ಮಾಡ್ತಾರೆ ಅದೇ ರೀತಿ ಕಾನೂನಿನ ಕೃಷಿ.
May I read, my lord? Matters to be considered in determining compensation. 1. The market value at the date of the publication of the declaration and section 15 of the Karnataka Highways Act. My lord, 23.
Section 23.
Yes, my lord. Matters to be considered in determining compensation.
Correct.
Number,
I'm asking simple question to you.
yes, my lord. Yes,
Do you agree that standing tree is a property?
yes, my lord. I do agree. my lord.
Do you agree?
Yes.
It fits into earlier 19(1) it was, now relegated to 300A. Whether standing tree, if that is property, will it fall within the ambit of 300 capital A?
Yes, my lord. Yes, now judgments are also have
We'll
come.
go step by step.
Yes.
We'll go by Socratean
Yes, ma'am.
method. If you cannot take property in the light of KT plantation, you cannot take private property for any purpose unless you make the payment of compensation. Should you not pay the compensation for property other than immovable property?
Yes, ma'am. Compensation only here only we are challenging. Solatium and
So compensation is payable.
yes, ma'am.
If you pay compensation on immovable property, lands, you will pay solatium also.
Yes, ma'am.
Then if you pay compensation for movable property, how solatium can be, what is the logic?
12% what is paid under 1A cannot be paid on the solatium also. That is
Yes,
why
ma'am. Yes, ma'am. That
it is entitled only on first component.
first
that is
component.
market value.
Yes.
So on solatium interest of 12%
Yes, ma'am.
is not
But
liable.
not liable.
Is your case?
Yes, ma'am. Yes.
Under 23(1A.
Yes.
12% interest, what statutory interest is there?
Yes.
That is should be calculated only on the market value.
Yeah, yes,
Not
ma'am.
including the solatium.
Yes.
Is your case?
Yes, ma'am.
In view of this.
Yes.
ಹಂಗೆ ಹೇಳ್ಬೇಕು, ನೀವು ಹಂಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ.
This,
ನೀವು ಹೇಳೋ
what-
something else you are
no,
saying.
What the reference court has done,
Reference court, my lord, that reference court order is
but unless whether that is committed mistake, then you have to go there and correct it.
illa. Ali lordship kindly peruse the page number 19, my lord.
If the order has merged into our order, ಅವಾಗ ಬರಲ್ಲ.
Here, where is that agreed portion of the judgment?
No, Honorable High Court, my lord, confirm the reference
Dorsi,
court.
Dorsi,
Yes, my
Dorsi.
lord. Reference court award, page 19, my lord.
19.
Yes, my lord. Paragraph 1, I may read, my lord. The claimants are entitled for compensation at the rate of 25,000 per gunta with regard to acquired lands. The market value in respect of 103 tea goods in survey number so and so fixed at 10,000 each. Further, market value in respect of 13 wind trees in survey number so and so fixed at rupees 5,000, 50,000 each. In addition to that, they are entitled for additional market value of 12% per annum on market value fixed above in respect of land and trees.
No, no, please see this last paragraph of the order.
Yes, madam.
Of page 19, the claimants are also entitled for solution 30% on the market value.
Of value of trees antanu bandbittidare.
Trees also
properties anta.
Trees is not excluded.
Yes, madam. Tree is not excluded.
See, acquisition of property can be
Yes, madam.
immovable property or movable property. Whether it is confined to only movable property. It is both. V.G. Ramachandran on law of land acquisition and compensation says 1894 Act is applicable to acquisition of movable and immovable property.
Yes.
Because the word used is property, not land. Land is a species of property.
Sir, section itself is very clear.
Section is clear. Yes, madam. Here only interpretation of. Yes.
First part, the market value of the land. 23, no?
23, yes.
First, the market value of the land published as on 4/1. Second one, please see this. What are the words referred?
The damage sustained.
It is not the market value.
Standing.
On that, interest is not entitled. Damage which may be on the land.
Sustained with the person interested in claim damage to the land
Damage
is
caused to the standing crop, or to the land, or to the but standing structure, trees are the market value.
property is defined. Immovable property is a transfer of property, General Clause Act 2. Immovable property is defined both under the Transfer of Property Act 1882 and the General Clause Act 1897. Both they define. Immovable property means land, things attached to property, rooted into property, etc. Only standing crop, growing crop and standing timber alone are grass is also excluded. Gross is.
Transfer property means
Section.
means sorry. Property definition. Property definition. Clause, 3.
Transfer property, na? That is what is immovable property.
Immovable property means does not include
Property.
standing timber, growing crop,
Ah.
or grass.
Grass. Standing timber, growing grass, or
Growing crop or grass.
growing crop or grass.
Other than that,
Everything is immovable property. So trees and other things, unless they are cut and dried, they will be part of the immovable property. And what about Justice G.N. Sabhahitru, the senior judge, he has held it that way. ಅಲ್ಲಿ ಕೊಡೋದು ಡ್ಯಾಮೇಜ್ ಇದೆಯಲ್ಲ ಅದು ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ರಿಮೂವ್ ಮಾಡಿದಾಗ ಆಗುವಂಥ ಪ್ರಾಪರ್ಟಿ ಡ್ಯಾಮೇಜು ಬಟ್ ಈ ಕ್ರಾಪ್ ಅಂತಲ್ಲ ಕ್ರಾಪಿಗೆ ಆಗುವಂಥ ತಗೋಬಹುದು ಗ್ರಾಸಿಗೆ ಆಗುವಂಥ ತಗೋಬಹುದು ಬಟ್ ದ್ಯಾಟ್ ವಿಲ್ ಬಿ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಇಮ್ಮೂವಲ್ ಪ್ರಾಪರ್ಟಿ ದೇರ್ ಆರ್ ಸಚ್ ಜಜ್ಮೆಂಟ್ಸ್ ಮುಲ್ಲಾಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಆಕ್ಟ್ ಕೊಡಿ ಅದಿದೆ ಇಮ್ಮೂವಲ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಡಿಫೈನ್ಡ್ ಇನ್ ಜನರಲ್ ಕ್ಲಾಸ್ ಆಕ್ಟ್ ಆಲ್ಸೋ ಕೊಡಿ ಅವರಿಗೆ ಇಮ್ಮೂವಲ್ ಪ್ರಾಪರ್ಟಿ ಡೆಫಿನಿಷನ್ ತಕ್ಕೊಡು ಅಂತ ಹೇಳಿ ಎಲ್ಲ ನಮ್ಮ ಕೈಯಿಂದನೇ ಮಾಡಿಸ್ತಾರೆ immutable property is defined.
Land benefits
Rising out of the land.
or anything
immutable
attached to
property,
the earth.
section. Anything attached to the earth ಇದೆಯಲ್ಲ
Attached to the land.
ಅದರಲ್ಲಿ ಟ್ರೀಟ್ ಮಾಡಿಬಿಟ್ಟಾರೆ ಟ್ರೀಸ್ ಅನ್ನ ಎಕ್ಸೆಪ್ಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಟಿಂಬರ್ ಬಿಕಾಸ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಟಿಂಬರ್ is excluded. Gross
Attached to the earth, everything.
excluded. Standing timber ಅಂತ anything attached to the earth ಇದೆಯಲ್ಲ
Yes.
subject to certain. Mullah discusses 2 judgments of Allahabad High Court. ಯಾವುದು ಅಟ್ಯಾಚ್ ಮಾಡಿದ್ರು ಇಮ್ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ ಲೈಟಿಂಗ್ ಕಂಬ ಇದೆ ಹಿಂಗ್ ಅಟ್ಯಾಚ್ ಮಾಡಿದ್ರು ಅದು ಇಮ್ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ ಆಗಲ್ಲ ಅಂತ ಮಾಡಿದ್ದಾರೆ 2 judgments are there. But rest of the things,
Yes,
they are immovable property. Otherwise they would have said all botanical things
Are growing things.
they have excluded grass and growing crop and grass ಅವೆರಡನ್ನು ಬಿಟ್ರೆ ಎಲ್ಲದೂ immovable property. Including your right to fish in the pond is held to be immovable property. Fishing right is immovable property because it's a benefit arising from immovable property. ಬರ್ಕೊಳ್ಳಿ ಏನು ಅದು beneficiary of acquisition and new.
Yes, my lord. Beneficiary.
The beneficiary of acquisition has presented this review petition seeking recall of a coordinate bench judgment dated 5/4/2017 rendered in MFA number 24490 of 2010 connected with MFA crop number 10061 of 2014. First, learned senior panel counsel appearing for the appellant, the review petitioner, takes us through the contents of affidavit supporting the application filed seeking condonation of delay, which again is too long. Yes, this on 900 odd days. So on so. There is a cryptic description as to why delay has been brooked. First of all, we cannot call that even a thumbnail discussion. First of all, therefore, no case is made out for condonation of delay. First, next paragraph. The above being said, we have examined the main matter on merits as well. First up, the contention of learned panel counsel that the judgment now put in review seeks to grant solatium to the standing trees in the property acquired, and that is impermissible, comma, falls foul of Article 300 capital A of the Constitution, which does not discriminate the property immovable property for the movable property, comma, the expression employed being property as a genus, and all other things like jura in re aliena and jura in re propria, etc., being the species thereof. First, section 3 of the Transfer of Property Act 1882 and also the General Clauses Act 1882, 1897 define what is immovable property. First, only growing crop and grass alone are excluded from the idea of immovable property, rest all falling within its gamut. First, if compensation needs to be paid for acquiring the private property for public purpose, comma, it goes without saying that compensation needs to be paid to the benefits arising from such property. First, in the above circumstances, we do not find any merits in the review and therefore dismiss it. Please.
Well, GA Dixinmat.
In serial number 12,
yes,
I appear for respondent number 2, my lord,
yeah,
who is the beneficiary of the acquisition. On
yes,
20th of August, my lord, I think my learned friend, instructing counsel, Mr. Veeresh, had appeared and had sought transposition, my lord, of respondent number 2 as applicant number 3. And thereafter, my lord, when confronted with the question as to whether you'll pay the court fee, had said that there's some difficulty in paying the court fee and therefore withdrew the application. But I think
your client also wants to lay challenge to this one.
yes, we also want to lay challenge.
All right.
And
Whether
if the lordship permits us, we'll pay the court fee.
you will pay the court fee also.
We'll pay the court fee as well, my lord. Therefore, we requested to recall that order and permit us to be transposed.
No. What is the ground on which they seek transposition? Suppose if they are getting a great view or a view to other. You are not you are not even the beneficiary of acquisition.
Yeah.
The decision of apex court.
We are because we are a SUC, my lord. We are a SUC, my lord, a single unit complex.
Single unit complex.
Cost for the single unit complex, my lord. So I would.
Archana cited one Supreme Court decision saying allotee at the hands of KADB is not a beneficiary. Which is that judgment? If that is so, what's to be transposed?
There seems to be, my lord, one judgment in the case of Mittal Steel, ArcelorMittal, where they were considered as a beneficiary and said the beneficiary must be necessarily heard and they must appeal the order that is passed.
No, that was under 18.1 reference.
Same, there was an 18-month reference, which enhancement is now being sought but not by the land losers. 88% of them have accepted the consent award and have been paid. This is the balance landowners who have filed a reference under Section 18. Therefore, a general award was made, and that was there's an enhancement made of, if I may say so, rather strange enhancement. The court holds that they have not proved the value of the land, but simply fixes 5 lakhs over and above the general award.
Which is that paragraph which you relied upon other day?
8, 10 to
12
and 19 below.
1-9. Huh? Where is the statement 19? We see no reason to take a different view than the view taken by the court in can neither be said to be a beneficiary nor a person interested for the purpose of determined compensation. Kindly see, Mr. Dhan.
My lord.
2022 10 SCC 461.
Yes, lord. Is that the ArcelorMittal case, lord?
19 only, they have succinctly said what's the ratio emerging.
Lord, is that the ArcelorMittal case or?
This is no, Gregory, Gregory Petrov versus Mangalore Refinery, MRPL.
Oh, I see.
2020.
But there's another judgment, which I think the other side is also referring to, where, my lord, the court has held that without the beneficiary challenging it.
No,
Under
beneficiary,
54.
correct. Who is the beneficiary?
Ah.
That
In-
we, that is
Unfortunately, my lord,
defined
I
by
understand.
judgment.
I want your lordship to see another judgment of Justice Oak, my lord. I don't know if that judgment is before your lordships now.
Which name of the judgment ಹೇಳಿ ನೀವು ಹೇಳೋದು?
My lord, it is, I think,
ಹೆಸರು ಹೇಳಿ.
Mr. Viresh has it, my lord. The judgment.
ಯಾವ judgment ಅದು?
ArcelorMittal, my lords. If my lords permit me, my lord.
No, the person to whom, see, acquisition scheme nalli, whether be it 1894 Act or 2013 Act or KIDB Act, acquisition emanates as a result of exercise of eminent domain, power of
Yes.
eminent domain. State does it, subject to exception. It does it for the benefit of another body. Generally, that body partakes the character of company as defined under the acquisition rules, acquisition of
Yes.
property for company rules.
Correct.
But if the company has allotted to XYZ, they do not partake the character of beneficiary is the law. You may
No, no,
argue for defense is another thing.
Yes.
You are on the defense side now.
Yes, yes. I am of course not supporting the appellants. I'm supporting the appellants. My only difficulty is I think your lordship must look at ArcelorMittal's case where KIDB acquired land.
Understand? If you want to support the case of the appellant, you support it even as a respondent.
My lord, I think there's some difficulty here because of a similar situation where the Supreme Court said because the beneficiary did not challenge the enhancement, KIDB cannot challenge the enhancement, and ultimately, my lord, dismissed the appeal filed by KIDB itself. And owing to which, my lord, it has created a difficult scenario for us that if we don't challenge it tomorrow, someone, the other side may cite that judgment to your lordships and say that we will not allow you to now challenge it. That's the difficulty which has arisen now. My lord, I personally, my lord, I think acquisition is for the benefit of KIDB, and therefore KIDB is before your lordships challenging it. There can't be another beneficiary other than KIDB. But that judgment in ArcelorMittal has created a slight difficulty for us. I don't seem to have that.
Then your client was a party before the reference court also.
Yes, yes.
On a point of law, my lords, my lord. On a point of law, my lords. Lords, in Gregory, my lords. In Gregory, my lords, my learned sister, the bar is referring to Gregory, but Gregory was a case where the allotment was made subsequent to the acquisition. My lords, para 10, if my lords were to kindly take, with the permission of the honorable court, my lord, because it's an audacity to submit when the senior counsel is there. Only for my lord, 10 paragraph, my lord. The short question which is posed for the consideration of this court.
That was the case of allotment made subsequent to acquisition.
Please, my lord. But this, my lords, is a single unit complex. Acquisition is made for my purpose.
Acquisition is.
How do? It's not disputed. I am sure my learned sister, the bar will not dispute it. Para 10 may kindly be seen, my lord.
Allotment was made subsequent to acquisition. ಅವನು party ಆಗಬೇಕು ಹೊರಟ ಅಲ್ಲಿ such a lot.
Para 10, if my lord.
Acquisition is made in so many words mentioning their name only. Then they are beneficiaries. There cannot be anything else but the beneficiary.
Para 10, if my lords to kindly take. Para 10 of Gregory, my lords.
We read it.
Please, please.
ಅವಾಗ ಆ time ನಲ್ಲಿ that decision will not be applicable at all ಅನ್ನೋದು ನಿಮ್ಮ contention.
Please.
But if the acquisition, your name is mentioned in the acquisition documents.
Please.
ಯಾವ document?
But even the 28-1 notification. My lord, I will.
There is no dispute.
It is not in dispute.
No dispute.
Do you dispute that acquisition was for the purpose of this company only?
Any acquisition is made prior to acquisition, if they want to transfer it to any of the companies also, it will be in the notification itself.
But this company was mentioned.
Moreover, as per the definition of the KIDB, person interested is to be looked into, If there is any adjustment between the company and the KIDB, that is a different issue. But as per the land acquisition, my lord, we have to see the definition clause also to be taken into consideration, you know.
Which is that?
KIDB definition, my lord, person interested.
No, if, what if land itself is being acquired for the benefit of this company, still it will not be beneficiary in the light of this judgment?
Because they will be, though the allotment is made to them, even then, my lord, they have no right to challenge because
Not only
KIDB
question of allotment, their name is mentioned in the acquisition notification.
even under the land acquisition also, they can come in under the land acquisition for acquisition purpose. They no need to be under the KIDB. Only to see that the award will be delayed.
Madam, in Northern Glass, the Supreme Court has said that they are the necessary parties without making them a
They
party.
are the necessary parties, my lord. There is a judgment.
Or on that ground only matters are remanded back.
I held that way, and I believe that apex court has, I don't
It is
remember the
only to
name.
make them as a party because they have to pay
They are the
compensation
persons
to
who
the
are paying
land
the money.
users, but they are not the
That is a case which, the judgment which you are now citing, is a case where subsequently allotment was made against to one Mr. X. He wanted to challenge. Court said, you do not fit into the parameter of beneficiary. That way. A decision is an authority. 1901, Lord Halsbury said, a decision is an authority for the proposition emerging from the fact matrix of it, and not for all that which would logically follow from what has been laid down. Wynne versus Latham, 1901, House of Lords.
I'll do some research and I'll be permitted to file an objection to the I which has been filed because recently they have filed.
When did they file?
Because 33.
When they did, tell us the date when they filed the application, when you were served with that. Tell the date.
4/9, please, sir.
4/9.
4/9.
4/9, just 1 week ago.
Please.
Because I have
We'll
to
call
take
it next week.
signatures of 33 of land users.
Acquisition 18(1) I have held that he is a necessary party, and there cannot be 18(1) award enhancing the compensation in the without hearing. He need not be a party, but without hearing.
Northern Glass Supreme Court.
If they were not made a
call this
party,
matter-
they can impede and get they can argue. That is the land.
My own judgment is there where,
My lord, have it on 17th, my lord.
17th.
17th. I'm anyway coming to Dharwad on that day. If I can assist your lordships on this matter as well.
You are coming to Dharwad that day?
Yes, my lord. I have another matter before my lord on that same day.
Your lordship, minimum 15 days because 30
No.
at least.
Call on 7. No,
Your lordship,
you have
I
already
have to
given.
file an application.
You may file whatever you want to.
Because 33 land users are there, my lord.
Next.
I'm grateful.
Yes.
PM Shilwan.
For petition. Challenge the order of learner single judge.
Yes, Mr. Shilwan.
Permitting the the petitioner therein for renewal of passport.
Renewal of?
Passport.
Passport.
No, sir. The appellant herein is the wife.
Is there a concept of renewal of passport?
Yes.
Read which section?
Plus the renewal of passport.
Justice End Law of Delhi High Court said there is no question of renewal, idea of renewal of passport. It is always a fresh passport. He said under the old act. Now
No, sir,
change I do not know.
No, sir, under section 8, extension of period of passport. They extend the period of passport.
That's not renewal.
Not renewal. Not renewal, sorry. It is extension of lost passport.
Yes.
I can, sir. Under section 8.
Renewal concept is unknown to passport law.
Yes.
Ah,
No, my lords, the petitioner, my lords, the appellant here in his wife. She filed a complaint on 25/11/2023.
appellant
Against him.
filed, appellant,
Is the wife.
appellant is the wife.
Yes. Marriage took place, my lords, registered marriage took place on 16/11 to, sorry, 6/4/2022.
1 second. Marriage took place on
6/4/2022. It is a registered marriage.
means what? Is it registered under the Special Marriage Act?
No,
Then why do you say registered marriage? Meaningless.
registered marriage. It is registered.
Please.
Marriage solemnized.
Do not confuse us unnecessarily telling something. If marriage is marriage amongst Hindus, Muslims, Parsis happens only by the
then special
performance
marriage.
of rituals. But where a marriage is, such a marriage is registered, it is only extra data available to the government for framing the policies. Where marriage is registered under the provisions of Special Marriage Act, the
Then it is registered
registration brings into existence the marriage. This is the difference, which Paras Diwan in his marriage and I was so beautifully discussed this aspect of the matter. Anyway, yes, all right.
Must both applied, jointly applied for visa to USA. Must they attended, my lords, 14/4/2022, they attended the biometric.
Visa.
Yes, my lords.
Visa or a
Joint visa.
Visa. Visa.
It's a visa.
You had already passport.
Yes.
But
I was,
visa-
my lords, railway employee then. I was a railway employee.
Okay.
My lords, on 18/4 interview was held. Plus, the respondent, who is the husband, got his renewal of visa, my lords, got visa, rejecting my, my lords, rejecting my visa on the ground that he is single, he has not married. That visa, my lords, he got, and he fled to, my lords, USA on 16/11/2023. So 16/11/2022. Now, then I filed, my lords, a criminal case against him, against my lords, for various offences. He applied for, my lords, the extension of passport, my lords, to the magistrate court when the case was pending. It was rejected. He suppressed all these facts before the.
No, we are not understood. All wrong things.
A case was registered against him. My lords,
Case was registered under which provision?
in, my lords, for the offences.
Crime number?
Crime number, my lords, 90/2022.
19.
For, yes, my lords. 90/2022.
90.
For offences, my lords, 498A, 323.
498A,
323.
323,
504.
504.
506. 420, 149 of IPC. In these, my lords, he makes, pursuant to circular issued by the passport authorities, person who wants extension of passport, then he has to get an order from the court for extension of passport.
Which is that?
Plus, that circular he has produced before this, my lords, annexure E, my lords, page 47.
Does it exclude power of the authority to issue
No.
extension?
Court has to, my lords, limit the extension time. Accordingly, they pass an order. That is the circular issued by, because they are not flying to America or foreign countries without attending the court. Therefore, this guidelines was issued. Yes, ma'am. When the case is pending, he has to obtain order from the criminal court. He applied, pursuant to this, he applied, my lords, before the criminal court at page 121. Yes, ma'am. His application was rejected at page 125. These are all additional documents which I produced because he suppressed all these things in the writ court.
Application is rejected.
Yes, ma'am. This order was passed on 4/9/2023. He files writ petition on 5/10/2023 suppressing this fact.
This he has not disclosed.
This he has not disclosed.
And gone away to US now.
Yes, he has gone away to US. And my lords, court can restrict the, no, I'm not saying court can refuse it. Court can restrict the period as per the circular. This is not done in the writ petition. Now, kindly see his application that he want to attend the court. Grounds matter at page number 31.
What was the endorsement challenge for the single judge?
Single judge, my lords, the endorsement was issued to get an NOC from the criminal court.
That is rejected.
Yes.
Because this was suppressed.
Yes. And my lords, kindly, okay, sorry, I'm sorry.
The back.
No, what was the endorsement?
Where is that endorsement?
Yes, ma'am.
Page 46, annexity.
46.
Yes.
Yes, ma'am.
This is by the authority.
Yes.
And it is there, no? Full case number is there. Where is this non-disclosure?
No, in the writ petition, he has not disclosed all those things.
No, this was challenged before the
Yes, ma'am.
annexity was challenged.
Yes. Rejection is not challenged. Rejection is not challenged.
This was the annexure which was challenged before the learned annexity. Annexity, ne?
What was challenged before single judge?
Sealing the letter dated 8/6/2023.
Go to magistrate court. Obtain.
Advised to obtain NOC. That NOC was rejected.
In
And suppressing that he has come.
that he has suppressed and obtained. That he did not mention in the writ petition anywhere.
No, no.
Huh?
No. At page number, kindly see.
Like, it is part, annexure B was crime number, he has, no, it was placed.
Rejection by the learned magistrate.
That is at 125, page 125.
He has gone.
Adna suppressed.
That is not,
That is
suppressed. He has suppressed, he has
No,
suppressed.
he would have not maintained.
ಹೌದು,
the
ಹೌದು.
petition. He would have challenged some kind of revision or something like
Yes,
ಮಾಡಬೇಕು.
that is
ರಿಜೆಕ್ಟ್
suppressed.
ಆದ್ಮೇಲೂ ತೊಗೊಂಡ ನಾವು ಮತ್ತೆ
that. Only.
ಫ್ರಾಡ್ ಅದು.
ಹೌದು.
It's fraud on the court.
ಇಲ್ಲಿ ಕೋರ್ಟ್ ಪ್ರೊಸೆಸ್ ತಪ್ಪಿಕೊಂಡು ಹೋಗುವಂತ ಮಾಡಿದಾನ.
Now, though order is passed, he is not turned up unless NBW issued. He is not attending the court. The main purpose of Malas filing writ petition is he want to attend the criminal court. Till today has not appeared before the court. After obtaining this Malas renewal of passport.
ನೋಟಿಸ್ ತೊಗೊಳ್ಳಿ.
Please.
How we will take notice to?
ಅಲ್ಲ, ನಾವು
ನೋಟಿಸ್ ಹೆಂಗ್ ತಗೋಬೇಕು ನೀವು? ನಾರ್ಮೇಟಿವ್ ಪ್ರೊಸೆಸ್ ನೇ ತಗೋಬೇಕು.
Please.
ಲರ್ನೆಡ್
ಇಲ್ಲ, ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಗವರ್ಮೆಂಟ್ MB Kanvi appears for 1 and 2.
Kanvi 1 and 2 ಇಬ್ರೇನಾ? 3 is 3 and 4
ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ.
Email
3 ಯಾರು?
Three, I will take notice.
4 ಯಾರು? 4 ಯಾರು?
4 is Malas, whose father, who has represented Malas writ petition. He is in USA, Malas. Now, the petition,
against father ಮೇಲೆ ಏನು?
Allah, petition is filed by father on behalf of the Malas third respondent. Third respondent.
ಅವ್ರು ಯಾಕೆ ಫೈಲ್
He
ಮಾಡಿದ್ರು?
has filed the affidavit, signed the affidavit.
Yes, yes. Yes, yes.
But third, how we will take notice to third?
ನೋಟಿಸ್ ಥ್ರೂ ಇದನ್ನ ತಗೋ.
Through Malas
ಇಲ್ಲ
embassy.
Through embassy.
Through embassy, Malas.
CPC ಅಲ್ಲಿ ಸಪರೇಟ್
Embassy.
ಪ್ರೊಸೀಜರ್
I'll
ಇದೆ.
take.
ಅದನ್ನ ಫಾಲೋ ಮಾಡ್ಕೊಳ್ಳಿ.
Adamma.
Kanvi for 1 and 2, learned DST for 1 and 2. Emergent notice to respond number 4. Notice through the prescribed procedure to respond number 3, who is residing abroad.
Please.
Abroad. Okay. Registry to facilitate taking of steps by the petitioner for serving the person on foreign soil.
That.
ಅವೆಲ್ಲ ಏನೇನ್ ಬೇಕು ಅದು ಮಾಡ್ಕೊಡ್ಬೇಕಾ?
Friend, appeal, my lord. These are all similar matters.
Call along with.
My lord, here filed IO number 1 for dispensation of production of
IO number
translation
1?
copy. Next year. Please. Not so bad.
Dispensed for 8 weeks.
In this case, my lords, I undertake to file wakalat for respond number 4, my lords. Today I will file.
Three so and so. Give a name.
Chetan, my lord.
Appears for.
Undertake to appear for. Let me list along with.
15,
Please, my lord.
50 party.
In this matter, the direction is to delete the name of the government, my lord, in the revenue records.
Yes.
Put in survey number and enter the name of the complainants. Pursuant to this order, my lord, Tahsildar, my lord, is already, my lord, processed and initiated, my lord. Now he is also forwarded to the deputy commissioner. The reason is, my lord, even though they have only made the Tahsildar to delete the name of the government in terms of the high court, it is the only the deputy commissioner who can do all the high court orders, my lord.
Deputy Commissioner party.
ಮಾಡಿಲ್ಲ ಮೇಡಮ್ ಅದಕ್ಕೆ ಬಟ್ ನಾವು ಮಾಡಿದ್ದೇವೆ ಆಲ್ರೆಡಿ ಅವ್ರ ಕಡೆಯಿಂದ ಮಾಡಿಸ್ಕೊಂಡು ತಂದು ಕೊಟ್ಬಿಡ್ತೀವಿ ಅಂತ
You assure that he will, ನೀವು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ರಿ ಡ್ರಾಪ್ ಮಾಡ್ತೀವಿ.
ಅಕ್ಯೂಸ್ಡ್ ಆಲ್ಸೋ
ಮತ್ ಮಾಡ್ಕೊಳೋದು ಡಿಸಿನ್ಯಾಕ್ ಪಾರ್ಟಿ ಮಾಡಿರ್ಲಿಲ್ಲ.
My lord, we had only challenged, my lord, the order of the tribunal earlier. And the representation after that was given to the Tahsildar.
Tribunal order set aside ಆಗಿದೆ.
Tribunal order set aside, matter is remanded. Lord.
ಆಮೇಲೆ ರಿಮ್ಯಾಂಡ್ ಏನಾಯ್ತು?
ಇನ್ನು ಮಾಡಿಲ್ಲ.
Any change they will do will be subject to
ಹೌದು ಸಬ್ಜೆಕ್ಟ್ ಟು ಔಟ್ಕಮ್ ಆಫ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು, there is an order.
He is here, he is saying that he will do it 10 days.
ಮಾಡ್ತಾರೆ. ಯಾವತ್ತು ಮಾಡ್ತಾರೆ ಕೇಳಿ ಅವ್ರ ಹೆಸರೆಲ್ಲ ತೊಳಿ.
10 days ಅಲ್ಲಿ.
10 days
days ಅಲ್ಲಿ
ಅದನ್ನ ಅಂಡರ್ಟೇಕಿಂಗ್ ಮಾಡಿ
ಪ್ಲೀಸ್
ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡೋಣ. If they don't do, then you will be landing in great trouble.
You will do it.
You will be landing in great trouble. Do you understand? Yes. Okay. The entries in the revenue records were mutated in favor of the government pursuant to land tribunal order, which came to be set at naught in the writ proceedings. First, a direction has been issued by the learned single judge to restore the entries in the name of the landlord. First, that having not been done, this complaint of contempt has been filed. First, next paragraph. After service of notice, the respondent Tahsildar, having entered appearance through the learned GA, promises the court that the writ of the learned single judge would be complied with by deleting the name of government and retaining the name of complainant.
Subject to outcome.
Within a period of 10 days. First off, he hastens to add that this would be done subject to outcome of the remand pending at the hands of tribunal. Land tribunal. First, next paragraph. In view of the above, these proceedings are liable to be and accordingly dropped with liberty to the complainant to seek their revival in the event the promise given to the court is breached. Please. Breached. Okay.
Next matter also same.
Next matter also same.
2 weeks.
Instead of 10 days or 2 weeks.
Grateful.
Next matter is also same.
Same order. Common order. Okay. 7 separate orders. Okay.
17, Sheila Bellikatti.
Question by the wife, your lordship, respondents, challenging the order under section 9 of Hindu Marriage Act, your lordship.
Restitution of conjugal rights.
He served and
unrepresented.
presented. There's a delay of 603 days, your lordship. Please, your lordship, and she is very much willing to go with the husband, your lordship, but there is a threat, your lordship. So that's why we filed this appeal.
Cut down the delay, no? Delay is there. Why there is delay?
Please, because it was during the COVID period, your lordship, and thereafter.
Third, on I-1 of 24, rules the amendments made in the affidavit accompanying the IA, and also taking note of the fact that not after this is passed against the respond wife, appellant wife, delay of so and so days in the appeal is condoned.
Lordship, they have produced some several additional documents, your lordship.
ಅದನ್ನ 4127 ಕಡೆ ಟ್ರೀಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ along with the hearing.
Maintenance certificate is printed there.
It is granted, but he is not paying, Your Lordship. 3,000 for the wife and 1,500 for both children, Your Lordship. Totally 6,000. Two children.
Children are with whom?
Mother,
Mother.
Your Lordship.
What is your client?
Please, Your Lordship.
What?
I am for the wife.
Wife. What is she doing?
She's not doing anything, Your Lordship. She's housewife. Actually,
What
she has,
children are doing?
they are studying, Your Lordship. One is in a residential school and another is a small kid, Your Lordship.
ಅದಕ್ಕೆ ಅವನಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟು ಈ ಡೈರೆಕ್ಷನ್ ಟು ಬಿ ಸರ್ವ್ಡ್ ಥ್ರೂ ಪೊಲೀಸ್ ಅಂತ ಹೇಳಿ ಬಂದ್ಬಿಡ್ತಾನ.
The officer indicate that the notice on respond number is served. 30th May.
ಒಂದ್ಸರಿ ಹೆಸರು ಕೂಡಿ.
Name is called out.
Ashok Mahadevappa Churi.
Now he is retired, Your Lordship.
Retired.
Where is this?
At Salali, Ramdurga. ಅಲ್ಲ ಇದ್ದಾರೆ.
Service ಆಗಿದೆಯಲ್ಲ ಅವ್ರಿಗೆ?
ಆಗಿದೆ. Called out and officer no response.
No, there is no response. Issue notice once again to jurisdiction police. Returnable by and date body?
Date body. 26th notice.
Mobilized it.
Because you have two children.
He is directed to be present before the court
next day
on so and so for consideration of IA 4 of 24 as well as and maintenance.
Mobilized.
ಅವ್ ಬರ್ಲಿ ಬಂದ್ಮೇಲೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ಹೌದು ಪೆನ್ಷನ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ತಗೊಂಬಂದ್ರೆ ಪೆನ್ಷನ್ ಅಥಾರಿಟಿಗೆ ಆರ್ಡರ್ ಮಾಡಿಬಿಡ್ತೀವಿ ಇಷ್ಟು ಅಮೌಂಟ್ ಇವ್ರಿಗೆ ಕೊಡ್ಬೇಕು ಅನ್ನೋ ರೀತಿ.
She is unable because she is they are not that much studied and army persons, they won't give the details, Your Lordship.
Okay. ಅವ್ನ ಕೈಯಿಂದ ತರ್ಸೋಣ.
18.
Correct.
18 KL Patil.
This is the wife's appeal against ex parte decree of divorce. Lords, in this case, on 9/5/24, delay was condoned and interim order was already granted.
Condoned?
Yes.
Interim order is granted?
Yes, ma'am. On 9/5/2024.
ನೋಡಿ ಅದೇನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿರೋ ಕಾಪೀಸ್. Interim order to continue.
Please.
Interim order to continue. Call parties here.
Your Lordship, kindly fix the date, Your Lordship.
ಯಾವತ್ತು?
Any date, Your Lordship.
ನೀವು ಹೇಳಿ ಯಾವ್ದು ಡೇಟ್ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರೆ ಆ ಡೇಟಿಗೆ ಮಾಡ್ತೇವಪ್ಪ ನಾವು.
Today is the date.
Next week, Your Lordship.
Today is the date.
ನೀವು ಕೇಸ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಅದನ್ನ ಡೇಟ್ ಕೇಳಿದ್ರೆ ಆಗ್ತಿಲ್ಲ. ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು ಕೇಸನ್ನು. Call in the third week of October at the request of counsel appearing for the respondent. Yes.
90. Nagasi Kulluri.
My lord, it's an insurance company appeal challenging both liability and contempt, my lord. Delay of
amount ತುಂಬಿಡು.
Delay of 26.
In this
case.
Agide. They may be permitted to withdraw the 20 lakh rupees out of the deposited amount.
Not. In this case.
They may be permitted to withdraw 20 lakhs of the
How much is award?
1 crore 44 lakh, my lord. The thing is that, my lord, the claimant being the software engineer, she had given the evidence that due to the accidental injuries, she was not working with. And we have produced the salary certificate of the lady before the court below that she was working and drawing the salary. Even then they passed the order under the head of loss of future earning for the injury sustained.
Lord.
Lord.
Future ಅವನು deceased ಇದ್ದು.
ಅಲ್ಲ sir, injured.
Injury case.
Yes, ma'am. My lord, my lord, the accident took place in the year of 2020. That is 29/1/2020. Records took. Bandil.
Records ಬೇಕಾ?
ಬೇಕು.
Heard on IA 3 of 24. Learned counsel for the appellant submits that he has no objection.
No, my lord, that,
In
that
this
is
case-
not to be.
In this case,
My lord,
kind
that is
permission.
not to be.
I have spent the 30 lakhs to pay to the medical. Medical bill is itself is 27
lord.
lakhs, my lord.
Lord, medical expense
my
of 27.
ಬದ್ಲಿ ನಾಗರಾಜ
Yes, my lord.
30.
Please.
That's
Hills
and-
ಇದೆ.
My lord, my lord, my lord. There is a three
My lord,
points are
page
involved.
28 of the
There is the
judgment.
involvement of three vehicles. Even though charge sheet is on me, there is a negligence on the part of the another vehicle, that's a car.
ಜಾಯಿಂಟ್ ಥಾಟ್ ಫೀಚರ್ಸ್ ಆಗ್ತಾರೆ.
Also me, ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು 20 lakhs the amount can be released.
My kind permission. Our vehicle is par.
25. ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತೀವಿ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡ. ಲೆಟರ್ ಗೆಟ್
Any date, my lord. My lord, if they are ready for my lord.
My learned friend submit that 3 vehicle is involved. My vehicles to
ಹಂಗ್ ಮಾಡೋದ್ ಬೇಡ.
kindly
ಕಾಸ್ಟ್
30 ಅಲ್ಲ medical bill may be 30 lakhs may be released. Then my lord,
Except in the cost shown, delay of 26 days in referring the appeal occurred on I3 of 24. Counsel for the applicant submits that the injured has incurred more than 3 lakh rupees to the
medical is.
Considering the claim of the injured and also keeping in mind the fact that the appeal is filed by the insurer challenging quantum of compensation as well as liability, whereof the considered view that interest of justice would be met if the claimant slash respondent is permitted to withdraw 27 lakhs.
Yes. ನಿಮ್ದು
30 ಲಕ್ಷ ಮಾಡಬಹುದು ಸರ್.
ಮುಂದೆ ನೋಡೋಣ.
Please.
That is amount what he has.
My lord, it's to be called along with 102011 of.
TCR.
Call along.
20 MCU carry. 21 Sunanda P party.
Claimants appeal for enhancement as well as challenging the liability. Notice.
Who appears?
For respondent.
Requested to accept notice for
Respondent.
emergent notice to
ಚಂದ್ರಮಾಲಿ
22 Ramachandra Mali.
Appellant, my lords, appellant seeking the judgment, my lords, passed by the trial court on the, only on the ground, my lords, the paternal grandfather has been appointed as the guardian, my lords. Now,
Who are the respondents?
respondent, my lords, respondent number 1 is the grandfather of the minor child, my lords.
Yes, sir.
What is sober?
My lords, there is some urgency, my lords, urgencies, my lords, due to this accident, my lords, the sum amount has been deposited in the name of the minor, my lords. Now, by the order of this lower court, my lords, the respondent number 1 is withdrawing the amount deposit in the name of the.
Issue emergent notice on I1 of 24 as well as on May. Matter requires detailed consideration. During the pendency of this appeal, the respondent number 2 respondents are restrained from withdrawing any amount pursuant to the impugned judgment and award.
Please, my lord.
Preliminary hearing mat 23 Pirish Budhia.
Lords, the petitioners was staying at the foot of the hills, my lord, in Karwar with the western cart belt, my lords, approached this honorable court, my lords, and their prayer, my lords, was only that let, my lords, I have no complaint against the, my lords, the defense system. I stand here only because my brethren are fighting for me, my lords, at the borders. But having said that, without there being, my lords, any EIA, without there being any feasibility report, my lord, there's afforestation.
ನಾವಲ್ ಬೇಸ್ನಲ್ಲಿ ನೀವು ಇಲ್ಲೇ ಇಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ sir. But we are at the foot of the hills. We are at the foot of the hills, my lord. We are at the foot of the hills. We are staying, my lords, at the foot of the hills, which is not within the area of the project scene.
How you are aggrieved ಅಂತ?
My lord, but only because, my lord, there's a deforestation, my lords, and cutting of the trees, my lords, rampantly, without there being a feasibility report. My lord, there is a possibility, my lord. In fact, my lords, almost about 1 year ago, we made a submission before.
What is your individual right? It's a communal right.
But because, my lords,
Communal right.
please,
What is your individual right?
my lords, Lords, the theory of neighborhood, my lords, I may as much swing my hand, subject to condition that will not, my lord, punch into my neighbor's nose. So let the Indian Navy, my lords, carry on any activity. I have no difficulty. My lord, because of the activity, my lord, my lord.
File PIL.
Allah, I can't file a PIL for this reason, my lord. It is my own interest. As a matter of fact, my lord, when filing a PIL, I'll have to file an affidavit that there is no personal interest of mine which is involved in the petition. Here is a case, my lord. All that I'm saying is let there be a feasibility report before, my lords, the Navy does it. There's absolutely no feasibility report. Complaints have been given, my lords, to district administration.
How you are aggrieved?
My right to life, my lord. If at all, my lord.
Right to life ಆ ರೀತಿ ಅಲ್ಲ. ಈಗ ಸಪೋಸ್ ಒಂದು ಸಮುದ್ರದಲ್ಲಿ ತುಂಬಾ ಮೀನ್ ಸತ್ತೋಗ್ಬಿಡ್ತಾವಪ್ಪ. ನಾವು ಅಲ್ಲಿ ಮೀನ್ ತೆನ್ಕೊಂಡು ಜೀವನ ಮಾಡ್ತಿರ್ತೀವಿ. ನಮಗೆ ರೈಟ್ ಟು ಲೈಫ್ ಹೋಗಿದೆ ಅಂತ ಆ ಲೆವೆಲಿಗೆ ಹೋಗ್ತೇವೆ ನಾವು. ಒಂದು ಕಾಂಕ್ರೀಟ್
without there being any study, without there being any study,
Project is completed. It may not serve. Itself is completed. So
in which case, my prayer number 2, my lords. Now I'm seeking, my lord, if at all there's any afforestation without there being a scientific basis, let them, my lords, take steps to, my lord, make
defense project ಇದೆ.
please, defense project.
How so? Must, my lord, please, though, my lords, it's a defense project, my lord, my submission is, my lord, let there be, because it was as if it was a prediction that there is going to be a massive landslide. We have mentioned that in the petition. And exactly. ಮಾಡಿಲ್ಲ ಅವ್ರು ಹೇಳಿ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿ ನಾವು ರಿಪೋರ್ಟ್ ಕೊಡೋದು ಬೇಡ.
ಡಿಫೆನ್ಸ್ ವಿಷಯದಲ್ಲಿ ನಾವು ಅಷ್ಟು ಆ ರೀತಿ ಡಿಫೆನ್ಸ್ ಇರಲ್ಲೆಲ್ಲ ನಾವು ಪ್ರಿಪೇರ್ ಆಗ್ಬರಲ್ಲ. ಅದು ಪ್ರಶ್ನೆ ಮೆನಿ ಬಹಳ ನಮ್ಮ ದೇಶದ ಆಜು ಬಾಜು ಅನೇಕರು ಕೆಲವರು ನಮಗೆಲ್ಲ ಸಮಸ್ಯೆ ಇದೆ, ಹಂಗಾಗಿ ಅವೆಲ್ಲ ಡಿಫೆನ್ಸ್ ಜಜ್ಮೆಂಟ್ಸ್ dismissed, agreeing with the reasoning of the learned single judge. Obliged. Project itself is completed.
24, please. Shivraj. This matter was listed last week, my lords, with regard to that the Kabristan, the land being declared, my lords, for the purpose of graveyard. And my lords,
settlement.
My lords, I've been instructed that, my lords, they want to challenge the grant made in favor of, my lords, the petitioner.
Grant made in favor of?
The petitioner, the original petitioner, the respondent herein, my lords.
ಇದರಲ್ಲಿ ಏನು ಚಾಲೆಂಜ್ ಮಾಡಿದೆ?
ಇದರಲ್ಲ, they want to separately challenge, so my lords, the settlement could not be possible. Because what? Agala. Because this land is, my lords, being utilized as a graveyard, my lords, since Mughals period, I'm instructed, my lords. Even in the grant made in favor,
grant ಕೊಟ್ಟಿದ್ದು ಬಿಟ್ಕೊಂಡು ಉಳಿದಂತ ಲ್ಯಾಂಡ್ ಅನ್ನು ಉಪೇಕ್ಷಿಸಿದ್ರು.
That is what is my grievance. ಅವ್ರಿಗೆ
ಯೂಸ್ ಮಾಡಕ್ಕೆ ಬರ್ತೀರಾ ನೀವು?
Only in 1955-56 record of rights, my lords, it is mentioned that it is Kabristan land. After that, it is mentioned only as government land, my lords.
ಎಲ್ಲ ಕಬ್ರಸ್ತಾನನು ಗವರ್ನಮೆಂಟ್ ಲ್ಯಾಂಡೇ.
It all started in 2019, my lords, when they gave representation to change their survey number from 61 to 58, my lords, on the pretext saying that the boundaries mentioned in 61 does not match earlier survey number 7, my lords.
It's the only.
Granted to you more than that you can't.
Yes, my lords. As of now, yes, my lords. As of now, my lords, what my submission before your lordship says.
Annexure G, no?
Annexure G, my lords. Annexure G, page number 85.
Granted to?
It is, my lords, the portion of the land is declared, my lords, is earmarked for the purpose of usage for graveyard. That portion is 1 acre 24 guntas. She has been granted, my lords, my friend has been granted a portion of 38 guntas in the same land. 38 guntas.
However, the
The
same
total
is not
land
mentioned.
measures, my lords, 2 acres 35 guntas. Out of 2 acres 35 guntas, she is granted, my lords, 38 guntas. So the balance, my lords, is 1 acre 31 guntas, out of which, my lords, 1 acre 24 guntas is granted in my favor.
38 guntas granted to her.
Granted to her. My lords, under in the 1978 under landless as a landless person, my lords, portion is
scheduled caste person.
Scheduled caste.
No, my lords, Lingayat, not as scheduled caste.
Huligewa
Provision is not
Bhimappa
mentioned, my lord. It is just mentioned as to the landless. Under what provision it's not
Annexure G
mentioned?
mentions one Mr. Huligewa Bhimappa reason.
They are others.
In Annexure G, my lords.
They are others. They are encroachers.
My lords, however, in Annexure G, my name does not appear, my lords, that I am in possession of 38 guntas.
71 reserve, under section 71.
Yes, my lord,
Yes,
under
my lord.
section. Reserved. ಎಷ್ಟು 2 ಎಕರೆ 35 ಗುಂಟೆ ಟೋಟಲ್ ಇರೋದು ಅದು ಅದು
In that, my lords, 1 acre 24 guntas is reserved for
1 acre
graveyard.
24 ಗುಂಟಾಸ್ ಮಾತ್ರ
Matra.
ಇಟ್ಟಿದೆ.
It will not affect, my lords, the land whatever is granted to my friend, my lords.
But the only clarification is that Annexure G, my lords, my 38 guntas land is not at all mentioned, my lords, while describing all the portions of land held by
ಈ grant
several
ಮಾಡುವಾಗ.
people. Yes, my lord.
But
At
your
Annexure-
land
Yes, yes, ma'am. I am in possession.
your land was land allotment to you was made earlier to this.
Yes, my lords.
ಯಾವಾಗ?
1977, 78 order prakara
ಎಲ್ಲಿದೆ?
I have been.
Annexure
land-
A, my lords,
Annexure
page
A,
20.
my lords.
Only one survey number or another survey?
Third survey number, my lords,
Yes,
57 and
57
58.
and 58. Total 3 acre 30.
ಅಲ್ಲ ಇದನ್ನ ಈಗ ಅವ್ರಿಗೆ ಈಗಾಗಲೇ ಗ್ರಾಂಟ್ ಮಾಡಿದ ಲ್ಯಾಂಡ್ ಅನ್ನ ಹೆಂಗ್ ರೆಡ್ಯೂಸ್ ಹೆಂಗ್ ಮಾಡೋದು?
Our land will not be reduced, my lords. My humble submission is, she is entitled only to 38 guntas, my lords, out of survey number 58, which totally measures 2 acres 35 guntas.
ಕರೆಕ್ಟ್. 2 acre 35 ಗುಂಟಾಸ್ ಅಂದ್ರೆ 47 80 ಪ್ಲಸ್ 35 115 ಗುಂಟ ಆಯ್ತು.
Yes,
15
please,
ಗುಂಟಾಸ್. ಹಾ ಅದರಲ್ಲಿ 35 ಗುಂಟಾಸ್
38 guntas is in our
38
report.
ಗುಂಟಾಸ್ 105 115 ಮೈನಸ್ 38 ಆಯ್ತು. ಉಳಿದಿದ್ದ ತಮ್ಮ ನಿಮ್ದು
1 acre 24 guntas.
ಎಷ್ಟು ಉಳಿತದೆ?
64 guntas, my lords.
ಅವ್ರು ಕೊಟ್ಟು ಆದ್ಮೇಲೆ ಉಳಿತದೆ.
ಅದ್ಮೇಲೆ ಮತ್ತೆ ಭೂಮಿ ಉಳಿಯುತ್ತೆ.
ಆಯ್ತು ನಿಮ್ ಲ್ಯಾಂಡಿಗೆ ಇಂಟರ್ಫಿಯರ್ ಆಗೋದು ಬೇಡ ಅವ್ರು ಅಷ್ಟೇ.
Yes, ma'am.
This intra-court appeal calls in question a learned single judge's order dated 30 January 2023 entered in private respondents WP number 100235 of 2023 KLR res.
21.
First, Kutali, please. The operative portion of the order reads as under. Nodama. ಇದೆಲ್ಲ Next paragraph. Learned counsel appearing for the appellant vehemently argues to falter the impugned order on the inter alia on the ground that the Khabristan, that is Muslim graveyard, has been existing in the subject land since the days of Mughal, semicolon. Even if the land granted to the contesting respondents herein is left out, comma, Khabristan as it has been, comma, would continue unhindering the interest of the said respondents. First off, learned counsel appearing for the respondents per contra contends for sustaining the order of the learned single judge by supporting the reasons on which it has been structured. First, having heard the learned counsel for the parties and having perused the appeal papers, we are of the considered view that much interference in the matter is not required, in as much as the land in survey number
58, my lords.
58 in all admeasures 115 guntas.
In all measures, 2 acre 35.
2 acres?
35 guntas in all measures.
130. That is 2 acres, 35 guntas. 1 acre is 40
40
guntas.
guntas. Yes.
40 guntas. And that the land allotted to the contesting respondents herein, who happened to be the petitioners, it measures
38 guntas.
38 guntas. In the very same survey number, namely survey number 59, 58 of village, no?
Munirabad village.
Munirabad village.
They are granted 3 acre. Remaining land falls in survey number 27. So clarity.
First, the grant order dated 30 September 1978, a copy whereof avails at Annexure A to the paper book, in its operative portion, reads as under, very paragraph mode, reads as under. Page number 30. Next paragraph. A mere common sense approach to the problem brought before the court would diffuse the dispute in as much as the Kabristan would continue to the extent of
1 acre 24 guntas.
1 acre 24 guntas, as has been specified at Annexure G,
please.
At Annexure G, and that the remainder would continue to be the land held and granted and held by the private respondents herein,
Others also.
in addition to granted to others. In addition, granted to others, any others. First up, both are directed not to interfere with each other's holding. First, with the above observations, this appeal is disposed of.
Please.
Disposed of.
Order passed by the learned single judge.
And the order passed by the learned single judge shall be read, construed accordingly.
The order has set aside this annexure itself, my lords.
That is set aside. Semicolon. Consequently, the set aside there be construed. Rest of the things shall be construed consistent with the reasoning part mentioned above.
Please.
Delay condone.
25, Shokar Kalyan Shetty.
As if tomorrow or day after tomorrow, the council on record is out of station.
Milord, 12th, my lord. 12th. I'm sorry, my lord, sir.
Award compensation. 1 year code. Compensation. Compensation, damages ಆಗ್ತದೆ. To say compensation, it should be under the normative process under 1894 Act or 2013 Act. The V.G. Ramachandran says, compensation, see, there is lot of difference between compensation and damages. We should understand, there is a famous book by Kemp and Damages, Mr. Patil may be knowing that. Kemp and Kemp, an English author wrote, what is damages, what is compensation? Ordinarily, damages is granted by way of recompensation, true, but compensation is granted ordinarily under the statutory schemes like Land Acquisition Act, Inta Act with our Motor Vehicles Act, Railways Act, Inta Act nalli kodtare. Idu damages annodu, it is more the idea operating in law of torts. Even tort nalli, correct, contract nallu bartade, breach of contract ittu andre damages bartade alli, like ಆ ರೀತಿ ಇದೆ. tort nallu bartade, idrallu bartade. ಉಳಿದಂತ ಎಲ್ಲ ಕಡೆ ಕಾಂಪನ್ಸೇಷನ್ ಆಗೋದು. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ CRPCL, there is a provision for payment of compensation, victims compensation, 354 or something like that. 350, 355 or 56, something like that. ಅದರಲ್ಲಿ ಆಯ್ತಾ? ಇಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ನೋಡಿ, ಯು ಆರ್ ಲ್ಯಾಂಡ್ ಲೂಸರ್, ಯು ಆರ್ ದ ಲ್ಯಾಂಡ್ ಲೂಸರ್, ಯು ಆರ್ ದ ಲ್ಯಾಂಡ್ ಲೂಸರ್. ಏನು ಆರ್ಡರ್ ಓದಿ, ಕಮ್ ಟು ಪೇಜ್ 21. Acquisition cannot be compelled. You can't compel the king to do a particular thing because the power of eminent domain. Justice C.S. Venkatramana judgment ಇದೆ. Court Godrej so and so. ಅದನ್ನ ಬೇಸ್ ಮಾಡಿ there is a base, ನೋಡಿ ತೆಗಿರಿ, base corporation versus so and so. ತೆಗಿರಿ, Justice Nagartna's judgment. You can't compel. In extreme cases it may be. You can't compel the state to exercise power of eminent domain. It is like asking the government, central government, you wage war. Huh? You have succeeded. You either succeed or you direction to pay the acquire antide. Pay compensation.
Pay compensation. Directed to award compensation to the petitioner for the framing of road.
ಹಂಗೆ ರೈಟ್ ಟು ಫೇಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೋಟಿಫೈ ಆಗ್ಬೇಕು, ಲ್ಯಾಂಡ್ ನಾರ್ಮೇಟಿವ್ ಪ್ರೊಸೆಸ್ ನಲ್ಲಿ ಎಕ್ವೈರ್ ಆಗ್ಬೇಕು, ಅವಾಗ ಕಾಂಪನ್ಸೇಷನ್ ಬೇಕು. ಅದರ್ವೈಸ್ ಡ್ಯಾಮೇಜಸ್
ಅದನ್ನ ಮಾಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಕ್ವಿಸಿಷನ್ ಮಾಡೇ ಇಲ್ಲ ನಾವು.
ಮಾಡ್ಲಿದಕ್ಕೆ ಡ್ಯಾಮೇಜಸ್. ಯಾರು ನಿಮ್ ಲ್ಯಾಂಡ್ ದುಟಾಯಿಗರಿಂದ ತಗೊಂಡ್ರು ಅಂದ್ರೆ ಅದಕ್ಕೆ ನೀವು ಲ್ಯಾಂಡರ್ ವಾಪಸ್ ಕೇಳ್ಬೇಕು, ಇಲ್ಲ ಡ್ಯಾಮೇಜಸ್ ಕೇಳ್ಬೇಕು. ಲ್ಯಾಂಡ್ ಕೊಡಕ್ ಆಗಲ್ಲಪ್ಪ, ಏನೋ ಒಂದು ಡ್ಯಾಮ್ ಕಟ್ತಾರೆ, ಬೇರೆ ದೇಶಕ್ಕೆ ಬಿಟ್ಟು ಕೊಟ್ಬಿಡ್ತಾರೆ ಅಷ್ಟನ್ನ, ಅವಾಗ ಸೀಕ್ ಡ್ಯಾಮೇಜಸ್.
H1 ನಲ್ಲಿ ತಾವೇ ಹೇಳ್ತಾರೆ ಸರ್, ಲ್ಯಾಂಡ್ ಕೊಡಕ್ಕಾಗಲ್ಲ, ಕಾಂಪೆನ್ಸೇಷನ್ ಕೊಡ್ಬೇಕಂತ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಮಾಡ್ಕೊಳ್ಳಿ, ಏನ್ ಬರ್ದಾರ, ರೀಡ್ 21. Read 21 now.
The writ petition is allowed in part. Respondent 1 is directed to award
compensation to the petitioners for forming a road on the property so and so, by taking into consideration the land value that existed in the year 2002.
It is there for the ration now.
ಅದು ಡ್ಯಾಮೇಜಸ್ ಅಂತ ಓದ್ಕೋಬೇಕಂತ ಅಷ್ಟೇ. ನೀವು ಹಂಗೋದ್ರೆ ಸೂಟ್ ಹಾಕೋಕಾಗ್ತಿತ್ತು. ಎನಿವೇ, ವಾಟ್ ಯು ಅಪಿಯರ್ ಫಾರ್? Who appears? You have robbed land of the citizen. What are you going to do? That is a fundamental right.
I appear as a proxy counsel for the on-record advocate. He's not keeping well. He has sought to tomorrow or day after tomorrow.
Not keeping well. You are here. Your senior is not here.
Please.
My senior is wishing. My senior is wishing.
Your senior idara?
12th ಹಾಕೋಬಹುದು. 12th ಹಾಕೋಬಹುದು ಸರ್. 12th ಹಾಕೋಬಹುದು.
All right.
Lord, may I make one more submission? With regard to the previous matter, my lord, fourth matter, my lord, they are all contempt matter only. Abruptly, my lord, that was. ಅಲ್ಲ, one date ಕೊಟ್ರೆ ತಾಬ್ರೆ. They are all, my lord, senior citizens, 85 years old.
ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್ ಕೊಟ್ಟರೆ, ಡೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್,
ಒಂದು ಡೇಟ್ ಕೊಟ್ಟು 2 weeks ಆದ್ಮೇಲೆ ಅಷ್ಟೇ, 3 weeks ಆದ್ಮೇಲೆ ಕೊಡಿ ಒಂದು ಡೇಟ್.
ಅಲ್ಲ, ಒಂದು ಡೇಟ್ ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕನ್ವಿನ್ಸ್ ಲಾರ್ಡ್ಶಿಪ್.
ಬಹಳ ಪ್ರೆಷರ್ ಇದೆ, ಪ್ರೆಷರ್ ಭಾಳ ಇದೆ, ಇಲ್ಲಪ್ಪ ನಾವು ತಗೊಂಡೇ ಬಿಡ್ತೀವಿ.
ಅಲ್ಲ, ಒಂದು ಕನ್ವಿನ್ಸ್, ಟ್ರೈ ಟು ಕನ್ವಿನ್ಸ್ ಯು ಲಾರ್ಡ್ಶಿಪ್.
Not
one date, one dog.
I am proxy counsel appearing for the complaint, my lord. I am a proxy counsel appearing for the complainant, my lord. With respect to I number 1, my lord, production of a certified copy of annexure.
You are saying you are counsel. When you are making submission, you are a counsel. That's all. We are not barred from entering.
ನೀವು ಹೇಳಿ, ಮಾತಾಡಿ. ನಾವು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ಹೆಸರು ತೋರಿಸ್ತೀವಿ, ಅಲೋ ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸ್ಬಿಡ್ತೀವಿ. ಮಾತಾಡಿ.
My lord, kindly, I don't have the copy, my lord, right now.
What is the direction, sir?
ಕೈ ಫೈಲ್ ಬಂದಾಗ ಯಾವ್ದೇ ಬಸ್ ಟಿಕೆಟ್ ಬಂದ್ರು, ಬರ್ನಾರ್ಡ್ ಶಾ ಸೆಡ್, ಸಪೋಸ್ ನೀವು ಒಂದೇ ಯಾವ್ದೋ ಊರಿಗೆ ಹೊಂಟ್ರಪ್ಪ, ಕಂಡಕ್ಟರ್ ಬಂದು ಬಸ್ ಟಿಕೆಟ್ ಕೊಟ್ಟ.
At the last moment, I
ನೋಡ್
come to know.
ಓದ್ಬೇಕು ಏನಿದೆ ಟಿಕೆಟ್ ಇದು.
Last moment, I come to know about this case.
Take out the page.
My lord, I
How
don't
much
have-
hours required we'll see.
Yeah,
No, my lord, I don't have the file,
Take
my
out
lord.
this page number 16. ಕೊಡಿ. ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ ಫೈಲ್ ಇಲ್ವಾ?
Please.
ಕೊಡಿ.
ಫೈಲ್ ಕೊಡಿ.
I'll give.
ಓದ್ಕೋಬೇಕು.
Who has given this file?
ಪಾಟೀಲ ಹೇಳಲ್ಲನ ಓದಕ್ಕೆ ಗಿಡಕ್ಕೆ
Without
ಅಂತ
a file,
ಅನ್ಕೊಂಡು.
without file, somebody has asked you to appear.
No, my lord, just for proxy counsel, I'm appearing, my lord.
What is the instruction saying?
My lord, with respect to, no, my lord, to take adjournment, my lord.
ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲೆಲ್ಲ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೊಡಲ್ಲ. ಹೇಳ್ಬೇಕು ಜಡ್ಜ್ಗಳು ಸರಿ ಇಲ್ಲ.
Due to personal inconvenience, my lord.
ಕೊಟ್ಟರೆ ನಾವು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಬೇಕು.
Madam has said.
Vidyatham Kotter Shetty.
Notice.
Please.
ಓದ್ಕೋಬೇಕು.
Please.
ಓದ್ಬೇಕು. ಅದೇನು ದೊಡ್ಡದಿರ್ತದ. Palkiwala prepared the that RC Cooper matter within 3 hours. He gave dictation within 3 hours. ಅದು ಅಂಥದ್ದೇನು ಇರಲ್ಲ. ನೀವು ಒಂದು ಸ್ವಲ್ಪ ಓದಿದ್ರೆ ಏನಿದೆ ಏನಿರ್ತದೆ ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರ್ತದೆ, ಅದು ಕಂಪ್ಲೈ ಆಗಿರಲ್ಲ. ಎಸ್
Same, please.
28, Susayam Patil.
Sai, generally he comes.
Kindly pass on file.
Pass
Senior
on.
ಬಂದಿದ್ದಾರೆ ಸರ್ some transport inconvenience.
ವಿಶ್ವನಾಥ್ ಹೆಗಡೆ.
29, Vishwanath Hegde.
Please, my lord.
ಕೊಡಿ.
My lord, at relevant page at para 18, my lord, page number 18, my lord, para number 17, my lord. This honorable court has issued direction to the respondents to comply the order, my lord.
Needless to state that exercise shall be completed within 4 months from the date of. Within 4 months ಮಾಡಕುಂತಿತ್ತು ಯಾರು ಅಪಿಯರ್
How's
ಆಗುತ್ತೆ?
my lord?
Remand.
Remand.
Committee has to do.
Committee has to look into. Please.
ಆಗಿದೆ, ಸರ್ವ್ ಆಗಿದೆನೋ ಇಲ್ಲ?
ಇಲ್ಲ, just first time. Please.
It's not there in the operative portion.
ಅಲ್ಲ, ಅದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್, ಬಟ್ ದಿ
17 ನಲ್ಲಿದೆ, ಪ್ಯಾರಾ 17.
30, Praveen Tarikar.
Yes, Praveen.
I pay for the petitioner in a connected writ petition.
Connected. 30.1.
Yes, 30 point.
ಏನಿದು ಮಲ್ಲಿಕಾರ್ಜುನ್?
This is a case where the date of eligibility of the petitioners, which was fixed by the then competent authority as 4/10/2005, has been unilaterally changed by the government while preparing the gradation list in the year 2019 pursuant to the judgment of B.K. Pavitra. The facts are these. The petitioner was appointed on 26.
G.T. Ramaswamy ಏನು ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು?
They say that the eligibility date will be the date on which promotion will be given. But in the case,
ಆಲ್ಟರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ. In my case, pursuant to the government's approval itself, the date of eligibility minutes giving officiating promotion was given by the government itself.
Government itself. ಯಾವಾಗ ಅದು ಕೊಟ್ಟಿದ್ದು?
Your Lordship's minutes, the regional commissioner passes an order minutes on 12/1/2012.
Date of eligibility ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ರು?
Date of eligibility was given on 8/8/2012. 8/8/2012.
8/8/2012.
Fixing the date as 4/10/2005.
Order fixed date of eligibility
As 4/10/2005.
4/10.
Yes, ma'am.
4/10/2005.
Yes.
2005.
Yes.
ಅದು ಆರ್ಡರ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಆಗಿತ್ತನೋ?
Subsequent ಆಯ್ತು 2012.
ಅದು ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಅದು?
Your Lordship's annexure A5 minutes, page number 65 minutes.
Page number
65 minutes. I'll take your Lordships to the relevant page, page number 68 minutes.
68.
Yes, ma'am. My name finds place at serial number minutes, number 4, so and so. Date of eligibility, your Lordships will get in the last column. Aharta dinanka 4/10/2005. In the last page.
ಶಿರಸ್ತೇದಾರ
Yes, ma'am.
ಒಂದಕ್ಕೆ ಸೇರಿದ ಬಡತಿ ದಿನಾಂಕ ಯಾವ್ದಿದೆ?
10/2/2010 ಸೇರಿದ ದಿನಾಂಕ. ಅರ್ಹತಾ ದಿನಾಂಕ 4/10/2005.
4/10/2005. ಯಾರು ನಿಮ್ಮ ಅಪೋನೆಂಟ್?
Government.
How can you alter this? Ramasamy judgment ಇದೆನಾ?
Yes.
These are all birthmarks ಇವು. ಇವನ್ alter ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಸ್ವಲ್ಪ
ಹೇಳಿ.
These persons initially joined service on 9/3/2000.
9/3/2000.
6/4/2000, 26/7/2000.
9/3/2000, 6/4/2000.
26/7/2000. As an inspector ಅಥವಾ first division assistant ಅಂತ.
ರಾಮಸ್ವಾಮಿ ಚಾಲೆಂಜ್ ಆಗ್ಲಿಲ್ವಾ ಮುಂದೆ?
It has not been, let's say, it did not fill for consideration, let's say.
ಎಲ್ಲರೂ ಚಾಲೆಂಜ್ ಆಗಿದೆ.
But
My
my
case,
case,
Yes, no,
any court followed this? Our high court reiterated this. Just look in.
recent, the law.
9/3/64/26/7.
26/7/2000.
Date of entry.
Entry in the service as an inspector, my lord, first division assistant ಅಂತ. But their case is that, my lord. Their case is as on 4/1/2005, 4/1/2005,
4/1/2005.
4/1/2005, some of nearly 28 persons, 28 persons has placed under Rule 32 for the post of Deputy Tahsildar.
Rule 32.
Rule 32. ಇವ್ರಿಗೆಲ್ಲ ಬೇರೆದವರಿಗೆ.
All right.
ಬೇರೆದವರಿಗೆ. ಇವ್ರ contention, their contention, as on that day, there are other 3 persons were retiring and our, my lord, 3 persons were, 3 vacancies were arising. As on, my lord,
4/1/2005.
2005.
32 ಅಂದ್ರೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ಚಾರ್ಜ್ ಇನ್ಚಾರ್ಜ್?
ಅದು ಇನ್ಚಾರ್ಜ್ ಕೊಟ್ಟಿದ್ರು ಅವ್ರಿಗೆ.
ಇಂಡಿಪೆಂಡೆಂಟ್ ಚಾರ್ಜ್.
Sorry, Rule 30.
Rule 32.
I'll. Independent charge ಕೊಟ್ಟಿದ್ರು. Not for this other 28 persons. Their case is, my lord, as on that day, we are also eligible.
ಯಾರು?
ಇವ್ರು 3 ಜನ. ಯಾಕಂದ್ರೆ these persons completed as a 5-year service in as an inspector or first division assistant, and also there is a 3 deputy Tahsildar were retiring on 31/1/2004, 34/2005, 31/7/2005, 3 vacancy arise ಆಗ್ತದೆ. Therefore, we also should be placed under Rule 32 anta their contention. They went before the KAT, but actually their promotion was on 1/2/2010.
1/2/2010.
10. Your promotion, regular promotion, they are much before that time, they have not placed any independent charge under Rule 32 at all.
Rule 32 is not a case of promotion at
No,
all.
no, that is what their contention before here is. If you see the, my lord, earlier this matter was heard and reserved. Later, my lord, released from the, on the, no, on the ground that, my lord, this court wanted to, my lord, whether before 10/2/2010, whether they have placed under any Rule 32, so that, my lord, they can claim the promotion with a retrospective effect. Their case before the KAT, that, my lord, we should be granted a retrospective effect, fixing the date as 4/10/2005.
That was the eligibility date, na?
4/10/2005.
Yes.
Yes, their
Come
case.
to page 68.
In first
4/10/2005 ಅಂತ ಎಲಿಜಿಬಿಲಿಟಿ ಡೇಟ್ ಕೊಟ್ರಪ್ಪ ನಿಮ್ಮ ಎಂಪ್ಲಾಯರ್ ಒಂದು ಡೇಟ್. ಆ ಡೇಟಿಗೆ ಕೊಡ್ಬೇಕದ್ನ. How you can alter the birthmarks?
One clarification. It is not only this order. Subsequently, my lord, a state seniority list was prepared by them.
ಅದರಲ್ಲೂ ಇದೆ.
Adrelli no date of eligibility is shown as 7/2014.
Throughout they have done that.
Yes, my lord. Only after BK Pavitra they tried.
ಯಾವುದು ತೋರಿಸಿ.
Your lordships will get it at page number 74 minutes. The next year A6.
Date. First matter.
My name is shown at serial number 1471.
74.
Yes, ma'am.
GB Swadi,
GB Swadi.
MS Arkeri, VV Kulkarni.
I am at serial number there, VK Kulkarni. Kindly see the
VV
column.
alva. ಇದು ಫೈನಲೈಸ್ ಆತಾ?
This was finalized, let's.
Final list ಇದು?
ಇಲ್ಲ, this was a state provisional seniority list that was prepared.
It's liable to be changed depending upon the.
Yes, but
Chate Gowda.
by taking note of this, for a next promotion, let's, we were placed under Rule 32 for the post of Deputy Tahsildar, let's.
You were placed on deputy post of the Deputy Tahsildar yavaga?
On 2010-2014. Election A7, let's.
2010-2007.
Yes, Tahsildar grade 2.
14.
2014.
Page number?
Page number, you'll also get it, page number 90 minutes.
A7.
A7. This is under Rule 32, I was placed under Tahsildar grade 2 by taking that date of eligibility itself.
ಆ ಡೇಟ್ ಎಲಿಜಿಬಿಲಿಟಿ ತಗೊಂಡು ಮಾಡಿದ್ದಾರೆ.
ಹೌದು. Otherwise ಇಲ್ಲ, ನಾನು ಬರ್ತಿದ್ದೆಯಲ್ಲ ಈ ಪೋಸ್ಟಿಗೆ.
My case is.
No, you have given the, you have given the eligibility date.
That was, my lord, what happens is, by mistakenly, my lord, which is operated, the reason is it cannot be, my lord.
ಹೇಳಿದ್ರಿ, ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ? By mistake it has been.
Thereafter, my lord, it was corrected. Allah, seniority, my lord, which you have challenged before the KAT.
If you say, by mistake this happened, where have you taken up that contention?
ಅದು ಫೈನಲ್ ರಿವೈಸ್ಡ್ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವರು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದು. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಸೆಕೆಂಡ್
ಎಲ್ಲರದ್ದು ಸೇಮ್
ಬಟ್ ಪೇಜಿನೇಷನ್ ಚೇಂಜ್
ಇಲ್ಲ, ಒಂದೇ ಅಪ್ಲಿಕೇಶನ್.
yes
ಎಲಿಜಿಬಿಲಿಟಿ ಡೇಟ್ ಕೊಟ್ಟ ಮೇಲೆ ರಾಮಸ್ವಾಮಿ says ನೀವು ಎಲಿಜಿಬಿಲಿಟಿ ಡೇಟ್ ಕೊಟ್ಟ ಮೇಲೆ you have to scrupulously adhere to that because it creates an indefeasible expectation.
The reason is, my lord, for giving a eligibility date as on 4/1/2000
secretary has given it.
4/1/2005. The reason is, my lord, that cannot be given effect because on that day they were not born in the service at all. The latest Supreme Court judgment, because the reason is they were given a promotion only with effect from they have given a regular promotion on 10/2/2010 itself. Can you see, my lord? What is most important is they have given a regular promotion.
Page 102.
Please. On 10/2/2010 itself. Now they are claiming that, my lord, they should be given effect from the date of 4/10/2005. The reason is, my lord, on that day, my lord, other 28 persons have been given, my lord, independent charge under Rule 28, and they became also, my lord, eligible to be considered under Rule 32. Therefore, my lord, treat this as a 4/10/2005 as a eligibility date. On that day, my lord, we have not given, these persons have never given me an independent charge. But under the 1978 rules, the retrospective promotion only be given
To the person holding independent charge.
independent charge. They never been an independent
The
charge.
claim was not under Rule 32.
No, yes.
My learned friend is,
No,
what
no,
we
no.
have said
Their
is,
entire case before
those
the
who
court.
were not even entitled, we have placed them under Rule 32. Though we were eligible as on 4/10/2005, you have not given a regular promotion was our claim. And it is not that, it is only the regional commissioner who had done this. Regional commissioner recommended it to the government. Government said, the proposal was considered by the government. Government said you fix a date in terms of this recommendation. That government document is, order is also produced, let's by me.
But it cannot be fixed. 4/10/2000 cannot be fixed. On that time, my lord, they are not born in the service at all. They are given regular permission only on 10/2010. How do 10/2010 is the regular permission?
But all right, but they gained entry 9/3/2000, 6/4/2000 and 26/7/2000.
2000, yes, my lord. 2000.
Why you give, see, eligibility date ಯಾವಾಗ ಕೊಡ್ತಾರೆ? ನಿಮ್ಗೆ ಏನೇನೋ ಕಾರಣಕ್ಕೆ ಅವ್ರಿಗೆ ಪೋಸ್ಟ್ ಕೊಡಕ್ ಆಗಿರಲ್ಲ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ, ನೋಡಪ್ಪ ಈ ಡೇಟ್ ಕೊಡ್ತೇವೆ ನಿಮಗೆ, ಅವತ್ತಿನ ದಿವಸ ಪ್ರಮೋಟ್ ಮಾಡ್ತೀವಿ.
Promote, my lord.
You honor your commitment.
But the actual promotion is given only on 10/2/2010. My lord, there are two things, my lord. There are two things. One is, my lord, consideration for promotion is as a right, my lord. They cannot claim as a matter. We can consider. They cannot claim.
ಹಂಗಲ್ಲ, ಅದು ಆ ಅರ್ಥ ಹಂಗಲ್ಲ. ನೀವೇ ಡೇಟ್ ಕೊಟ್ಟು ಎಲಿಜಿಬಿಲಿಟಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿ ಎಲಿಜಿಬಿಲಿಟಿ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡುವಾಗ ಸೆವರಲ್ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ಇರ್ತಾವೆ, ಅದನ್ನೆಲ್ಲ ತಗೊಂಡು ನೋಡಪ್ಪ ಇದು ಚಿಕ್ಕ ಮಕ್ಕಳಿಗೆ
But recently, my lord, what Supreme Court, no. Otherwise, my lord, what happens? Very recent, my lord, how this has to be considered.
ರಾಮಸ್ವಾಮಿ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ? ರಾಮಸ್ವಾಮಿ ಇದೆಯಾ?
In fact, it has not been disturbed. I have verified.
It remains
Yes.
intact.
Discussion on the legal position ಅಂತ ಹೇಳ್ತಾರೆ. Argument advance 17 and 18. Latest.
ಇದು ರಾಮಸ್ವಾಮಿ ಪೇಜ್ ಏನು?
Minutes, sir.
ಪ್ಯಾರಾಗ್ರಾಫ್?
Minutes, sir. Conclusion is para 48 minutes. 48 minutes. 48, para 48. What emerges from our discussion in that the 1976 seniority list, whatever be its legality, had become final and can only be modified in terms of an order that can be made by the Supreme Court or this court in any other case, whether pending or filed hereafter. When once we reach the conclusion that in 1976 list had been reached finality for whatever reason that may be, it necessarily follows from the same that ranking assigned in that list cannot be tinkered with and all further preparations must be on the basis of that list only. We are also of the view that this conclusion follows from the ruling of the judgment in S.K. Ghosh's Union of India and also from Kadley's case. That is Kadley's case. And even in my case, Millard, that seniority, the date of eligibility fixed has not been questioned by anybody.
But that was a provisional seniority list.
No, final. So far as 2012 is concerned, that order fixing a date of eligibility is final.
ಎಲ್ಲಿದೆ?
That order itself, 88/2010 is a final order.
Only court alone can alter these dates ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿತ್ತು. ಅದನ್ನು ಫಾಲೋ ಮಾಡಿ ಬದಾಮಿ ಕಡ್ಲಿ they proceed on the same premise only. ಅದು ಎಲ್ಲಿದೆ ಇದು ಫೈನಲ್ ಇದ್ರದ್ದು?
Annexure A8 itself, let's is final. Annexure A5, page 65. That is a final order pursuant to the government approval.
65 is final order?
Yes, ma'am. Because at that point of time, the authority itself was
65 ending with 68.
Yeah, ending with 68.
ಆ 3 names ಅನ್ನೋದು?
ಹೌದು.
Brother,
please.
Follow ಮಾಡಬೇಕು. I have followed that Ramsamy number of matters.
It's true, my lord. But my lord, here is in this case.
How can you alter that date? Supreme Court said, no other official, no government official shall alter the date. Only High Court and the Supreme Court.
My lord, in
alone they will do it.
Lord, what happens, my lord? Fixing the date of eligibility.
Judgment argue ಮಾಡಿದ್ರು ನೋಡಿ ಎಲ್ಲ HV ದಾತಾರು ಎಲ್ ನಾರಾಯಣ ರಾವ್ ಅವರೆಲ್ಲ ಪಾಟೀಲಿ ಕೇರ್ ಗೊತ್ತಾಗ್ತದೆ. All stalwarts. All stalwarts. ಸರ್ವಿಸ್ ಲಾದಲ್ಲಿ ಎಲ್ ನಾರಾಯಣ ರಾವ್ ಅಂಕು ಸಚ್ಚೆ ಎಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಬರ್ದಾರ ಜಡ್ಜ್ಮೆಂಟ್. ಅದಂಗ ಮಾಡಲ್ಲ. ಈವನ್ ದಿ ಜಡ್ಜಸ್ ಹೂ ರೋಟ್ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆರ್ ಆಲ್ಸೋ stalwarts in the field of, at least one of them is in the field of service jurisprudence. Swami.
But recent judgment, Lord, my case is what I contend.
ನಾವು ಅದೆಲ್ಲ ಬೇಕಿಲ್ಲ. ನೀವ್ ಹೆಂಗ ಆ ಡೇಟ್ ಅನ್ನು ಆಲ್ಟರ್ ಮಾಡ್ತೀರಿ ಅಂತ ಇಷ್ಟೇ ಹೇಳಿ. ನಮ್ಗೆ ಅಲ್ಲಿ ಸರ್ವಿಸ್ ನಾಗ ಏನೆಲ್ಲ ಆಗ್ತದೆ ಗದ್ಲ, we are not bothered. There is a can of worms. We don't want to put our fingers into that. How you could alter the eligibility date?
ಅದಕ್ಕೆ ಅಲ್ಲ objection
all these employees.
Thereafter, my lord, they have considered and made and my lord revised ಇದರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. The reason ಕೊಟ್ಟಿದ್ದಾರೆ ಯಾಕೆ why my lord
ಮಾಡಕ ಬರಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳೋದು. Once that is fixed, you cannot touch it ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳೋದು.
ಇಲ್ಲ ಅಂತ the person who are not born in the service.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಂಗೆ ಹೇಳಿದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟಿಗೆ ಗೊತ್ತಾಗಲ್ಲ ಅಂತೀರಿ ಅದಲ್ಲ ನೀವು ಹೇಳೋ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಅಲ್ಲ ನಾನು ಲೇಟೆಸ್ಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೊಟ್ಟೆ 24th ನಾನು
ಚೇಂಜ್ ಮಾಡಬಹುದು ಅಂತಿದ್ಯಾ?
ಹೇಳ್ತೇನೆ
ತೋರಿಸಿ.
I request you also discussion on the legal position. It is no longer res integra that the promotion is effective from the date it is granted and not from the date when the vacancy occurs on the subject post or when the post itself is created. No doubt a right to be considered a promotion has been treated by the courts not just as a statutory right but as a fundamental right. At the same time, there is no fundamental right to promotion itself. In this
first year law student at least one or 2 years service law practice ಮಾಡಿದ್ರೆ ಏನು ಹೊಸದು ಏನು ಹೇಳಿದ್ರು?
ಅಲ್ಲ, then in this matter my lord, the claim which they are claiming that, my lord, to treat as a 410 on that day.
ಎಲಿಜಿಬಿಲಿಟಿ ಡೇಟ್
ಇಲ್ಲ, ಅದಕ್ಕೆ
ನೀವು ಎಲಿಜಿಬಿಲಿಟಿ ಡೇಟ್ ಕೊಡುವಾಗ ಇದನ್ನೆಲ್ಲ ಕಣ್ಮುಂದೆ ಇಟ್ಕೊಂಡೆ ಕೊಟ್ಟಿರ್ತೀರಿ ನೀವು.
ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಅಂತ ಒಂದು
ಅದು ಎಲ್ಲಿ ಹೇಳಿರಿ ಅಂತ ತೋರಿಸಿ.
that was their challenge, my lord, before the honorable.
ನೀವು ಆಮೇಲೆ ಚೇಂಜ್ ಮಾಡಿದ್ದನ್ನು ಮಿಸ್ಟೇಕ್ ಅಂತಾರ ಅವರು. ಇದ್ದಿದ್ದ ಡೇಟ್ ಇದ್ ಪ್ರಕಾರ ಇಟ್ಕೋಬೇಕಿತ್ತು, ಅದನ್ನ ಆಲ್ಟರ್ ಮಾಡಕ್ ಬರಂಗಿರ್ಲಿಲ್ಲ ಅನ್ನೋದು.
ಒಂದ್ ವೇಳೆ ಹಾಗಾದ್ರೆ ಏನಾಗುತ್ತೆ my lord?
ನೀವ್ ಎಲ್ಲಿ ಹೇಳಿರಿ, ವೇರ್ ಯು ಹ್ಯಾವ್ ಸ್ಟೇಟೆಡ್ ಈ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿದ್ದು ತಪ್ಪಾಗಿ ಕೊಟ್ಟಿದೆ, ಇದನ್ನ ರಿಪೇರಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅನಾಹುತ ಆಗ್ತದೆ, ಸರ್ಕಾರ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ತೋರ್ಸ್ರಪ್ಪ ಸಾಕು. ನಾವು ಅಬ್ಜೆಕ್ಷನ್ಯಾಗೂ ಬೇಡ, ಇರೋಂತ ಮಟೀರಿಯಲ್ ಅಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ಒಂದ್ ಲೈನ್ ಆ ಅರ್ಥ ಬರುವಂತ ಒಂದು ಮಾತು ತೋರ್ಸಿರ ಆಯ್ತಪ್ಪ, ಒಂದು ವಾಕ್ಯ ತೋರ್ಸಿರ ಆಯ್ತಪ್ಪ.
A9 ಅಲ್ಲಿ ಹೇಳಿದ್ರು,
A9
ಅವ್ರದ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ. I find a detailed objection also, not before the KT. Now, Arikeri and 16 ಅಲ್ಲಿ some pagination.
Page ಹೇಳಿ.
105 not. ನನ್ನ annexure A9 ಅಂತಿದೆ seniority list ಅಲ್ಲಿ.
ಬೇರೆ ಯಾರ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತಾರನೋ ಇದನ್ನ ಈಗ ಅವ್ರಿಗೆ ಎಲಿಜಿಬಿಲಿಟಿ ಅವ್ರು ಯಾರ ಪಾರ್ಟಿ ಇದ್ದಾರ ಇಲ್ಲಿ?
What happens, my lord? Other person, there may be, my lord, the effect of, my lord, they may be promoting, my lord, treating them as a eligibility date from 2005.
ಯಾರು ಏನ್ ಕಳ್ಕೊತಾರೆ? ಎಲ್ಲ ನೋಷನಲ್ ಇದೆ.
Senior, that I don't, that I had to, my lord.
No, it was not their case before the gate that others will be disturbed by this date. No, it is not the case before the gate.
Okay. It was considered and objection was, my lord, ಇದನ್ನ sir. So
ಅಲ್ಲ ಅವರು ಇಲ್ಲ ಅದರಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಅಂತ ಬರೆಯಂಗಿಲ್ಲ. ಇಲ್ಲಿ ರಿಪ್ಲೈ ನಾನು your explanation.
ಒಳ್ಳೆಯದು. It is notional. ಆ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ಆ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ.
Actually from ministerial act officials.
Once that date is fixed, ಅವ್ರೇನ್ ಮಾಡ್ಲಿಕ್ಕಂದ್ರು ಅರೆಸ್ಟ್ ಪೀರಿಯಡ್ ನಲ್ಲಿ ಒಂದ್ಸರಿ ಡೇಟ್ ಕೊಟ್ಮೇಲೆ ಅಲ್ಟರ್ ಮಾಡೋದು, ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಬೇಕು, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಬೇಕು ಅಂತ ಬರೋದು ಕರೆಕ್ಟ್ ಇದೆ ಅದು. ಅದರ್ವೈಸ್ ಅದು ನಾವು ಏನ್ ಬೇಕಾದ್ರೂ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ, ತೆಗೆದು ಹಾಕಿರ್ತಾರೆ, ಹಂಗೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅವರ ದಿ ಎಂಪ್ಲಾಯೀಸ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ದಿ ಥರ್ಡ್ ಆರ್ಗನ್, ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಗ್ತಾರ ಅವರು, ಅವ್ರಿಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಇದೆ.
ಅಲ್ಲ ಅವರು ಮಿಸ್ಟೇಕ್ ಅಂತ ಬರೆಯಲ್ಲ ಅದರಲ್ಲಿನು, ನಿಮ್ಗೆ ಕೊಟ್ಟಿರೋ ಸರಿಯಾಗಿದೆ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. ನೌ ಡೇಟ್ ವಿಚ್ ಇಸ್ ಫಿಕ್ಸ್ಡ್ ಇಸ್ ಕರೆಕ್ಟ್ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. ಪೇಜ್ ನಂಬರ್ 114.
The date of
my objections which were considered by them to the provisional list, page 114.
114.
Which my learned friend says that consideration is there to my objections.
ಮಾರ್ಕ್ ಮಾಡಿದ್ದ ಅದು ಟಿಕ್ ಮಾರ್ಕ್ ಇದೆ.
Yes, Lord. This is their explanation to my objections. ಶ್ರೀ ಸೋಯನ್ಸೋ ಇವರು ಪ್ರಥಮ ದರ್ಜೆ ಸಹಾಯಕ ಅಂತ 25/7/2000 ಹಾಜರಾಗಿದ್ದು ಇರುತ್ತದೆ. ಆಕ್ಷೇಪಣೆದಾರರು ತಮ್ಮ ಆಕ್ಷೇಪಣೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಆಕ್ಷೇಪಣೆದಾರರಿಗೆ ವಿಜಯಪುರ ಜಿಲ್ಲೆಯಲ್ಲಿ 12 ಜನ ಸಿಬ್ಬಂದಿಯವರಿಗೆ ಪದೋನ್ನತಿ ಕೋಟಾದನ್ವಯ ಶಿರಸ್ತಾರ ಹುದ್ದೆಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿ ವಿಜಯಪುರ ಇವರು 4/1/2005 ನಿಯಮದಡಿ ನಿಯಮ 32ರಡಿ ಶಿರಸ್ತದಾರ ಉಪತಹಶೀಲ್ದಾರ್ ಹುದ್ದೆಗೆ ಸ್ವತಂತ್ರ ಪ್ರಭಾರದಲ್ಲಿಸಿದ್ದು ಇರುತ್ತದೆ. ಆ ಸಮಯದಲ್ಲಿ ಆಕ್ಷೇಪಣೆದಾರರು ಪ್ರಥಮ ದರ್ಜೆ ಸಹಾಯಕ ವೃಂದದಲ್ಲಿ 5 ವರ್ಷ ಅರ್ಹತಾದಾಯಕ ಸೇವೆಯನ್ನು ಆಗದೇ ಇದ್ದ ಕಾರಣಕ್ಕೆ ಅವರು ಪದೋನ್ನತಿಗೆ ಅರ್ಹ ಇರುವುದಿಲ್ಲ. ತದನಂತರ ಜಿಲ್ಲಾಧಿಕಾರಿ ವಿಜಯಪುರ ಇವರು ಈಗಾಗಲೇ ನೀಡಿದ ನಿಯಮ 32ರಡಿ 28 ಜನ ಶಿರಸ್ತದಾರ ಉಪತಹಶೀಲ್ದಾರ ಸಿಬ್ಬಂದಿಯವರಿಗೆ ಸರ್ಕಾರ ಆದೇಶ 4/10/2005 ಸ್ಥಾನಪನ್ನ ಬಡ್ತಿ ನೀಡಿದ್ದು ಇರುತ್ತದೆ. ಈ ಹಿಂದೆ ಈ ಕಚೇರಿಯಿಂದ 7/10/2008 ಶಿರಸ್ತದ
Please look into. There is one more rules, my lord, which is yes. The grant of retrospective permission which they are claiming, it only permissible under 3 circumstances, my lord, under the rules, the Karnataka State Civil Service Regulation of Promotion and Pay Pension Rules 1978.
ಅದು ಕನ್ಸಿಡರ್ ಆಗಿದೆ ಅದರಲ್ಲಿ
ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಯಾವಾಗ ನೀವು ರಿಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಪ್ರಮೋಷನ್ ಕೊಡಬಹುದು ಇವರಿಗೆ ಅಂತ. Now the what the retrospective promotion, my lord, if the rule specifically provides that judgment also speaks same thing, my lord, It can only.
This judgment also considers the suspect, na?
That judgment would not consider the point that once an officiating promotion is given for a quite a reasonable point of time.
Can it be
Can it
ignored?
be
No,
disturbed?
fine, ಅದು consider ಆಗಿಲ್ಲ ಅವರು.
In fact, the case Mutugal of Supreme Court judgment says it can't be disturbed even if there is a challenge to it.
Correct.
After quite a long time.
Even if it is wrong,
Yes.
that cannot be disturbed ಅಂತ hold ಮಾಡ್ಯಾರ ಅವರು.
From 2012 till 2020. nothing
ಇಂಥದ್ರ
happened.
ಮೇಲೆ ಇನ್ನೊಂದು ಒಂದು ಪುಟ್ಟ ಬುದ್ಧಿ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಅಂತ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತು. ಪುಟ್ಟ ಬುದ್ಧಿ ಇವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು, ಮುರಳೀಧರ್ ರಾವ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು.
ಅವರ ಹೈಕೋರ್ಟ್ಸ್, ಅವರ ಹೈಕೋರ್ಟ್.
ಅಮ್ಮ ಕೊಡುತ್ತೆ. ಪುಟ್ಟ ಬುದ್ಧಿ ವರ್ಸಸ್ ನೋಡಮ್ಮ ಯಾವ್ದಾರ ಅಂತ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೇನೋ, ಪುಟ್ಟ ಬುದ್ಧಿ ವರ್ಸಸ್ ಬೈ ಇಟ್ಸ್ ವೆರಿ ನೇಮ್ ಐ ಯೂಸ್ ಟು ರಿಮೆಂಬರ್ ಜಡ್ಜ್ಮೆಂಟ್. Justice Muralidhar Rao, when he was at the bar, he used to argue. One particular Ramaje's services under the state nalli the treatment.
Please.
Treatment, but that is not treated in Samaraditya Pal. Only Ramaje's has treated by taking unreported judgment on the court ma treatment.
One more judgment, 2008, same point, my lord. The issue, my lord, what was
ಅದರ ಮೇಲೆ ಇಲ್ಲ ಇಲ್ಲ ನಾವು.
No, when
my lord proposition ಹೇಳ್ತಾ ಇದ್ರಿ ಅದರ ಮೇಲೆ ಇಲ್ಲ ಇಲ್ಲ ನಾವು.
When they, my lord, not holding the, my lord, promotion or, my lord, independent charge much before, so they cannot claim, my lord, as a matter of, my lord, right, my lord, refix from the retrospective approach. ಅಲ್ಲ ಅವ್ರದ್ದು 2005 ಇಂದ ಕೇಳ್ತಾ ಇರೋದೇ retrospective promotion.
ಅಂದ್ರೆ ನೀವು ಅದು correct. It is on the ground that you had given, you had assured us with effect from this date. ಆ ಪ್ರಕಾರ ಕೊಡ್ರಿ ಅಂತ ಕೇಳ್ತಾರೆ.
ಅದು ಕೊಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ, ಯಾಕಂತಂದ್ರೆ ಅವರು they are not born in the service before that.
ಡೇಟ್ ಯಾಕೆ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರಪ್ಪ?
That is, my lord,
ಇಂದನೇ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು.
that is, my lord, but they have not challenged the 2010, my lord, granting promotion. They only challenge, my lord, refixation, that's all.
Whatever, we do not know, this is only discussion.
Yes. So, my lord,
Not result.
1978 rules also, my lord. 78.
31.
ನನ್ನ ನೋಟ್ಸ್ ಅದಕ್ಕೆ.
Please.
Ramsamy type. Just examine whether Ramsamy is tinkered by any court.
I have verified. It has
ನೋಡಿದ್ರಾ?
not been referred to in any.
ಯಾವ್ದಾರ ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ರೀಟ್ರೇಟ್ ಮಾಡಿದಾರ ರಾಮಸ್ವಾಮಿ ಏನಾದ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿ?
It has not been referred. I will also verify.
Okay.
31. Anusha L.
ತಮ್ದೊಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ, ಐ ಥಿಂಕ್, ಫಾಲೋಯಿಂಗ್ ದ ರಾಮಸ್ವಾಮಿ ಜಜ್ಮೆಂಟ್.
ನಾನು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ದೆ, ಅದಕ್ಕೆ ಕೇಳಿದೆ ನಾನು. ಅದು
Down.
ರಿಪೋರ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ನಾನು.
I'll give that, my lord's order. I just.
ಬಟ್ ಅದನ್ನ ಕೆ ಸುಬ್ರಾವ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು ಆ ಜಡ್ಜ್ಮೆಂಟ್.
ನಾನು ಓದಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಓದಿ
I remember one judgment.
This is not with respect to, my lord, they fall under that. Here is, my lord.
ಇಲ್ಲ, ರಾಮಸ್ವಾಮಿ ಫಾಲೋ ಮಾಡಿದೆ ನಾನು. Because all stalwart judges and stalwart lawyers have argued, stalwart judges have written that judgment.
But this case, my lord, is entirely, my lord, the reason is, my lord, they are not at all eligible. So grant of doesn't arise, my lord.
They were not yet born anta.
Born and
Not.
2005
Let us see, we do not know.
Because before that time, neither they have given independent charge in the 32 or, my lord, placed, my lord, rule 32, my lord. The only regular promotion has happened in the 2010 itself.
One more point which requires 8 long years when it has been given effect to and consequential promotions are given. Can they, let's unilaterally change it?
ಏನ್ ಗ್ರೌಂಡ್ ಹೇಳಿದ್ರು ಚೇಂಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವರು?
Our BK Pavitra judgment ಬಂದ್ಮೇಲೆ they prepared a seniority list for redoing the entire thing. At that point of time, they fixed this date.
We should have done it, my lord, when we have BK Pavitra case.
Yes, we are not claiming any benefit under BK Pavitra.
ರಿಸರ್ವೇಶನ್ ಕೇಳ್ತಾ ಇಲ್ಲ, ಎಂತದ್ದು ಕೇಳ್ತಿಲ್ಲ.
It's true, my lord, but when we noticed that, my lord, granting a promotion, my lord, because they are not at all eligible, so question of, my lord, granting promotion doesn't arise.
No.
31. Anusha L. Appear for the petitioners. Senior counsel V. Lakshminarayana sir is online. May be permitted to.
Contempt. Notice, huh?
Yes, sir. Notice, sir.
Lakshminarayana, it is case for notice.
Mute ಮಾಡಿ, unmute ಮಾಡಿ.
Over emergent notice.
32. Hanuman Reddy Saukar.
Appear for the.
ಏನ್ ರೆಡಿ ಗಾರ್ ಇದು?
The appellant has filed the writ petition before this honorable court. The where in the FDP proceedings, the respondent 1 and other respondents have settled the matter. Compromise petition was filed, where we have not been made as a.
FDP 1 of 2011.
Yes,
ಸೆಟ್ಲ್ ಆಗಿತ್ತಾ?
Settle, leaving my client, my lord, they have settled it. And I challenged that order before this honorable court. This honorable court has set aside that order and remanded the matter to the FDP, my lords. After the remand, as per the, my lord, the compromise, respondent number 1 got entered her name. After the remand, my lord, during the pendency of the writ petition, she sold the property to, my lord, the now respondent number 5. I filed an application for impleading. The matter was remanded since all the parties have not signed the compromise petition. After the remand, my lord, they have, my lord, withdrawn the compromise.
Set aside, sale was executed. FDP set aside.
The order of, my lord, the compromise set aside. Kindly see, my lord, annexure C, page.
That sale is made. Huh?
No, during the pendency of, my lord, the writ petition. The writ petition was, my lord, January 23. The sale was, my lord, sale deed was executed.
Whose name are entered?
In the respondent number 1 name is there.
There's name.
So subject to result of the FDP ಆಗ್ತದೆ.
That's how it is there, my lord, then we do. Now purchaser has made an application before the Tahsildar to enter his name. Tahsildar has rejected, saying the matter is pending in the FDP court.
Correct. FDP ಆದ್ಮೇಲೆ.
Yes, yes.
FDP is a continuation of the original suit process.
Yes, that's right, my lord.
ಅಲ್ಲಿ ಏನು FDP ಎಲ್ಲ ಆಗ್ತದೆ depending upon the treaties ಮಾಡ್ತಾರೆ.
Now, my lord, the respondent number 1 taking undue advantage of entering her name.
ಬೇರೆ ಕೆಲಸ ಮಾಡ್ತೀವಿ. ಇಲ್ಲಿ ಬರಲ್ಲ.
Now I am challenging the order passed by the Learned Single Judge, where
ಅಷ್ಟೇ ಹಂಗ ಮಾಡಿರ್ತಾರೆ. That's called pencil entry under Bombay Land Revenue Code ಇತ್ತಲ್ಲ. They used to call it as pencil entry. Pencil entry ಅನ್ನೋ ರೀತಿ ಮಾಡಲ್ಲ. ರೌಂಡ್ ಅಪ್ ಮಾಡ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಬೇಕು ಅವರು ಸಬ್ಜೆಕ್ಟ್ ಟು ಔಟ್ಕಮ್ ಆಫ್ FDP ಅಂತ ಒಂದು ರೌಂಡ್ ಮಾಡಿ ಮುಗಿಸ್ತಾರೆ.
Otherwise, this case faced already problem. If before this order is set aside, it's a sold. ಅಲ್ವಾ?
ಅಲ್ಲ ಇದು the order is passed, my lord, on
list pendant supply expense. ಏನೇ ಮಾಡಿದ್ರು list pendant supply.
Please, sale deed is executed on, I produced the along with the additional document, my lord.
ನಾವು ಡೇಟ್ ಕೇಳ್ತಾ ಇದೇವಪ್ಪ, ಡೇಟ್ ಕೊಡಬೇಕು.
18/12/2023, 12/23, my lords.
ಅಷ್ಟೇ.
Then why you have not brought the purchaser on record? For single judge? Not necessary.
That is the by
subject to list pendants.
Is there? Now he is expressing that difficulty.
ಏನ್ difficulty? List pendants ಆಗ್ತದೆ. FDP is continuation of suit for all practical
No,
purposes.
I am not, if it is in the name of the respondent number 1, who is the, my lord, the party in the FDP court, we have no objection. Now she has sold this property to some third person.
That will be subject to this FDP ಅಂತ ಹೇಳಿದ್ದಾರೆ ಜಡ್ಜ್. ಏನ್ ತಪ್ಪಿದೆ?
ಅಲ್ಲ ಅವರು ಹೇಳಿರೋದು entry in the name of the respondent number 1. As per the compromise decree.
Justice Mukherjee of Calcutta High Court. So ಬಿಟ್ ಕೊಡ್ರಿ ಮುಲ್ಲಾ ಕೊಡ್ರಿ 52 ಮೇಲೆ ಎಷ್ಟು ಚಂದ ಹೇಳ್ಯಾರ ನೋಡಿ. Justice ಅಂತ ಮುಖರ್ಜಿ, PB ಮುಖರ್ಜಿ.
Now he is disturbing our possession, purchaser.
ಅದಕ್ಕೆ ನೀವು ಬೇರೆ ಕಡೆ ವ್ಯವಸ್ಥೆ ಮಾಡ್ಕೋಬೇಕು. ಇದರಿಂದ ಮಾಡ್ಕೊಳ್ಳಿಕ್ ಬರಲ್ಲ.
But now, my lord, I am seeking only.
ಮಿಸ್ಟರ್ ರೆಡ್ಡಿ ಗಾರು ಕೊಡ್ರಿ 52 ಕೆಳಗಡೆ ಲಿಸ್ಟ್ ಪೆಂಡೆನ್ಸ್ ಮೇಲೆ ಎಷ್ಟು ಚಂದ ಹೇಳಿದಾರೆ ಒಂದು ಕಲ್ಕಟಾ ವೆರಿ ಓಲ್ಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಕಲ್ಕಟಾ ಹೈಕೋರ್ಟ್. ಅದೇ ಉತ್ತರ. ಅಲ್ಲೇ ಬೆಳ್ಳುಳ್ಳಿ ಕೊಡು.
And shrewdly, my lord, after the remand, they have withdrawn the, my lord, compromise petition. Because they sold the property, now they are washed their hand, now putting me in trouble.
ಅವ್ರು ಎಂತ ಮಾಡಿದ್ರು ತೊಳಿ ಒಂದು ಜಸ್ಟಿಸ್ ಮುಖರ್ಜಿದ್ ಒಂದು ಸಣ್ಣ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಇದೆ, ಎಷ್ಟು ಚಂದ ಆಪರೇಟ್ ಆಗ್ತದೆ ಅಂತ ಬರ್ದ ಕೊಟ್ರಿ ಹೋದ್ರಿ. ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿ, ಮುಲ್ಲಾ ಹ್ಯಾಸ್ ಕೋಟೆಡ್ ಇಟ್. ಐ ರಿಮೆಂಬರ್ ಮೈ ಪ್ರೊಫೆಸರ್ ರಾಜಶೇಖರ್ ಇಸ್ ಟು ಟೆಲ್ ವೆರಿ ಆಫನ್, ವೆರಿ ಫಾಂಡ್ ಆಫ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್. 52 ದಲ್ಲಿ ಜಸ್ಟಿಸ್ ಮುಖರ್ಜಿ ಅನ್ಕೊಂಡು ಒಬ್ಬ ಜಡ್ಜ್ ಒಂದು ಕೋರ್ಟ್ ಆಗಿತ್ತು. ನಾವು ಸ್ಟೂಡೆಂಟ್ ಇದ್ದಾಗ ಈಗೂ ಇರತ್ತ, ವೆರಿ ಫೇಮಸ್ ಜಡ್ಜ್ಮೆಂಟ್.
In the Calcutta case,
correct.
In the Calcutta case, Justice Mukherjee, speaking of the application of the doctrine of suits of specific performance contracts to transfer immovable property, said that when the jurisdiction of the court had once attached, it could be ousted by the transfer of defendant's interest. There would be no end to litigation.
Because use ಆದ್ಮೇಲೆ ಇನ್ನೊಬ್ಬರಿ ಮಾಡ್ತಾರೆ, ಮತ್ತೆ ಬನ್ನಿ ಬಿಟ್ಕೊಂಡು ಮತ್ತೊಬ್ಬರಿ ಹಿಂಗಾಕೋತ ಹೋಗ್ತದೆ ಅಂತದೇ ಕಂಡೀಷನ್ ನಲ್ಲಿ ಹೇಳಿದ್ದು. ಅದಕ್ಕೆ ನಿಮ್ದು ಏನೇ ಇದ್ರು ಸಹಿತ still this is pending. FDP is pending.
In the FDP, my lord, the application for impleading. Yes,
ಉತ್ತರ ಕೊಡಿ.
Yes, yes.
ಯಾಕೆ ಉತ್ತರ ಸರಿಯಾಗಿ ಕೊಡಲ್ಲ? ಅರ್ಥ ಆಗಲ್ಲ ಏನು ಪ್ರಶ್ನೆಗಳು? ಮತ್ತೆ
That
ಉತ್ತರ
is-
ಕೊಡಿ, ಆಮೇಲೆ explain ಮಾಡಿ.
Yes, that is stated by this honorable court in the writ petition. One of the impleading application was filed and against that matter, writ petition was filed before this honorable court.
ಅದಿನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ.
Yes, Mr. Pending.
ಮತ್ತೆ ಕರೆಕ್ಟ್ ಇದೆ ಅವ್ರಿಗೆ ಹಂಗ್ ಮಾಡಿದ್ರೆ. ನಿಮ್ಗೆ ಅಲ್ಲಿ ಏನಾರ ಸಮಸ್ಯೆ ಇತ್ತು ಅಂದ್ರೆ ಆ FTP ಸ್ಟೇ ಮಾಡಿದೆಯಲ್ಲ ಕೋರ್ಟ್, ಅಲ್ಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ. ಇಫ್ ಯುವರ್ ಪೊಸಿಷನ್ ಈಸ್ ಡಿಸ್ಟರ್ಬ್ಡ್, ನಾವೊಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ತೀವಿ, ದುಪೇಕ್ಷೆ, ಬೇರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಇದು.
Now, my lord, he is going to enter his name. Tahsildar has rejected his application. Vendor, the respond number 5, now I am sought to implead him as a respond number 5. Based on the sale deed, he filed an application and
ಅವನ ಹೆಸರು ಬರ್ತದೆ, ಬರ್ಲಿ, ಅದು FDP ನೀವು ಔಟ್ಕಮ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ.
once entry is there, my lord, he can raise the loan and.
No
he can-
entry is ಅದೇನ್ entry very ambulatory depending.
Compromise itself has gone now.
Yes, my lord, that is the reason.
To the notice of the single judge where it is challenged or before the commission saying that.
Oh, that was brought to the notice of the single judge, my lord. In fact, kindly see in the impugned order, it is referred. It is.
When purchaser seek for entry of his name, you bring to the notice saying that compromise itself has gone. Question of his entry will not come and FDP is pending. Already single judge has observed this.
But that is subsequent writ petition I filed, my lord. That is impugned order now. Annexer C was the challenging the compromise decree which was remanded. After the remand, my lord, the compromise petition was withdrawn. She has not got enter her name. We have filed a disputed case and the Tahsildar has allowed her name to be entered. And AC has also rejected, DC also rejected. Against those orders, my lord, the impugned order that is now under challenge, I have filed the writ petition. Challenging the mutation entry in the name of the respond number 1 based on the compromise decree, her name came to be entered. That is page 8, my lord, in the writ petition now under the impugned. Where, my lord, the learned single judge has, though, my lord, the compromise decree was set aside and remanded, but still, my lord, the learned single judge has quotes that, my lord, entry in the name of a respond number 1 is subject to result of the review.
Correct ಇದೆ, because it is still pending ಅಂತ.
If that is there, my lord, we would not have much grievances because she is also entitled. If it is there in her name, we would have got the in the FDP. Since she has sold the property, my lord, the third person, my lord, is the obstructing our possession.
ಅದು ಪೊಸಿಷನ್ ಇಲ್ಲಿ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
Now, what I am seeking, my lord, only this observation is to be, my lord, this removed. Her entry in the name of the respond number 1. I am of the opinion that in page 15, in the impugned or last 4 lines.
1-5.
Yes, I am of the opinion that the name of the respond number 1 found in the record of right shall be subject to the result of the
Number
FDP.
15.
15 minutes.
Internal page number 8 of the learned single judge order.
ಪೇಜಿನೇಷನ್ ಮಾಡಿಲ್ಲ ನೀವು, ನೀವು ಪೇಜ್ ಮಾಡಲ್ಲ, ಅದು ಅಷ್ಟು ರೆಸ್ಪೆಕ್ಟ್ ಜಡ್ಜ್ಗಳಿಗೆಲ್ಲ.
I'm sorry.
I am of the opinion that the name of respondent number 1 found in the record shall be subject to the result of FDP 1 of 2011.
Pending before the
before the
civil
civil
court,
court.
with the observation writ petition could be disposed of. According writ petition
is
disposed of, holding that the entry in the record of right shall be subject to result of.
FDP number so and so so and so.
If this is not, we are not, but now she has sold the property to.
ಅವಾಗ that will be subject to, ಅದು ಇದಕ್ಕೆ ಸಬ್ಜೆಕ್ಟ್ ಆಗೇ ಬಿಡ್ತದೆ.
Now,
If this sale is prior, then you have to file a review before the same judge and say, assume that you are aggrieved. No, now this is all right, R1's name is all right for us, but purchaser is coming and troubling that, then you would have filed a review before single. Because it's prior to the disposal of the single judge, either R1 would have brought to the notice or you would have said to the court saying that say already sale has happened. That doesn't make any difference ಅಲ್ಲ ಸರ್.
Prior ಇದ್ರು ಸಹಿತ
ಡಿಸ್ಪೆಂಡೆನ್ಸ್ ಬರುತ್ತಲ್ಲ ಸರ್.
ಡಿಸ್ಪೆಂಡೆನ್ಸ್ ಡಿಸ್ಪೆಂಡೆನ್ಸ್ is a very strong doctrine ಅದು. ಅದಲ್ಲ, during the pendency of either pendency ಅನ್ನೋದು, if they see the pendency of 1 of 2011, if that is pending, whatever transaction that takes place will be subject to outcome of FDP ಅಂತ ಹೇಳಿದಾರೆ ಅವರು. ಇನ್ನು ಚಂದ ಹೇಳಕ್ ಬರ್ತಿತ್ತು, that's another thing. There is scope for improvement even in heaven. But it makes sense ಅಂತ ಅಷ್ಟೇ.
But thing is now, if
liberty is reserved to ಅಂತ ಬರೆದು ಹಾಕ್ತೇವೆ, to go before the appropriate court and seek injunctive order ಅಂತ ಹೇಳಂತ. This order shall not come in the way of the parties protecting their possession if they are in.
It is multiplicity of proceeding. Now, in his name, cell deed is there, and if it is in his name is entered, then our rights will be little difficulty.
ನಿಮ್ಮತ್ತಿಗೆ ಸೇಲ್ ಡೀಡ್ ಇದೇನು ಈಗ?
We are the party to the FDP.
FDP ಪಾರ್ಟಿ ಇದ್ದೀರಿ ನೀವು.
Yes, yes, madam.
FDP ಕೋರ್ಟ್ ಮುಂದೆನೆ ಕೇಳ್ಕೊಳ್ಳಿ ಇದನ್ನೆಲ್ಲ ಇದನ್ನ. If that person is claiming under one of the parties to the FDP, then whatever order FDP court makes, he also will be bound by that. ಹಂಗ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಜಸ್ಟಿಸ್ ಸ್ವಾಮಿ ಅವ್ರ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅದರಲ್ಲಿ. Justice Swami, the great judge.
And now he has made application before the revenue authorities to enter his name. Once his name is entered, then it will be again trouble for us.
Intra-court appeal rejected, agreeing with the reasoning of the learned single judge. First, however, the observations made by the learned single judge in the subject writ petition shall not influence pursuit of remedy by any of the parties for protecting their possession in accordance with law. Okay.
33, Shadab Dharwad.
It's appearing for the appellates, my lords.
ಏನಿದು?
Lords, appellates was the petition before the learned single judge. They had challenged ordered annexure A before the learned single judge. The same came to be, yes, my lords.
K ಏನದು?
Page number 49, my lords.
9.
Lords, the appellates is the chairman of Anjuman Islam Dharwad.
Karnataka Waqf Board of the proceedings.
Please, my lords.
ಏನ್ ಹೇಳ್ತಿದೆ ಅದು?
Lords, there is a school, Anglo-Urdu High School at Hangal. That is in the administration of Anjuman Islam Dharwad since many years, my lords. Now, in the year 2008, Anjuman Islam Hangal made a representation to the Karnataka State Board of Waqf to hand over the management of that school to the Anjuman Islam Hangal on the ground that the distance between the Dharwad and Hangal is 100 kilometers. So on that ground, my lords, that representation came to be considered. As per the annexure A, the Karnataka State Board of Waqf has directed the Anjuman Islam Dharwad to hand over the management of Anjuman Islam Hangal, Anglo-Urdu High School to Anjuman Islam Hangal, my lords. Initially, the same came to be challenged before the Karnataka State Board of, Waqf Tribunal, my lords. When the order was challenged, my lords, there was no managing committee of Anjuman Islam Dharwad. There was an administrator. He has not chosen to file any appeal. In fact, he has consented for the handing over the management to the Anjuman Islam Hangal. Therefore, interested persons of Anjuman Islam Dharwad have challenged that. The tribunal has held that the order is cannot be set aside. In the interest of public, that is order is correct. That is came to be confirmed in the writ petition. It is also subsequently came to be confirmed in the writ appeal, my lords. In the writ appeal, my lords, the division which of this honorable was held that since there is no managing committee for the Anjuman Islam Dharwad, after the constitution of a duly constituted committee, it can challenge that order. Their liberty was reserved. On the basis of liberty, my lords, this said order annexure is came to be challenged before the learned single judge. That is came to be dismissed, which is order is impugned under this appeal, my lords.
On what ground?
My lords,
Dismissal is on what ground?
Dismissal is on the ground that, my lords, the learned single judges held that under section 32, my lords, of Waqf Act, the board is having control over the Waqf properties and it can transfer
Its properties
its
or
properties
institution to somebody.
Some number. That was the main observation, my lords. Now, my lords, my submission.
ಅದು ತಪ್ಪಾ ಸರಿನೋ?
That is wrong, my lords.
ಯಾಕೆ ಸೆಕ್ಷನ್ ಓದಿ?
My lords, please.
ಬಡಿ. ವಕಫ್ ಆಕ್ಟ್ ಕೊಡಿ.
Section 32.
32.
30?
32.
32.
32.
32. 32. Please.
Subject to any rules that may be made under this act, the general superintendents of Waqf in a state shall vest in the board established or the state, it shall be the duty of the board so to exercise its powers under this act as to ensure that the ACF under its superintendents are properly maintained, controlled and administered, and the income thereof is duly applied to the objects and for the purposes for which such ACF were created or intended. Power is there.
Please note.
They have power.
Please note. Now my submission is that if a particular work is not properly administrating, under section 65, they can directly assume the power or either by the administrative. In this case, the Karnataka State Board of Work is a selective lords. It has taken only one institute out of number of institution, where there is no separate management for Anglo Urdu high school lords. Anjuman Islam Dharwad is altogether there are number of institution, and it has taken only one institution out of our institution and directed to hand over that to the Anglo school Hangal Milords. Now this is one Milords.
Where is the fault in that?
Milords?
Where is the fault line in exercise of that power?
Milords, Milords,
What was that order you had challenged before the learned single judge?
Annexary, Milords, annexary.
A. To hand over the management to Anglo Urdu school Hangal anta order ಮಾಡ್ಯಾರ.
Please notes.
ಇದರಲ್ಲಿ ಏನು ತಪ್ಪಿದೆ ಅಂತ?
Notes, the property under which the school is standing, that property is gifted to Anjuman Islam Dharwad by one Yellappa in the year 1978. We have constructed that school, and since 1978 till today that is in.
Who are you? We have under who are you?
Notes, we are the Anjuman Islam Dharwad Milords.
You are Anjuman Islam.
Dharwad. So Milords, my submission is that. Milords, the president is Milords, because before the learned single judge also, the parties were read like this. Chairman Anjuman Islam Dharwad.
ಅವ್ರಿಗೇನು ನಿಮ್ಮ ರೈಟ್ಸ್ ಏನಿದೆ ನಿಮಗೆ? How the Anjuman Islam decides the matter? What is the basis? Resolution ಎಲ್ಲಿದೆ?
Please notes.
Resolution. How you represent the body as the president?
Along with Wakalat, I have produced the
Wakalat ಅಲ್ಲ. ಇವನಿಗೆ ಕೇಸ್ ಹಾಕ್ಲಿಕ್ಕೆ ಮ್ಯಾಂಡೇಟ್ ಎಲ್ಲಿದೆ ಅಂತ?
Notes, along with Wakalat, the authorization is also produced. Notes. Authorization I have produced. Notes, along with Wakalat.
Resolution, not Wakalat.
Along with Wakalat, Notes, an authorization to file appeal.
It's the elected body.
Notes.
It's the elected body.
I mean, it is elected body, Notes.
ಏನಾಗಿದೆ ಪಾಟೀಲ್ ಏನಿದೆ?
My lord, what has happened, your lordship, will kindly. What they did, my lord, your lordship, will kindly. They filed, my lord, the Anjuman Islam. Earlier, my lord, there was an undivided district of entire. After the division of, my lord, the district, lord, this Anjuman Islam, my lord, Hangal, as it is situated within the district of Haveri, entire administration was transferred by exercise by the board by exercising the powers noted under section 32 of.
ಡಿವಿಷನ್ ಯಾವಾಗ ಆಯ್ತು?
Please.
ಡಿವಿಷನ್ ಯಾವಾಗ ಆಯ್ತು ಅಂದೆ?
ಡಿವಿಷನ್ ಇದು ಯಾವಾಗ ಇದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಫಾರ್ಮೇಶನ್ಸ್ ಆಯ್ತಲ್ಲ, ಅವಾಗಲೇ ಇಮಿಡಿಯೇಟ್ಲಿ ಅದನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ
ಅದು
ಹಾವೇರಿ ಜಿಲ್ಲೆಗೆ ಬಂತು. ಅದ್ರ ಸಲುವಾಗಿ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಸಲುವಾಗಿ ಇಟ್ ಇಸ್
ಅಪ್ಶೂಟ್ ಆಫ್ ಕ್ರಿಯೇಷನ್ ಆಫ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ನಾಗೆ ಅದನ್ನಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಫಾರ್ ಎ ಬೆಟರ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್. ಇವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಅಂತಂದ್ರೆ ಆಸ್ ಎಫ್ ಹಿ ಹ್ಯಾಸ್ ಗಾಟ್ ಎಂಟೈರ್ ಕಂಟ್ರೋಲ್ ಓವರ್ ದ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿ ವರ್ಕ್ ಟ್ರಿಬ್ಯುನಲ್ ಹೋದ್ರು. ವರ್ಕ್ ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಆಮೇಲೆ ಲರ್ನಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಬಂದ್ರು, ಅದು ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಆಮೇಲೆ ಡಿವಿಷನ್ ಬೆಂಚಿನ ಒಳಗೆ ಬಂದ್ರು, ಡಿವಿಷನ್ ಬೆಂಚಿನ ಒಳಗೂ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಒಂದು ಸ್ಟ್ರೇ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ರು. However, it is open to them to challenge it, Lord, if it is on merits, Lord. Work board dismissed, work tribunal dismissed, learned single judge dismissed, and also, Lord, the division bench also on merits holding that they don't have any right to challenge it. Observation.
Right over.
They because section 32, interpreting section 32, they do not absolutely, they don't have any right over the property of this question is concerned. It was held so. ಆಮೇಲೆ ಒಂದು ಸ್ಟ್ರೇ ಅಬ್ಸರ್ವೇಷನ್ ಮೇಲೆ ಆಲ್ ದಿಸ್ ಲಿಟಿಗೇಷನ್ಸ್ ಇತ್ತು. ಲಾಸ್ಟ್ ಅಕೇಷನ್ ಐ ಬ್ರಾಟ್ ಟು ದ ನೋಟಿಸ್ ಆಫ್ ದಿಸ್ ಬಿಫೋರ್ ದ ಲರ್ನಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್, ಐ ಬ್ರಾಟ್ ಟು ದ ನೋಟಿಸ್ ಆಫ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್.
ಏನು proposition ಏನು?
stating that if matter is not disposed of on merits, a stray observation will not, will not
Come to the right to
to the aid, Lord, for them, Lord, is the question, Lord, which has been decided by the Supreme Court, basing on 2008 Supreme Court.
Lords, earlier there was administration for the,
res judicate ಆಗತ್ತದು.
Lords, he has not challenged that order.
ನಾವೇನ್ ಮಾಡೋಣ? ಅವ ಚೇಂಜ್ ಮಾಡ್ಲಿಲ್ಲ.
In fact, he has consented, Lords. In fact, he has consented for having.
Suppose ನಿಮ್ ಕಮಿಟಿ ಹೋಗ್ತದೆ, ಇನ್ನೊಂದು ಕಮಿಟಿ ಬರ್ತದೆ. ಅವ್ರು ಬಂದ್ಕೊಂಡು ಹೇಳ್ತಾರೆ ನಮ್ ಹಿಂದಿನ ಕಮಿಟಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಿತ್ತು, ಮಾಡಿಲ್ಲ, ನಾವು ಚಾಲೆಂಜ್ ಮಾಡ್ತೀವಿ. ಆ ಕಮಿಟಿ ಹೋಗ್ತದೆ, ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ ಆಗ್ತಾರೆ. ಅವನೆಲ್ಲ ಎರಡೂ ಕಮಿಟಿಗಳು ಕೆಲಸ ಮಾಡಿಲ್ಲ, ನಾನು ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ತೇನೆ. ಹೌ ಇಫ್ ಮ್ಯಾಟರ್ ಈಸ್ ಅಜಡ್ಜ್ಡ್ ಆನ್ ಮೆರಿಟ್ಸ್, a stray observation will not dislodge the res judicata.
Yes, please. Please, Lords.
Stray observation may give you a locus standi, but not a cause of action.
Yes.
It cannot undo the res judicata. Otherwise, there will be no end to the litigation. Yes. ಅದಕ್ಕೆ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಬಾರ್ದಂತದ್ದೆಲ್ಲ. However, liberty is reserved ಇವೆಲ್ಲ ಮಾಡ್ತಾರಲ್ಲ, ಡೇಂಜರಸ್. It keeps the fire burning. If matter is adjudged by the tribunal on merits and matter taken to the learned single judge adjudged on merits, matter taken to the appellate court adjudged by the division bench, that adjudication as such res judicates you. It res judicates you. We cannot reopen it. There is a greater principle in that. On the basis of some observation, you cannot come saying that again we'll reinvent the wheel ಅಂತ ಅನ್ಲಿಕ್ಕೆ ಬರೋದೇ ಇಲ್ಲ. ಏನಿಲ್ಲ.
As your lordship knows, Lord, this has been held by the Supreme Court in the year 2008 SC, page 2187.
Adjudication is conclusive. Yes.
Please, Lords. Lords, only the technical problem is, Lords, page number 85.
85.
Page number 85, Lords.
ಏನದು?
It is a certificate of registration, Lords.
85.
Please, Lords.
How that comes to your?
Lords, the additional properties belonging to Anjuman Islam Dharwad district.
No, they don't deny all this at all.
No,
now what happened is the new district came to be carved out.
Please, Lords.
From Dharwad.
Yes, Lords.
Haveri ಜಿಲ್ಲೆ
Better administration.
Haveri ಜಿಲ್ಲೆಗೆ ಬರ್ತದೆ.
Better administration ಗೆ ಅಲ್ಲಿ ಕಳಿಸ್ಕೊಡಿ.
Administration ಬರ್ತದೆ. ಏನಾಗ್ತದೆ? ಅನೇಕ ಕಾರಣಕ್ಕೆ
ಬಿಟ್ಟರೆ ಬಾಕಿದೇನಿಲ್ಲ.
ACAT ಹೋಗೋದು, ಆಫೀಷಿಯಲ್ಸ್ ಹೊತ್ತಿಗೆ ಹೋಗೋದೆಲ್ಲ ಬರ್ತದೆ. ಅಲ್ಲೇ ಹತ್ತಿರದಲ್ಲಿರೋ ಮಾಡಿಕೊಂಡು ಅದೇ ಕಾರಣಕ್ಕೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಎಕ್ಸಿಜೆನ್ಸಿಯಲ್ಲೇ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ನ ಫಾರ್ಮ್ ಮಾಡಿರ್ತಾರೆ. ಆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ನಲ್ಲಿ ಅನುಕೂಲ ಆಗ್ತದೆ ಅನ್ನೋದಕ್ಕೆ ಮಾಡ್ಯಾರ. ಅಂಡ್ ದಟ್ ಈಸ್ ಅಡ್ಜಡ್ಜ್ಡ್ ಬೈ ದ ಟ್ರೈಬ್ಯುನಲ್. ಟ್ರೈಬ್ಯುನಲ್ ಮಾಡಿದೆ. ಟ್ರೈಬ್ಯುನಲ್ ಇಸ್ ಅನ್ ಎಕ್ಸ್ಪರ್ಟ್ ಬಾಡಿ ಅಲ್ವಾ?
Please, please, Lords.
But ಅವರು ಡಿಸೈಡ್ ಮಾಡಿ ನಾವೇಂಗ್ ಇಂಟರ್ಫಿಯರ್ ಮಾಡಕ್ಕೆ ಬರ್ತದೆ?
Lords, when it's come to the powers in the section 2, ಯಾಕಂದ್ರೆ previous proceedings ಅಲ್ಲಿ all the courts has held regarding section 32 powers, Lords. My submission that the court will be having, the board will be having only supervisory jurisdiction over the power. It cannot take the management from one institute, work from one work institution and hand over to the another work, Lords.
Supervisory ಎಲ್ಲ ಓದಿ.
Lords,
section 32 ಓದಿ.
Please,
not
Lords.
supervisory, ownership.
Subject to any rules that may be made under this act, the general superintendence of all the work in the state shall vest in the board established or the state, and it shall be duty of the board to exercise its power under this act as to ensure that under each superintendence are properly maintained, controlled and administered, and the income thereof is duly applied to the object and for the purpose of which the such work of is created or intended. Provided that in exercising its power under this act in respect of any work, the board shall act in conformity with the direction of the work, purpose of the work, and the usage of the work, usage or custom of the work sanctioned by the School of Muslims law, which the work belongs.
Even ವಕಫ್ ಬಗ್ಗೆ ಏನಾದ್ರು ಸ್ಕೀಮ್ ಡ್ರಾ ಮಾಡಿದ್ರು ಸಹಿತ ಈ ಪವರ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ ಅಂತ ಹೇಳ್ತದೆ ಸೆಕ್ಷನ್. ಬೋರ್ಡ್ ಹ್ಯಾಸ್ ಗಾಟ್ enormous power under the text of rule section 32.
Notes, clause 34, 5, 6 are material notes. Because this state that the work will not be having any control notes. Even if they want to utilize this property, it has to first serve a notice to the Mutwalli to intending development.
ಅದು ಯಾವಾಗ ಆಯ್ತು? ಯಾವ ಡೇಟಿಗೆ ಆಗಿತ್ತು ಆ ರೀತಿ ಆಗಿದ್ದು?
Notes,
which date it all this happened?
In 2008 notes.
ಈಗ ನಾವು ಯಾವ
15th November 2008, my lord, page 50, your lordship may kindly take. Page 50.
50.
Please. 19th November 2008. Annexure A.
ಅಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಇರ್ತಾರೆ ವಕಫ್ ಟ್ರೈಬ್ ನಲ್ಲಿ ಅಲ್ವಾ?
Please notes.
ಮೊದಲಿನ ರೌಂಡ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ಸ್.
My lord, this is the order which was challenged, my lord, your lordship, before the work tribunal. Your lordship should kindly annexure B. Page 67, my lord.
ಸಿಂಗಲ್ ಜಡ್ಜ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು, ರಿಟ್ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು.
ಆಯ್ತು, ಪ್ಲೀಸ್.
ರಿಟ್ ಅಪೀಲ್ ನಲ್ಲಿ
ಒಂದು ಸ್ಟೇ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ರು.
ಯಾವ್ದು ಅಬ್ಸರ್ವೇಷನ್?
Observation is
Just. My lord, the page 83 may kindly be taken, lord. Page 83. Last. On merits, it has been dismissed. However, it is made clear that after the constitution of duly elected managing committee of the Anjumani Islam Dharwad, it is always open to them to challenge the order of transfer of management in accordance with. This is one stray observation. Merit mege order of the tribunal do single judge ಮತ್ತು division bench ಇದೆಲ್ಲ confirm ಆಗಿದೆ. ಇದು ಒಂದು observation ಮೇಲೆ they are troubling us. A single judge order they did not produce.
ನಿಮ್ಮತ್ತಿಗೆ ಇದೇನು?
I don't have, my lord.
But in that also, my lords, the
Division bench, your lordship, should kindly, on merits,
Section
lord.
32. Only one submission, my lords, please. Because 34, 35, 36 of 32, my lords, they state that the workforce will not directly will not be having control over the property. Even if they want to use that property, they have to serve notice to the Mutwalli.
Correct. These are grounds for challenging the order.
Please, my lords.
But that order has been examined by tribunal, by learned single judge, by the division bench. And on merits, they said, although they have given liberty to challenge, it makes no sense.
Because these grounds, my lords, not as before the previous petition proceedings. Because in that 32 clause 6 says that after utilizing the property, the
Sorry, I have
state
got
board,
a single copy of the learned single judge, but it may pass on. Correct, no,
the board shall hand over that property to the work from the my lords. So they will not be having any power to.
ಏನಿಲ್ಲ. This intra-court appeal seeks to call in question a learned single judge's order. Wait here. Please. Order dated so and so, entered in appellant's WP number so and so. First, we decline indulgence in the matter mainly on the ground of res judicata, in as much as the subject list was treated by the tribunal earlier, comma, semicolon. Tribunal's order on being examined by the learned single judge, WP number 12505 of 505 and 506 of 2009 came to be negatived. Wide order dated 11/8/2009, semicolon. Matter did not rest there, and it was carried forward in writ appeal number 6285 and 86 of 2009, and a coordinate bench of this court, wide order dated 3/12/2010, rejected the challenge. Full stop. Next paragraph. There is a force in the submission of learned senior advocate Mr. F.A. Patil, appearing for the contesting respondents, that res judicata is a profound doctrine. It secures peace and tranquility in the society, semicolon. Once the matter has been adjudged on merits, semicolon, one cannot much bank upon a stray observation that reserves liberty to take up the proceedings for invalidating the same, comma, afresh. First, that view gains support from the decision of Apex Court in Dadu Dayalu Mahasabha, Jaipur, versus Mahant Ram Nivas AIR 2008 SC 2187. First, in view of the above, appeal is liable to be and accordingly dismissed. Rejected. The admission stage is rejected. Costs having been made easy. We appreciate learned counsel appearing for the appellant in very effectively assisting the court. Assisting the court. Okay. All.
34, Shivraj Ballalli.
Please tell. Shivraj, please.
One submission, my lords. Serial number 39, my lords.
39.
Please, my lords.
And you know,
With that appeal, my lords. Along with that appeal, few more appeals are pending, my lords.
sorry.
2000,
You are appearing from,
appear for appellants, my lord.
see the 2013 appeal.
Please, my lord. Along with that appeal, these are,
Whatever happens.
please, please.
Please, duplicate ಮಾಡಿದ್ರೆ ಆಯ್ತು.
Of course,
Order
of course. Please.
ಕಳಿಸಿ.
Sriram. Sriram. Judgment ಹಾಕ್ಕೊಡು, ಸೋಮವಾರ.
Password matter, cell number 3, Sam Kalwar.
Full done, man. File, man. Second set file.
You have done that? It fully stated to have been done, registry to verify.
Connected matter.
ಅದೇ ನಮಗೆ ನೋಟಿಸ್
Connected matter, Suraj Bololi matter ದಲ್ಲಿ ಕಾಲ್ವಾಡ ಯಾರಿಗೆ?
Respondent.
Is 3 SM Kalwad is requested to accept notice for respond number 1, emergency notice to R2.
Please.
So and so, ಎಷ್ಟು respond ಇದಾರೆ ಅವ್ರಿಗೆಲ್ಲ ಹಾಕೋಬೇಕಾ? On IA 1 of 23 as well as on main.
Please.
Second set file. Filed, second set.
Second set file, man.
10, Sunita P. Karsu.
Change the issue.
Submitted with respect to the law laid down by the Honorable Apex Court, that appeal, if even though the appeal provision is there, the petitioner need not go to exhaust the appeal remedy. The order, even the writ petition is also can be entertained, and entertaining of the writ petition is correct. That is being upheld by the Supreme Court, your lordships.
Every matter need not go to appeal anta.
Please, your lordships.
Ide ide. World full matters nalli. Chandrakanta ಚೆನ್ನಾಗಿದೆ.
And this is straight on the matter, your
On the
lordships.
act itself.
On the same set of facts.
Notice ಆಗಲಿ. Answer ಮಾಡಿ ನೀವೆಲ್ಲ. Issue notice. Entry ಮಾಡ್ರಿ ಅಂತ ಕೇಳಿದ್ರಿ ನೀವು?
Your lordships, since the matter was covered, I have not sought any interim order.
All right. All right.
The lordships,
There is a third
may I submit, your lordships? The petitioner, he is already on the boundary line, he may lose the appointment if the certificate is not issued. Can I seek a date for their submission, your lordship?
ಅಷ್ಟೇ ಪಾಯಿಂಟ್ ಇದೆ ಅದು.
ಅಷ್ಟೇ
But this has to be considered by special counsel C. Jagdish who appears on the
No,
caste.
no, this is not.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ caste verification
ಇಲ್ಲ.
committee, my lord, he
It-
usually appears.
SC/ST ಅಲ್ಲ ಇದು. This is caste verification committee is a 2A certificate. It is not coming.
Then
under
I will go
SC/ST.
through and
He
make
has to,
submission.
ಅಂತ ಹೇಳ್ತೀರಾ?
in fact, in the
ಹಾಕೋಣ. ಆಯ್ತು.
early, their appeal, your lordships, they have taken notice also in all the matters.
Learned CGP accepts notice for the respondents. Call, since short point, matter lies in a narrow compass. Come on. Call this, call the same next week. Okay.
Yes.
Published.
Sai M. Patil.
This issue is regarding payment of solatium.
Huh?
Regarding payment of solatium.
Payment of?
Solatium.
Solatium.
Under the National Highways Act. Lord, the only short point, my lord, that I canvassed is this, that there is delay in latches in filing the writ petition and claiming solatium. Because this is a case where everything was settled.
What was the delay?
Lord, the delay is like, I've given the dates and events. My lord. The dates are, my lord, I understand there is a judgment of your lordships. Only point I want to canvass, my lord, is this. On 22/5/2004.
For a delayed period, we can deny the interest. That's all. Rest of the things, how can you deny?
Yeah, that's right, my lord. Only point is this. My lord, there were series of judgments by the Supreme Court which arose from Golden Harvest. Lord, the Golden Harvest judgment was pronounced on 23/8/2008. Lord, in Gurpreet Singh was the first judgment considered by the Supreme Court against the appeal from that Golden Harvest. In that they said concluded cases.
I myself had decided on matters.
Yes,
like
yes,
this
my lord.
very
I know,
copy.
we have produced the judgment in the appeal
You have
itself.
produced that?
Yes, yes.
193.
193.
Yes, 93. Okay. ಇದೆ ಅಲ್ಲ?
Yes.
193.
Yes, yes.
Oh, that goes against you.
Yes, yes, it's against us. No, my lord, only point I was trying to canvass is this.
Interest will review. We cannot deviate from the standard. It's a considered standard.
Yes, my lord.
This interest aspect is not considered, no?
No, no. No, only, my lord, whatever is worth, my lord, my submissions may be considered.
Reckoning date for computation of solatium and interest.
Yes.
Huh?
Yes.
197 C.
Yes, yes. That's right, my lord, your lordships. Lord, why I'm raising this issue is this, because if your lordships don't consider my arguments, Lord, we have filed an application for review in the Supreme Court against Tarsim Singh. For it is not review, it's actually clarification. Because the Supreme Court there, my lord, in paragraph 40 and
Can we
41.
wait for that?
No, I'll tell, no, I'm not waiting for that. Because if I concede, it will be taken as I am willing to pay here. And that we had not argued this case
No, we'll
before
say
this.
we have
Yes.
vehemently argued on the case. Huh?
Yes, my lord.
A delayed period, no interest.
Well, because whichever matters are pending before the trial court as on 23/2008, my lord. So it is pending as on that date.
23?
23/2008, as per the Honorable Supreme Court judgment, my lord.
What is that judgment?
It's all started from, no, not Tarsim. It is Gurpreet Singh. Gurpreet Singh is the first judgment. Thereafter, relying on Gurpreet Singh, in Sunita Mehta's case, the Supreme Court said, that is first time the Supreme Court gave a date. Supreme Court said, matters which are pending on 23/8/2008, solatium can be paid, but prior to that, which has been concluded, it need not be granted.
So it
The
was
Supreme-
pending on that day or not?
No, this was not pending, my lord, according to us. On that.
It was pending, my lord. Before the appellate court, it was pending, my lord.
It was pending.
Before the Honorable in LA, in arbitration case number 3 bar.
That's also pending.
EP was pending, Lord. Appeal was not pending. EP is not the continuation.
EPL.
EP was not pending. Appeals were not pending.
This is
EP was
not
pending.
EP, my lord. It is, this is AP number 3/2006.
AP?
3/2006, my lord.
Where is that?
Exhibit D, my lord. Sorry, annexure D, my lord. D, my lord. Relevant page 100, my lord.
It was pending.
Yes, my lord.
Arbitration proceedings were pending.
Pending, my lord.
Before the deputy commissioner.
Yes, my lord. Being agreed by the arbitration case.
When it was disposed of AP?
This was 17/4/2000.
Arbitration case number 3.
17/4/2008, my lord.
17/4?
17/4/2008.
Disposed of?
Yes, my lord.
Thereafter?
So then it covers, no?
No, 17/4/2008.
Disposed of?
Yes, 23/8/2008 is a golden harvest judgment. Therefore, it was not pending.
Even this is not a ground urged before this honorable court.
Right, now it is there, na?
Yes. And further, my lord.
It was pending, huh?
And in this case, my lord, on 12/12/2002, payment was made to the petitioner, my lord. But whereas they have, because they have.
Because of execution, they made.
Not, annexure C is very much clear, wrongly pleaded because, my lord, how they have paid the award amount before passing the award, my lord.
They will see, their right to challenge, your right to challenge accrues only after award is passed.
Yes, yes, my lord.
Is it not?
Yes, my lord.
As on the date the award was passed, that is April 2008.
17/4/2008.
ಅದು ಆಗಸ್ಟ್ ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
Yes, ma'am. March, it is March, my lord.
ಯಾವ ಪೀರಿಯಡ್ ಇಂದ ಇಂಟ್ರೆಸ್ಟ್ ಡಿನೈ ಮಾಡಬೇಕು?
We have to, from which period we have to deny
Lord,
interest?
Lord, interest, we have taken a conscious decision saying that up to 2019 we'll pay interest.
Up to?
2019 we'll pay interest in matters which are pending. But matters which were concluded before 23/8/2008, according to us, no amounts are payable.
No
This is yes, this is a case which was not pending before 23/8/2008, according to us. He says it is pending, it is for him to prove, but execution proceedings were there. It was pending, execution proceeding. But according to us, execution proceeding is not a continuation of the proceeding. Only appeal or 37 is a continuation of the proceeding.
67 was not there.
No, nothing was there. Everything was disposed of. AP was disposed of on in March.
Not EP, my lord. AP appeal, my lord.
April.
April, sorry.
Before the honorable district court, my lord.
So from April to till this date, they are not entitled for.
They are not
interest.
entitled to, yes, that is according
Then
to us.
after arbitral award of the deputy commissioner.
Yes.
Whether matter went to arbitral court or not?
No, AP was disposed of in April. After that, nothing
34,
happened.
no, 34, no.
Yes, 34. After that, nothing happened.
So it was not pending.
So your case is that from 17/4 to 2008 to this date, they are not entitled for interest
No, they're not entitled
on solatium amount.
on solatium amount. Rest they're entitled. Rest they're entitled. Solatium they're not entitled.
Solatium, they are not
No,
entitled.
no, according to interest.
Consolation, they are not.
Interest.
Interest they're not entitled.
Where you have said that your policy decision that you will pay up to
2019, my lord, there is a letter issued to us by the
Some-
NHA.
some-
I'll produce it, my lord.
ಎಲ್ಲರ ಹೇಳಿರಾ somewhere?
at least you have stated
Anywhere you have stated that?
No, my lord, not in this. It was a subsequent development because it's based on a legal opinion. I'll produce that letter, my lord. I'm sorry, I don't have it today.
As on 23/8/2008, as on that date matter pending ಇರಬೇಕು. Only then interest.
Yes,
payable
interest is
on
payable,
solatium.
yes.
If matter is not pending, question of paying interest will not arise.
ಕೊಡಿ, ಇಲ್ಲೇ ಬರ್ಸ್ಬಿಡ್ತಾರೆ.
The honorable division
You
bench of
see,
this
whether
honorable
correct
court,
what I dictate or not. We'll see that.
the,
2 minutes, huh?
Yeah.
This
I have
appeal,
exhibit
this
R2, my lord.
intercourt- one second. This intercourt appeal is filed by the National Labor Authority of India, challenge assailing the order of the single judge dated 16/2/2024, passed in WP number 104809 of 23. To stop. Wherein learned single judge has allowed the writ petition filed by the claimant by directing the authority to pay solatium at the rate of 30% as per the Land Acquisition Act 1894. To stop. Sri so and so, Land Council appearing for the National Highway Authority of India submits that the entitlement of entitlement of solatium to the claimant is not in dispute. However, they are not entitled for interest for the delayed period. To stop, it is submitted that the appellants, it is submitted that as per the decision of the Honorable Supreme Court in the case of
Gurpreet Singh. Gurpreet Singh and Tarsim Singh.
it is there.
No, I will write it in.
Gurpreet Singh, so and so. The claimants are entitled solatium at 30% if the proceedings are pending as on 23/8/2008.
Yes.
Hence, he seeks to allow the appeal by denying the interest on solatium after the disposal of the respondents proceeding under section 34 of the Arbitration and Conciliation Act 1996. Per contra, Sri so and so, the Land Council appearing for the claimant oppose the appeal and submits that the proceedings in execution were pending. Hence, the claimants are entitled interest for the aforesaid period. He seeks to dismiss it. Next paragraph. We have heard the arguments of Land Council for the appellant, Land Council for the respondent, peruse the material available record. It is not in dispute that the respondent claimants are entitled solatium at the rate of 30% as per the provisions of Land Acquisition Act 1894 in view of the law laid down by the Honorable Supreme Court in Gurpreet Singh.
Gurpreet Singh
refers supra and Union of India and another versus Tarsim Singh and others reported in AIR 2019 SC 4689. To stop. The only question is whether the claimants, claimants are entitled interest on the said solatium amount for the entire period. To stop. Keeping in mind the enunciation of law laid down by the Honorable Supreme Court in the case of Gurpreet Singh referred supra. The respondents are not entitled interest from 17/4/2008. That is the date of the disposal of their appeal, application filed under section 34 of the Arbitration Act 1996. Till this day,
That is 26/3/2000.
stop. To the opposite effect, the order of the single judge is modified.
My lord, award of solation of award of interest, solation challenge. Award. ಆ ರೀತಿ ಮಾಡ್ಕೊಂಡು. ಇದು ಅವ್ರು ಹೇಳೋಣ. ಅವು ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಸೈಟ್ ಗಿವ್ ಸೈಟೇಷನ್ ಆಫ್ those two judgments.
Page number 172, may kindly peruse that. 172 page number, my lord.
172.
Yes, my lord. In this judgment.
First paradali about fifth line accordingly. First paradali 172 page number. A judgment reported on Union of India influence. Accordingly, it is directed that the award of solatium and interest on solatium should be made.
Where it is?
Judgment nil 172 page.
Appeal page number.
Gurpreet Singh.
Yes, my lord.
Tasmir Singh.
Gurpreet Singh.
Adರಲ್ಲಿ 172.
172.
About fifth line.
In appeal now.
Gurpreet Singh versus Union of India.
We have considered, hang start ಆಗ್ತದೆ paragraph.
Paragraph, it's para 8 and we have considered the submissions advance.
Correct.
Adರಲ್ಲಿ about fifth line. Accordingly, it is directed that the award of solatium and interest on solatium should be made effectively only to proceedings pending on the date of High Court order in Golden Iron so and so Union of India, that is 28/3/2008.
28/3, brother, it is not 23/8. 28/3, do it.
I'm sorry, my lord.
You have mistaken actually.
Oh, I'm sorry, my lord. It is yes. 20.
If that is so, matter was pending.
Yes, in fact.
ಮತ್ತೆ ಎಲ್ಲ ಹೇಳ್ರಿ.
I'm sorry, my lord.
You should thank your friend.
I'm sorry. I'm sorry.
And further, this honorable division bench has also held your honor in this.
Anyway, Supreme Court has said that.
Yes, yes. That's not
23/8 ಇದೆ.
28/3/2008. I'm sorry.
We have heard the arguments of learned counsel for the parties. Appellate and learned counsel for the respondent peruse the material available record. The contention of the learned counsel for the appellant has no merit consideration. View of para 8.
Yes.
Para 8 of Gurpreet Singh versus Union of India.
Allah.
ಇದು.
Union
ಅದು para 8 of
Para 41.
Tarsim Singh.
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ. Para 8 of Tarsim Singh ಅದು.
Para 40 ದಲ್ಲಿ ಮಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ ಹ್ಯಾವಿಂಗ್ ಕಮ್
ಕನ್ಸಿಡರ್ ಮಾಡಿದೆ. Tarsim Singh ಅದು.
No merit consideration in view of the observation of the Honorable Supreme Court in the case of Union of India versus Tarsim Singh. Which reads para 40 and dot. Then again 8 para dot account accordingly and accordingly and highlight right historic. In the instant case, admittedly, the respondent's application filed under section 34 of the Arbitration and Conciliation Act 1996 was disposed of on 17/4/2008, which is
about 15-20 days prior to that. After ಅಲ್ಲ 28/3 ಇದೆ. 28/3/2008.
ಅವ್ರು 8 ಅಂತ ಹೇಳಿದ್ರು ನಮಗೆ, ಹಂಗಾಗಿ ಇಷ್ಟು ಕನ್ಫ್ಯೂಸ್ ಆಯ್ತು.
ಇಲ್ಲಿ 4 ಇದೆ ಸರ್.
ಹೌದು.
After disposal, pending.
It was pending.
Pending ಇತ್ತು. Disposed of.
Disposed of on. In other words, the proceedings were pending between the parties. Hence, the respondent claimants are entitled interest on solatium amount. So, in view of the same, there is no appeal is accordingly dismissed.
Correct. But perhaps you mistook it is instead of 28/3, you mistook it 23/8.
23. I'm sorry.
Correct.
I'm obliged.
He's a good advocate. Seasoned advocate. Very fair.
Hmm. 34, Shivraj Paloli.
Any Shivraj?
Lords, widowed daughter-in-law is before your lordships. Lords, who's denied lords appointment on the ground of compassionate.
She is denied, my lords, appointment on compassionate ground in the post of her, my lords.
No, in the deceased female.
Deceased is, my lords, her mother-in-law.
Mother-in-law. She is the, my lord,
ಯಾರ್ಯಾರು cover ಆಗ್ತಾರೆ rule ನಲ್ಲಿ?
my lord, rule ಅಲ್ಲಿ deceased female like government's her son, daughter, unmarried, daughter ಅಲ್ಲಿ unmarried, married, divorced, widowed ಎಲ್ಲಾರು ಬರ್ತಾರೆ.
Widowed daughter.
And widower. ಇವರಿಷ್ಟೇ ಬರ್ತಾರೆ. Daughter-in-law ಬರೋದು.
Daughter-in-law ಬರೋದಿಲ್ಲ. But my lords, my prayer is to read down, my lords, of rule 4, rule 2, to also include, my lords, daughter-in-law. So I'm relying on the decision of, my lords, full bench of.
ಹಿಂಗ್ ಮಾಡ್ಯಾರ ಇಂಥದ್ದು?
ಮಾಡಿದ್ದಾರೆ.
ಡಾಕ್ಟರ್ ಇಲ್ಲ ಅಂತನಾ? ಅದು ಪಾಲಿಸಿ ಆಗ್ತದೆ. ಯಾವ ಸ್ಟೇಟ್ ನಾಗ ಏನಾರ ಮಾಡ್ಕೊಂಡು
ಪ್ರಸನ್ನ ಸಾಹೇಬ್ ಮಾಡಿದ್ರು ಮಾಡ್ಲಿಕ್ಕೆ
ಡೈಲ್ಯೂಟ್ ಮಾಡಿದ್ವಿ ನಾವು.
Full bench of, Honorable High Court of Allahabad.
ಸಾಹೇಬ್ರದೇ ಜಡ್ಜ್ಮೆಂಟ್ ತಮ್ಮದೇ ಹೊಂದಿದೆ.
ನಾನು ನಾಳೆ ಅಲ್ಲಿ ಏನ್ ಗೊತ್ತಾ, ಅವ್ರಿಗೆ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಫ್ಯಾಮಿಲಿ ಟ್ರೀಟ್ ಮಾಡಿಲ್ಲ ಪ್ರಸನ್ನ. ಫ್ಯಾಮಿಲಿ ಅಂದ್ರೆ ಮ್ಯಾರೇಜ್ ಆಗಿ ಹೋದ್ಮೇಲೆ ಶಿ ಬಿಕಮ್ಸ್ ಮೆಂಬರ್ ಆಫ್ ದಟ್ ಫ್ಯಾಮಿಲಿ. ಹಂಗಾಗಿ ಡಿಸ್ಟ್ರೆಸ್ ಆಫ್ ದಟ್ ಫ್ಯಾಮಿಲಿ ಬೇಕು. Very objective be defeated. Suppose if she is the daughter-in-law of Karodpati, then also we should give. ಅಂಜಾಗದ್ನ ನಾವು ಬೇರೆ ನಮ್ಮನೆ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದ್ವಿ.
ಇಲ್ಲಿ dear my lords, on the same day, the the mother-in-law and husband both pass away on the same day. So my lords, daughter-in-law, my lords, files an application for appointment on the ground of compassionate.
Who was employed?
Mother-in-law was employed.
Mother-in-law. Mother-in-law's daughter will be entitled, not mother-in-law's daughter-in-law.
Daughter-in-law. Because the rules
that will be doing, we will be recasting, will be manhandling the rule.
But if, as my lords,
same ಅದನ್ನೇ ಬರ್ದಿರೋದು.
Here, if it seen, my lords, the daughter-in-law is more, my lords, she would be more deserving than a married daughter, my lords.
Question is not that. Family is defined. We have to.
4 onwards.
4 onwards.
ತಾವು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಪ್ಯಾಂಡ್ ಮಾಡ್ದಂಗ ಆಗುತ್ತೆ ರೂಲ್ಸ್, which is not there in the original rules.
Rulemaker has so many words have specific
Stated who should decide other ground like
one decision was of full bench of the Allahabad High Court.
ಏನಂತ ಹೇಳ್ಯಾರ? Daughter-in-law.
Yes.
Why 2 words in English dictionary?
Very high court. Some other high courts?
Allahabad High Court, my lords, full bench, my lords.
Okay.
Para 8, my lords, page 3, para 8.
ಅವರ ಅಲ್ಲಿ ರೂಲ್ ಏನಂತ ಇತ್ತು?
Same, my lords, it included only daughter and sons. We must, however, para 8, my lords, page 3.
We must, however,
note
of the definition of the.
One feature of the definition of the word family, as generally contained in most rules. The definition of family includes wife or husband, sons, unmarried and widowed daughters. And if the deceased was an unmarried government servant, the brother, unmarried sister and widowed mother dependent on the deceased government servant. It is therefore clear that a widowed daughter in the house of her parents is entitled for consideration on compassionate appointment. However, a widowed daughter-in-law in the house where she is married is not entitled for compassionate appointment, as she is not included in the definition of family. It is not possible to understand how a widowed daughter in her father's house has a better right to claim appointment on compassionate basis than a widowed daughter-in-law in her father-in-law's house. The very nature of compassionate appointment is the financial need or necessity of the family. The daughter-in-law, on the death of her husband, does not cease to be part of the family. The concept of such daughter-in-law must go back and stay with her parents is aberrant to our civilized society. Such daughter-in-law must, therefore, have also right to be considered for compassionate appointment, as she is part of the family where she is, whether she is married and if staying with her husband's family. In this context, in our opinion, arbitrariness as presently existing can be avoided by including the daughter-in-law in the definition of family. Otherwise, the definition of that extent ex prima facie would be irrational and arbitrary. The state therefore should to consider this aspect and take appropriate steps so that a widowed daughter-in-law, like a widowed daughter, is also entitled for consideration by way of compassionate appointment.
ಯಾವುದು ಈಗ ಯಾವ ಡಾಕ್ಟ್ರಿನ್ ಕೆಳ ಬರ್ತದೆ? Spell out that doctrine. Doctrine of Reading down.
Reading down.
Where is read down? What is read down? It is red, white.
My prayer is, my lords, to.
Reading down is possible.
Adding down.
But
Adding.
adding
This
up.
is adding down.
Adding up.
Adding, doctrine of adding up ಹೊಸದು ಕಂಡುಹಿಡಿಬೇಕು ನಾವು ಅಷ್ಟೇ. This virtually amounts to the lawyer, the judges making the law. Judges can make law right from the days of Edward Coke is true, but not that way. Not that way. It's a pure policy matter.
But ಇನ್ನೊಂದು, there is one Supreme Court, even though it is in the concept, not the.
It's challenge ಆಗಲಿಲ್ಲ.
No, my lords, I have, to whatever extent research I have done, my lords, this was not challenged. I mean,
ನೋಡಿ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಅಲಹಾಬಾದ್ ತೊಳಿ
decision ಅಂತೂ ಸಿಕ್ಕಿಲ್ಲ.
ಇದು ಸರ್ ಈಗ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ one Supreme Court judgment, Lord, even though it says. This is in the context of not the regularization. What Supreme Court says, my Lord, we are happy to that, my Lord, to not para 49, my Lord, 49 only. We are happy that, my Lord, we should give a job to everyone. ಅವ್ರು ಹೇಳ್ತಾರೆ ಬಾರಿ ಚೆನ್ನಾಗಿ ಬರ್ದಿದ್ದಾರೆ ಅದರಲ್ಲಿ. We are happy that we should give job to everyone, but it is not our job ಅಂತ.
This is what. This petition seeks to call in question the service tribunal's order dated.
My Lord, dated 4th January 2024.
4/1/2024, whereby petitioner's application number
10005 of 24.
10005 of 2024 has been negatived. First off, the grievance of the petitioner before the tribunal was the non-consideration of her candidature for compassionate appointment. First, this the tribunal did not agree, and therefore the petitioner is grieving before us. First, learned counsel appearing for the petitioner in his usual vehemence submits that the definition of family given under rule
2B sub
rule 2B
subclause 2
2B2 of ಯಾವ ರೂಲ್ ಕುತ್ಕೊಂಡೆ ಹೇಳಿ
1996 rules
ಫುಲ್ ಹೇಳಿ of so and so rules ಬರ್ಕೊಂಡು ಕೇಳ್ಕೊಳ್ಳಿ ಬರ್ದ್ಬಿಡಿ please rules. In order to be saved from the vice of arbitrariness, needs to be read up to include the daughter-in-law of the family, and if that is done, his client is entitled to succeed in the petition. First, in support of this stand, he presses into service a full bench judgment of Allahabad High Court in so and so. More particularly, paragraph
8, my lords.
8. First, next paragraph. Learned GA appearing for the official respondents passionately resists the petition, contending that the doctrine of separation of powers is recognized as a basic feature of the Constitution in Indira Nehru Gandhi semicolon. The quasi legislations, such as the rules in question being made by the being by the delegate of the legislature, need to be respected by the coordinate organ of the state, namely the judiciary, semicolon. The rule maker, in his wisdom, has not included daughter-in-law in the definition of family consciously, semicolon. That being the position, adding daughter-in-law to the definition would virtually amount to manhandling the law, which is impermissible. First, in support of his contention, idu report enide. He relies upon a coordinate bench decision of this court in Pallavi GM versus managing director and others. KPTCL. Managing director, KPTCL and others. Support note WP writ appeal number 626 of 23. Yes, res disposed of on 7/9/2023. First, having heard the learned counsel for the parties and having perused the appeal petition papers, we decline indulgence in the matter, broadly agreeing with the submission of learned GA. First, the stand of the official respondents is adumbrated by the observations in Pallavi Supra, wherein paragraph 3, paragraph 4 reads as under. No, 4 ಹಾಕೋಬೇಕಾ? Next paragraph. The Allahabad High Court decision in so and so Supra at paragraph 8 reads as under. We are in respectful disagreement with the above decision, in as much as the same does not consider the doctrine of separation of powers at all. Full stop. It hardly needs to be stated that the primary function of judicial institution is adjudication, subject to all just exceptions, into which argued case of the petitioner does not fit. First, his invocation of doctrine of reading down, would not come to the aid of petitioner, in as much as ordinarily a reading down reading down downsizes the legislative instrument, legislative provision, stroke rule provision, and ಅನ್ನೋದು ಏನಾದ್ರು ಇದೆಯಾ?
What is the meaning of reading now?
Reading down ಅಂದ್ರೆ A, B, C, D ಇದೆ, ಒಂದು ಮಾವಿನ ಹಣ್ಣಿನ ಬುಟ್ಟಿ ಇದೆ, ಒಂದು ಡಜನ್ ಮಾವಿನ ಹಣ್ಣು ಇದಾವು, ಅದ್ರಾಗ ಒಂದು ತೆಗಿಬೇಕು, 4 ತೆಗಿಬೇಕು, ತಕ್ಕೋತ್ ಹೋಗುವಂಥದ್ದು, ಇಲ್ಲ ಅದಕ್ಕೆ ಆಡ್ ಮಾಡ್ಕೋಬಹುದು ಅನ್ನುವಂಥದ್ದು ಯಾವ್ದಾರ ಇದೆಯಾ? In the above circumstances, this writ petition is liable to be rejected, and accordingly it is one sentence for Kavu. For the purpose of compassionate appointment, who all can lay a claim is essentially a matter of policy, and the judiciary has to show deference to the same. Okay.
Bless you. The latest.
But one thing we appreciate, every time you bring some new material, you will not so easily leave us. Hello, it's a policy matter. We should respect it. Apex Court in Keswananda, please said, basically we should not tamper with the rule because it's an essential function. Please, law making, rule making, is it not? Yes, ma'am. Why that? We appreciate learned counsel appearing for the petitioner, Shri so and so, and the learned counsel appearing for the Mr. Learned Counsel Shri Girish appearing for the respondents, for the ingenious way they conducted the case at hand. Okay.
Obliged.
Okay.
35, Mallikarjun, payment.
The registry shall share a copy of this order if applied with them, if applied to. Please. Applied for.
Please. For petitioner.
ಈ ಪ್ರಿಪರೇಷನ್ ಮಾಡ್ಕೊಂಡ್ಬರ್ತೀನಿ, ಖುಷಿ ಆಗೋದು. ಶುಡ್ ಬಿ ಮೇಡ್ ಎ ಜಡ್ಜ್ ಆಕ್ಚುಲಿ. ಹೌದು, ಒಳ್ಳೆಯ ಜಡ್ಜ್ ಮಾಡಿದ್ರೆ ಉಪಯೋಗ ಆಗ್ತದೆ. ಎಲ್ಲ ಕಳಪೆ ಮಾಡಿದ್ರೆ ಏನು ಉಪಯೋಗ ಮುಟ್ಟೋದಿಲ್ಲ.
Petitioner, my lord. In this case, my lord, the petitioner is questioning the order of the honorable tribunal, my lord. Rejecting his application, my lord, filed with a prayer to consider his representation, my lord.
ಏನದು representation?
To consider his claim, my lord, for attending the counseling, my lord, that is scheduled to be held on 19/7, my lord. Actually, my lord, he's alla mugudhogide. Really, one thing is that, my lord, everything is over, my lord. Only there was some mistake on the part of the petitioner, my lord, that he could not brought it to the notice of the honorable tribunal that, my lord, he is working in a specified post, my lord, and he is eligible to be considered under 10(6) of the transfer guidelines, my lord. Instead of that, my lord, that
Everything is over. How this part remains here?
alla idralli one only thing, as on the today, my lord, the petitioner has not been relieved, my lord, and is still continuing in the same post, my lord, and no one has been posted to that post, my lord.
Without counseling, we can't conduct counseling here.
Alla counseling alla at appellation nalli iddala, till today is working there only.
Rejection order you are not challenged. 31/5 to 2024 order challenge.
Yes, that is true, my lord. That is not applicable to the petitioner because, my lord, he is working in a specified post, my lord. May I take your lordship to specified post is not a teaching.
Counseling participate 10/7/24 ಇಲ್ಲಿ counseling participate ಅಲ್ಲಿ select ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಅದರಲ್ಲಿ he on that day only he had given a
You cannot say that, my lord, I will not report it.
On that day only, my lord, he has given
7/7/24 you have participated in the counseling.
Yes, on that day only he made a representation before the concerned authority stating that, my lord, since I am working in a specified post, so I may be permitted to attend the counseling scheduled to be on 19/11/19/7, my lord. That was not considered, my lord, and he was forced. I am told that, my lord, he was forced to select the post, my lord. That I positively I can't make such submission, my lord.
ಅಲ್ಲಿ ಇದೇನು ಸ್ಪೌಜಲ್ ಗ್ರೌಂಡ್ ಇತ್ತನೋ?
Yes, my lord.
Spouse ground itta?
Yes, my lord.
ಏನದು?
Andra his wife is also working as a teacher, my lord.
ಎಲ್ಲಿ?
In Hospete Taluk, my lord. In priority counseling, my lord, the husband and wife who are working in the same taluk, they are not entitled to attend the prior counseling, my lord. It was brought to the notice of the concerned authorities that, my lord, since I am working in a specified post, my lord. Specified post is not a teaching post, my lord. It is just like a ministerial post in DDP office, my lord. So he requested them to attend the general counseling to be held on the 19th, my lord. That was not considered. That is his submission, my lord. And on that's why, my lord, he approached the honorable tribunal only with the prayer, my lord. That is also not correct, my lord, as per my, I can't make allegation against my brother also. At least you should have challenged that order, counseling order. ಮಾಡಬೇಕಾಗಿತ್ತು ಸ್ವಾಮಿ, ಅವರು ಮಾಡಲಿಲ್ಲ. ಇದರಲ್ಲಿ ಈಗ at present, my lord, he is working in the same post, in a specified post only, my lord. He has not been relieved.
ಹೆಂಡತಿ ಎಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಾರೆ?
ಹೊಸಪೇಟೆ ತಾಲೂಕಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಹೈಸ್ಕೂಲ್, ಗವರ್ಮೆಂಟ್ ಗರ್ಲ್ಸ್ ಪ್ರೀ ಯೂನಿವರ್ಸಿಟಿ ಕಾಲೇಜ್ ಹೊಸಪೇಟೆ, ಮೇಲೆ ಇವ್ರಿಗೀಗ ಕೂಡ್ಲಿಗಿ ಕಡೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್, ಚಿರ್ಬಿ.
ಇವರೆಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಾರೆ?
At present, he is working in Hospete only, my lord, in the third respondent office, my lord, as a education coordinator.
ಎಷ್ಟು ದೂರ ಆಗ್ತದೆ ಅಲ್ಲಿಗೆ ಮತ್ತೆ ಮನೆಯವರ?
ಈಗ transport post 70 kilometers from the Hospete, my lord.
70 kilometers.
70 kilometers. Now his only request is, my lord, since he has already not been relieved and no one is posted to his post, my lord.
ಅವ್ರು ಯಾರು ಪೋಸ್ಟ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿಗೆ?
ಮಾಡಿಲ್ಲ.
ಒಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ತಾರೆ, ಕನ್ಸಿಡರ್ ಮಾಡಿ, ಕನ್ಸಿಡರೇಷನ್ ಮಾಡೋವರೆಗೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬೇಡಿ. ಏನ್ ಆಫ್ಟರ್ ಆಲ್ ಟೀಚರ್
teacher, what happened? Now he's claimed that he is working in a specified, that doesn't.
ಕರೆಕ್ಟ್, ಅವ್ನು ಹೆಂಡತಿನೂ ಅದಷ್ಟೇ ಎದ್ರಲ್ಲೇ ಇದ್ದಾಳೆ, ಸೇಮ್ ಪ್ಲೇಸ್ ನಲ್ಲೇ ಇದ್ದಾಳೆ.
10 file rule, 10 file, if both the person working in the same taluk, then it is not applicable.
They are not entitled for prior counseling, my lord. That is true, my lord. Actually, he has made a mistake.
ಜನರಲ್ ಕೌನ್ಸಿಲಿಂಗ್ ಗೆ ಬರ್ತದೆ.
General counseling, he can seek for general counseling.
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡ್ತಾರೆ, ಕನ್ಸಿಡರ್ ಮಾಡ್ರಿ. ಏನ್ ಕಳ್ಕೊಳ್ಳೋದು? ಓಕೆ
ಪ್ಲೀಸ್.
ಹೌದು ಹೌದು. Petitioner who has lost his case before the service tribunal in application number 10933 of 2024, negatived on 6/8/2024, is grieving before the writ court that at least on the spousal ground, his case ought to have been considered, maybe by relaxing the normative process in which the counseling for transfer takes place. First, this having not happened, the counsel for the petitioner, submits that there is error apparent on the face of the tribunal's order, warranting interference of this court. First, GA appearing for the official respondents resist the petition, contending that the petitioner has not laid a challenge to the rejection of his request dated 31/5/2024, semicolon. Even otherwise, the normative process for transfer cannot be diluted, keeping in view one single case, since that may lay down a dangerous precedent for others who claim to be in the same boat. First, even otherwise, he adds, the aggrieved employee can make a representation to the government as observed by the apex court in Varadharao versus State of Karnataka, ಅಥವಾ State of Karnataka versus Varadharao, ಏನೋ ನೋಡ್ಕೋಬೇಕು, 85, 86 Supreme Court. And that would be considered objectively within a reasonable time. Next paragraph.
Having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned GA, and therefore we do not much interfere in the matter. First up, the fair stand of the respondents that if the petitioner makes an appropriate representation immediately, the same would be considered in accordance with law, within a time-bound manner, and within a time-bound manner, is really appreciable. ಏನ್ ನಿಮ್ಮನ್ನು ಬಹಳ ಹೊಗಳ್ಬೇಕು ನಾವು ಕೆಲಸ ಮಾಡಿ. In the above circumstances, we dispose of this petition, reserving liberty to the petitioner to make a representation within 1 week.
Please.
Airing his grievance. Semicolon. If that is done, the jurisdictional respondent shall consider the said representation within a reasonable period. First up, all contentions of the parties are kept open. Semicolon. Till consideration of the representation takes place, petitioner shall not be displaced.
If already not displaced.
Unless he is already relieved.
ನೋಡಿ ಒಂದು ಟೈಮ್ ಲಿಮಿಟ್, ಯಾಕಂದ್ರೆ
ಟೈಮ್ ಬೇಡ, ನೀವು ಬೇಗನೆ ಮುಗಿಸಿ.
ಏನಾಗುತ್ತೆ ನೋಡಿ ಅಂತಂದ್ರೆ ಸಿನ್ಸ್ ಸೆಕೆಂಡ್ ಅಬ್ಸರ್ವೇಷನ್ ಅವರು ಅದಕ್ಕೆ ಅವರಲ್ಲಿ ಡೇಟ್ ಹಾಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಕನ್ಸಿಡರೇಷನ್ ಮಾಡ್ಲಿಂಗ್ ನೋಡ್ಕೊಂತಾರೆ, ಅವರಲ್ಲೇ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಪೀರಿಯಡ್ ಆಫ್ 3 months.
4 weeks.
8 weeks.
Please.
Girish accepts notice.
Please.
Valeri, 36, SK Kakma.
Death case, Your Lordship.
What they are challenging?
I'm challenging Contempt, Your
They-
Lordship. We are also challenging Contempt, Your Lordship.
Quantum only.
Yes.
But
And,
ಬೇಕಲ್ಲ ಅವರು.
kindly
Back
tomorrow,
ಸಮನೆ
he
ತಪ್ಸಲ್ಲ ಅವರು.
told me, he informed me that he is held up in Kotal 5, Your Lordship, and he has requested to post the matter tomorrow, Your Lordship.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವಾಗ ಹಾಕೋಣ?
So, any date may.
The request of 11 council for the appellant list answer.
19.
Oblast.
37, RB head.
Please, my lords. Lordships, that I have challenged the liability on fixed, my lords, and connected
Mane
materials
was
for
asking
NS.
same, no?
Please, my lords.
Mr. Mane was asking.
Yes.
On him come, no?
The 2 points is involved, my lordships.
Mane generally is very prompt.
Please.
There is a request of learn council for the respond number 8 list next week. You are owner of the vehicle, huh?
Yes, owner come driver, my lordships. Only 2 points is involved, my lords. One is at the time of driving, my lords, owner is not in position of the driving license of auto cab driving license. Another one is permit is violation.
Driving license was not there only.
Auto cab involvement of vehicle is auto rickshaw, my lords. Auto rickshaw cab license does not have at the time of incident was happened. This is only 2 points, my lords. In this respect, my lord, there is judgment of this honorable court as well as.
Let the money.
So we filed a appeal for enhancement of
That is
compensation.
connected, the 2015.
Yes, my lord. In that.
Connected matter.
Yes,
my
please.
lord.
We'll consider. Let him be there.
Date will fix, my lords.
19.
Please.
38. Appeal party.
The matter where penalty of compulsory retirement has been imposed, my lords. Honorably acquitted subsequently in the criminal case.
Honorably acquittal.
Honorably acquitted. Lordships will get the finding of the criminal court at page 165.
No.
Para 139, para 39 and para 40.
Honorable acquittal.
No, it's not honorable, no, it's not honorable, and it's not comes, my lord, any of the grounds which my lord has laid down.
Rudrappa.
Rudrappa Barodal. If you see the, my lord, order of the
PV Rudrappa.
PV Rudrappa.
Finding is that the complaint is ill motivated against me.
Anta idea.
Houdu. Para 39 and para 40, page 165. 166 nalli, I'll read that relevant part if your lordships. Page 166. Further conversation of the complainant. Page 166. Conversation of the complainant and IO has to be disbelieved on the ground that complainant hatched up a false complaint against the accused by dragging him to the present case. By cross-examining PW 1 to 4 and 8 and also PW 5 and 6, defense has tried to demolish the case of prosecution, and as such it is noticed that the complaint was ill motivated towards the accused.
Ill motivated. Complaint ill motivated is cover agatte.
No.
Yadadu? Rangabalu. Rangabalu, unfortunately, when I drafted that PV Rudrappa, that was not cited before me. Rangabalu says, Rangabalu, correct. It says, where complaint is ill motivated anta finding iddaga, malice anta iddaga, adu idana ayipodu.
No, may read the entire, my lord. He has read the only.
Cover agide.
Malicious ಅಂತ ಹೇಳಿದ್ರಾ?
ಅದು cover ಮಾಡಿ ನಾನು sentence ಇದೆ mostly.
Lord, if read the entire, Lord, evidence. But he only
Finding
reading.
ಇದೆ.
No, I know it's not, I'll read it, my lord.
ಇದ್ರ ಮೇಲೆ appeal ಹಾಕಿದ್ರಾ ನೀವು?
Yes, criminal appeal is pending.
Pending.
Yes.
Lord, in the, we see them, Lord, in the department inquiry proceedings.
ನಾವೇನ್ ಮಾಡೋದು? Pending ಇದ್ದಾಗ ಏನ್ ಮಾಡಕ್ ಬರಲ್ಲ?
My humble submission as regards pendency of appeal is, assuming I am convicted in the appeal, they have got a different remedy against me, my lords, under the rules. CCA rules 10(2)(b) says that they can keep me under suspension automatically on conviction. Then rule 14 says, dispensing with all other procedures of inquiry, they can impose penalty against me.
ಅಲ್ಲ, PV Rudrappa invoke ಮಾಡೋದು ಯಾವಾಗ ಅಂದ್ರೆ, where criminal appeal is not pending. Appeal ನ reverse ಆತಪ್ಪ, ಮುಂದೆ ಮಾಡ್ಬೇಕು.
That is why 10(2)(b) and rule 14 of CCA rules, if your lordships could kindly take, on conviction, there is a complete separate cause of action for them to proceed against me. On conviction, only on conviction.
ಅಲ್ಲ, only on conviction ಅಂದ್ರೆ they need not hold the inquiry at all.
Yes.
That's how Bhaskar Rao.
Rule 11 and 13 is dispensed
Straight
with.
away he can on the basis of proceedings attack.
Yes.
ಅವಾಗ ಬಿಟ್ಬಿಡ್ಬೋದು ಅಂತನಾ? Appeal ನಲ್ಲಿ ಅವ್ರು succeed
Yes, if they succeed in the appeal, my lords, again, my entire service will go automatically by virtue of the provisions of the rule itself. And another way,
as long as the, so even in such case, Rudrappa, PV Rudrappa holds the field.
yes. And why I would say this, my lords, I'll draw an analogy which if your lordships may kindly appreciate.
Yeah, analogy ಬೇಡ, ಎಂತದು ಬೇಡ. Dismiss ಅಲ್ಲಿ appeal ನ conviction ಆತು ಅಂದ್ರೆ ಇಲ್ಲಿ ಕಿತ್ಕೊಂಡು
ಹೋಗ್ತದೆ ನನ್ನ. That's all.
Covered by judgment.
We'll wait the.
Wait ಮಾಡಿ ಕೊಡೋದು.
ಅಲ್ಲ,
admit ಆಗಿ appeal succeed ಆಗ್ಬಿಡ್ತು ಅಂದ್ರೆ he will go to the jail. And there he need not no inquiry need to be held ಅಂತ.
That's the rule.
ಹಂಗಾಗಿ automatically, therefore PV Rudrappa benefit has to be given. Subject to outcome of the appeal. Appeal ನಲ್ಲಿ ಈ ಅಬ್ಸರ್ವೇಷನ್ಸ್ ಡಿಲೀಟ್ ಮಾಡ್ಕೋಬೇಕು, ಇಲ್ಲ ಈ ಎಕ್ವಿಟಲ್ ಆರ್ಡರ್ ನ ರಿವರ್ಸ್ ಮಾಡ್ಕೋಬೇಕು. ಎರಡು ಆಪ್ಷನ್ ಇದೆ ಅವರಿಗೆ. ಅಪೀಲ್ ಸೈಡ್ನವ್ರಿಗೆ ತಿಳಿಯಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಸೈಡ್ನವರಿಗೆ ಸರ್ವಿಸ್ ಲಾ ತಿಳಿಯಲ್ಲ, ಸರ್ವಿಸ್ ಲಾದವರಿಗೆ ಕ್ರಿಮಿನಲ್ ಲಾ ತಿಳಿಯಲ್ಲ. ಎರಡೂ ಸಪರೇಟ್ ಅವು, ನಾವು ಮುಟ್ಟಬಾರ್ದು, ಇತ್ಲಾ ಹೋಗ್ಬಾರ್ದು, ಇತ್ಲಾ ಇನ್ನೂರು ಅತ್ಲಾ ಬರಬಾರ್ದು ಅನ್ನೋ ರೀತಿ ಇದೆ ಅವರು. ಇದೆಲ್ಲ ಗೊತ್ತಾಗದಂಗೆ ಹೆಂಗೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ ಅವರು ಅಲ್ಲಿ. ವಿಚ್ ಇಸ್ ದಟ್ ರೂಲ್ which says once he is convicted, no disciplinary inquiry be held until.
Rule 14 of CCA rules. CCA rule 14 of CCA rules.
ಹೌದು ನೋಡು.
10. I'll start with 10(2). 10(2) says on conviction automatically I am on deemed suspension.
Deemed suspension.
Deemed suspension 10(2) ದಲ್ಲಿ ಆಗುತ್ತೆ. Then under rule 14 they can directly impose punishment against me, dispensing with rule 11 to 13.
ಯಾವ inquiry ಬೇಕಾಗೋದು?
ಏನ್ ಬೇಕಾಗೋದಿಲ್ಲ.
ಒಂದು ಆಂಧ್ರ ಪ್ರದೇಶ್ ಜಜ್ಮೆಂಟ್ ಇದೆ. ಆಂಧ್ರ ಪ್ರದೇಶ್ ಜಡ್ಜ್ BP ಜೀವನ್ ರೆಡ್ಡಿ ಅವರು ಆಂಧ್ರ ಪ್ರದೇಶ್ ಹೈಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಬರೆದಿದ್ದಾರೆ.
ಮೇರಿ
ಅಷ್ಟೇ ಅವ್ರ ಕೇಸ್ ಏನಿಲ್ಲ. ಮತ್ತೆ ಇನ್ನಿಂದ ಮತ್ತೆ ಅದರದ್ದೇ ಹೇಳ್ತಾರೆ. ಏನ್ ಹೇಳಿ
ನೋಡ
ಈಗ ಅವ್ರು ಹೇಳೋದು ಗೊತ್ತಾಗ್ತಾ ನಿಮ್ಗೆ?
ಗೊತ್ತಾಯ್ತು ನೋಡ್ರಿ.
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಆಸ್ ಆಫ್ ನೌ PV Ridrappa applies.
ಅದು ಬರೋದಿಲ್ಲ.
Suppose that appeal ನಲ್ಲಿ
ಕನ್ವಿಕ್ಷನ್ ಅಂದ್ರೆ ಆಟೋಮೆಟಿಕ್ಲಿ
ನೀವು ಎನ್ಕ್ವೈರಿ ಮಾಡೋ ಅಗತ್ಯ DE ಬೇಕಾಗೋದಿಲ್ಲ. Straightly I will go to the jail.
ಡೈರೆಕ್ಟ್ಲಿ ಆನ್
Bag and baggages ಅಂತ
ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀವಿ. ಡಿಸ್ಮಿಸ್
because of rule
14, rule 10(2)B.
10(2)B is suspension. 10(2)B. 14 ಕೆಳಗಡೆ.
But I am not disputing that position of law. What I am arguing is, my lord, in the departmental inquiry, the 3 witnesses were examined.
ನೋಡ್ಕೊಂಬರ್ರಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಾವು ಮಾಡ್ಕೊಂಬರ್ರಿ.
Please, if you read the, my lord, entire evidence, my lord,
ಎಂಟೈರ್ ನೋಡಕ್ ಬರಲ್ಲ.
ಅಲ್ಲ ಅದನ್ನ
ಮೋಟಿವೇಟೆಡ್ ಇದ್ದಾಗ ಎಂಟೈರ್ ನೋಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ತಾವು ರುದ್ರಪ್ಪ ಕೇಸಲ್ಲಿ ಹೇಳ್ತೀರಿ, ತಾವು ರುದ್ರಪ್ಪ ಕೇಸ್ ಬಗ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲಿ ಹೇಗೆ ಅದನ್ನ ನೀವು ಹ್ಯಾವ್ ಟು my lord, both the cases has to be, my lord, considered ಅಂತ. You not only, my lord, picking those, you have to read the entire case, whether he has honorably acquitted in that case or even a benefit of doubt ಅಂತ. If you read the entire judgment, my lord,
ಕಂಪ್ಲೇಂಟ್ ಈಸ್ ಇಲ್ ಮೋಟಿವೇಟೆಡ್.
ಅದಕ್ಕೆ ಯಾಕಂತ there is a reason. No, there is a reason why it is ill motivated ಅಂತಂದ್ರೆ, in the defense, my lord, in the cross examination, my lord, he hostile the witness, the complaint hostile, stating that, my lord, it is true that he has demanded 500 rupees from me, but that amount it is only for the purpose of, my lord, some fee which has to be paid, my lord, for securing the document anta. Certified copies. Adike na 500 rupees kottene anta he is turned hostile in the department inquiry in the criminal case. Adike court navaru, since he himself is telling that the 500 rupees which he is offered is for the
ನೋಡಿ ಡಿಮ್ಯಾಂಡ್ ಅಂಡ್
ಅದನ್ನೇ ಹೇಳ್ತೀನಿ.
No, there is a finding. I read that.
No, may read.
Come to page 165.
166.
160.
Demand.
160.
Para 41.
40. Further 14 ಓದ್ತೀನಿ ನೋಡಿ. 14 ಓದ್ತೀನಿ. Para 14. Para 14.
Para 40?
40 of the judgment and there.
Page 165.
Which he has read, 165. Further, the payment of 500 by the complainant to the accused was voluntary because there is no evidence by the PW1 or PW2 that the accused has demanded the said amount from the complainant. Upon testing the said evidence with the reference to Exhibit P1, the said contents of Exhibit P are not corroborated by PW1 to 3 and 8. PW4 Tahsildar has not fully supported the prosecution by saying that the conversation was not clearly audible. Further, the Exhibit P to 18 photos are not clearly explained to say, so as to say that who is PW2 and who is P3.
Finding it that it's a false case antad. Finding
it is very difficult to say that who is PW2 and 3 only on the basis of the said photos without there being any identification marks to the picture of the person seen in the photos. Further, the conversation of the the conversation of the complainant and the IO has to be disproved on the grounds that the complainant has up a false complaint against the accused by dragging him into present case by cross-examining PW2 1 to 4 and 8 and also 5 to 6. The defense has tried to demolish the case of prosecution and such it is noticed that the complainant was ill motivated towards the accused.
False case and finding ಇದೆ.
That is yadike anta alla yadike false case antandre if you read the entire gottadre adike tavu melod if you read the melod evidence in the
case not proved, guilt is not proved to the guilt.
ಅದಕ್ಕೆ ಮುಂದೆ
I would have understood.
41 ನಲ್ಲಿ ಹೇಳ್ತಾರೆ ಯಾಕೆ ಪ್ರೂವ್ಡ್ ಅಂತ 41 ನಲ್ಲಿ ಮುಂದೆ ಹೇಳ್ತಾರೆ. In the present case, the complainant has stated that the fee which was to pay to the government has been paid by him. Even in the words of the complainant, in nutshell, this has been stated so mamuli, simply usual. So the said presumption which was drawn has been reverted by the defense through the PW1 himself. There was no demand of illegal gratification and acceptance of bribe amount, and that the testimony given by PW1 to 3 and 8 have not been
Demand and acceptance illa anta first
corroborated, and therefore
Second,
it can
false,
be said
case
that
anta
the
innೊಂದು.
presumption under section PC Act has been disclosed. And further, it is stated that the evidence of the IO cannot be accepted as there was no corroboration between his version as of the version of 303. Therefore, on the opinion, the prima facie prosecution has failed to prove his case beyond all reasonable doubts.
Demand and acceptance. ಎಷ್ಟು ರೂಪಾಯಿ 500 ರೂಪಾಯಿ
500 rupees.
ಎಷ್ಟು ದೊಡ್ಡ ಅಮೌಂಟ್ ನೀವು ಎಷ್ಟು
500 rupees ಗೆ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಡಿಪೆಂಡ್
ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನೋ ಬಗ್ಗೆ ಫೈಂಡಿಂಗ್ ಇದೆ. ಎರಡನೇದು ದೇರ್ ಇಸ್ ನೋ ಡಿಮ್ಯಾಂಡ್ ಅಂಡ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅಂತ ಫೈಂಡಿಂಗ್ ಇದೆ. ವೇರ್ ಇಸ್ ದಿ ಕೇಸ್ ಫಾರ್ ಅಗೇನ್ಸ್ಟ್ ಯು?
ತಾವು ಮಿಲಾಡ್ ಮೈ ಗ್ರೇಟ್ ರೆಸ್ಪೆಕ್ಟ್ ಮಿಲಾಡ್. This court is examining the evidences of the criminal code.
Correct.
Testimony into them. If you see the evidence which adduced in the department inquiry, Milord, it will clearly found that in the department inquiry, in the chief examiner, he admit
ಏನಂತ
500 rupees demand ಮಾಡಿದ್ದು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾನೆ ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾನೆ. Read the Milord, may read the running case 56 Milord.
ಇದು ಆನರಬಲ್ ಎಕ್ವಿಟಲ್ ಇದು ಆರ್ಡರ್ ನ ಇದರಲ್ಲಿ ಡಿಸಿಪ್ಲಿನರಿ ಎನ್ಕ್ವೈರಿ ಕನ್ಸಿಡರ್ ಮಾಡಿರೇನು?
ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ. ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ಮೇಕ್ಸ್ ನೋ ಸೆನ್ಸ್ ಬಿಕಾಸ್ ಆಫ್ 14 ಇತ್ತು ಅಂದ್ರೆ ಅಲ್ಲಿ ನಾಳೆ ಕನ್ವಿಕ್ಷನ್ ಆಯ್ತು ಅಂತಂದ್ರೆ 14 ಕೆಳಗಡೆ ಜೈಲಿಗೆ ಹೋಗ್ತಾನೆ.
ಪ್ಲೀಸ್ ಬಟ್
ನೀವೇನ್ ಡಿಸಿಪ್ಲಿನರಿ ಹೋಲ್ಡ್ ಮಾಡಕ್ ಪ್ರಶ್ನೆ
ಇಲ್ಲ ಯಾಕೆ ಮತ್ತೆ ಒಂದ್ ವೇಳೆ ಅಲ್ಲಿ
ಮತ್ತೆ ಅದು ಕನ್ಫರ್ಮ್ ಆದ್ರೆ ಮುಗಿದು ಹೋಗ್ತೀವಿ ನಿಮ್ ಕೇಸ್.
ಅದಕ್ಕೆ ನಾವು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇನ್ಕ್ವೈರಿ ಹೋಲ್ಡ್ ಮಾಡ್ತೀವಿ. ದಟ್ ಸೈಮಲ್ಟೇನಿಯಸ್ಲಿ ಮೈ ಲಾರ್ಡ್ ವಿ ಕ್ಯಾನ್ ಕಂಡಕ್ಟ್ ಬೋತ್ ದ ಕೇಸಸ್. ಬರ್ತದೆ
ಫಾಲ್ಸ್ ಕಂಪ್ಲೇಂಟ್, ನೋ ಡಿಮ್ಯಾಂಡ್ ಅಂಡ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್.
ಅದಕ್ಕೆ ಅದು ತಪ್ಪು ಅಂತ.
ಎರಡು ಕಾರಣಕ್ಕಿದ್ದಾಗ ಹೆಂಗ
ಫಾಲ್ಸ್ ಕೇಸ್ ಅಂದ್ರೆ the reason is not he in the cross examination in the evidence he admitted that not this 500 which is demanded is not for the bribe but as a fee anta adike false.
ಇದೇನು ಪನಿಷ್ಮೆಂಟ್ ಏನು?
Compulsory retirement. And I'm moreover my lord the trap was successful and he is my lord he is red-handedly my lord caught my lord while receiving the 500 rupees and his my lord hands were turned to pink. That's all my lord that is proved in the evidence.
ಎಷ್ಟು ಪ್ರಮೋಷನ್ ಮಾಡ್ಕೊಂಡಾನೆ?
ವಿಲೇಜ್ ಅಕೌಂಟೆಂಟ್
ಅಂದ್ರೆ ದುಡ್ಡು ತಗೊಂಡಿರ್ತಾನ.
ಅದು ಹೊನ್ನೇಗೌಡ ಅಂತ ತಾವು ಜಡ್ಜ್ಮೆಂಟ್.
Even if your lordships could kindly see cross examination of PW1 before the departmental inquiry, ಅಲ್ಲಿ what he says is ದುಡ್ಡು ಕೊಟ್ಟ ನಂತರ ಕೆಲಸ ಲಘು ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೋಗಿ ನಾನು ಲೋಕಾಯುಕ್ತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟೆ ಅಂತ. That is what he says. Page 48 of the cross examination. If your lordships could kindly take
48
ಹೌದು. ಆರೋಪಿ ನೌಕರರು ದಾಖಲೆಗಳನ್ನು ಹೇಳಿದ ಸಮಯಕ್ಕೆ ಕೊಡದೆ ನನ್ನ ಕಚೇರಿಗೆ ಅಡ್ಡಾಡಿಸಿದ ಕಾರಣ ನಾನು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟೆ. Page 48 last 3 lines. ಆರೋಪಿ ನೌಕರರು ದಾಖಲೆಗಳನ್ನು ಹೇಳಿದ ಸಮಯಕ್ಕೆ ಕೊಡದೆ ನನ್ನನ್ನು ಕಚೇರಿಗೆ ಅಡ್ಡಾಡಿಸಿದ ಕಾರಣ ನಾನು ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟೆ.
It is cross evidence. In the evidence, he admit everything. But in a cross, my lord, it's slightly given. But along with that, my lord, if you read the shadow witnesses along with the inquiry officer, and everything is clear. Shadow
51. He says government ಗೆ ರೊಕ್ಕ ತುಂಬಲಿಕ್ಕಿತ್ತು ಅದಕ್ಕೆ ಕೊಟ್ಟೆ. The same stance that it was paid towards payment of government statutory fees, that is again there in 49, page 49.
ಶುಲ್ಕ ಕಟ್ಟಲು ಹಣ ಕೊಡಬೇಕೆಂದು ತಿಳಿಸಿದ್ದರು. ನಾನು ಇದ್ದೆ. ಆರೋಪಿತ ದಾಖಲೆಗಳನ್ನು ಹೇಳಿದ ಸಮಯಕ್ಕೆ ಕೊಡದೆ ನಾನು ಕಚೇರಿಗೆ ಅಡ್ಡಾಡಿಸಿದ ಕಾರಣ ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದೂರು ಕೊಟ್ಟೆ.
ನಾನು ಟ್ರ್ಯಾಪ್ ದಿನ ಆರೋಪಿತ ನೌಕರ ಕೊಟ್ಟ 500 ಹಣ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳ ಕಡೆಯಿಂದ ದಾಖಲೆಗಳನ್ನು ಪಡೆದು ಕಟ್ಟಬೇಕಾದ ಶುಲ್ಕದ ಬಾಬತ್ತು ಕಡೆಗೆ ಕೊಡಲಾಯಿತು ಎಂದರೆ ನಿಜ.
ಯಾವುದು ಕ್ಯಾಶ್ ಆಗಿ
49
ನೋಡಿದ್ದೀನಿ ಎವಿಡೆನ್ಸ್, ಕ್ರಾಸ್ ಎವಿಡೆನ್ಸ್.
500 ರೂಪಾಯಿ ಆ ಶುಲ್ಕದ ಸಲುವಾಗಿ ನಾ ಕೊಟ್ಟಿದ್ದೆ ಅನ್ಕೊಂಡು ಹೇಳಿದ ನಾವು.
ಅದಕ್ಕೆ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅವಂದೇ ನೋಡೋದು ಫಸ್ಟ್. ಚೀಫ್ ಅಲ್ಲಿ 45
ಅಲ್ರಿ, ಚೀಫ್ ನಲ್ಲಿ ಕ್ರಾಸ್ ನಲ್ಲಿ ವೇರಿಯೇಷನ್ ಇದ್ರೆ ಯಾವ್ದನ್ನ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಬೇಕು?
I will go to an extent, no, he is entirely turned hostile. I will assume for the movement to prove my case. Hostile alla, ಅದಕ್ಕೆ ಅಲ್ಲಲ್ಲ. I'll go and say in the chief examination he supported my case that he has given a complaint, bribe, everything. In the chief, in the cross examination, he supported the complainant, the accused. My lord, I will ignore the entire evidence. My lord, I will only rely, my lord, the trap which conducted. Now the you also can turn to, my lord, shadow witnesses, my lord. The government servant.
He is not
51
treated hostile after chief
51
examination.
51 element. I know the DGO was village accountant. He is entirely agreed, my lord, that the police was given a complaint to given civil, and we have read some of them. The police, the philanthropy powder and the said currency notes, and after recording its numbers, the said notes were kept in the short packet. Then the police washed both the hands of in solution, and the said was turned into pink color, and same was collected in bottle and sealed, and everything, my lord, he supports.
Next. We'll consider the detail hearing. Consider.
Lordship, sir, kindly take it for further hearing. Move The third time it is listed before your lordship.
Is that even in review the criminal case also in DA we are able to prove.
Independently, I can prove.
Shadow witness says, "Nanagenu clear case illa gadlu bhal ittalle." Even in the disciplinary inquiry, he says so. Nanagenu case illa gadlu bhal ittu. This has taken place in
ಯಾವುದೇ revenue record by hand 500 rupees ಅನ್ನ ತಗೊಂಡು document ಕೊಡ್ತೇವೆ ಅಂತ. There is nothing.
May I request date may kindly be fixed, my lords.
Week of
Please.
the other date. Next week ಜಾಸ್ತಿ ಇದಾವಲ್ಲ 26 ಒಂದೆರಡು admission
Meeting ಅದ
first ಯಾವ admission notice ಆಗಲ್ಲ
admission meeting ಇದೆ
serial number 39
Supreme Court
39 ready
Ready, ಇನ್ನೊಂದು 4 ಮ್ಯಾಟರ್ ಇದಾವ ಸ್ವಾಮಿ.
this is based on LSC 146 of 2009 no
Please, my lord.
on that if everything is correct 4 lakh or something amount
ಇಲ್ಲ ಸ್ವಾಮಿ, ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 162 rupees per square foot ಕೊಟ್ಟಿದ್ದಾರೆ. 162 rupees per square foot ಆಗಿದೆ.
from same notification
ಅಲ್ಲ, subsequent notification 1 year difference, my lords, 1 year different, my lords.
ಕೊಡಿ ಅದೆಲ್ಲ
Accord ಇದೆ ಸ್ವಾಮಿ.
list along with MFA number so and so date ಕೊಡಿ ಅದು. Where is that
Along with synopsis and judgments, I will produce, my lords.
produce that
With all those things.
otherwise
Please, my lords,
4
we'll
lakh
produce.
10,000 is
No, no, no,
correct
we'll
because they are
produce,
not
my lord.
produced any evidence
These are judgments, my lords, we will produce it.
ಕಾತೂರ್ ಅವ್ರು ಏನ್ ಇದ್ರಲ್ಲಿ
Lords, next week.
ಎಷ್ಟು ಅಮೌಂಟ್
Death of
40% ಅಡಿಷನ್ ಆಗಬೇಕು.
ಹೌದು.
ಇನ್ಕಮ್ 7,000 ತಗೊಂಡಿದ್ದಾರೆ.
8,750 ಆಗ್ಬೇಕು. 8,750.
8,750
750.
ಅಷ್ಟಾಗಬೇಕಾ?
ಆಮೇಲೆ ಕನ್ವೆನ್ಷನ್ ಹೆಡ್ಸ್ 55 20 20 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು
8750 ಅಲ್ಲ?
ಹೌದು.
ಪ್ಲಸ್ 40%.
ಪ್ಲಸ್
3,500.
12 ಮಲ್ಟಿಪ್ಲೈ ಇದೆಷ್ಟು?
ಮಲ್ಟಿಪ್ಲೈರ್ 18 21 years.
21 years.
21 years.
Multiplier 18.
18. ಕನ್ಸೋರ್ಷಿಯಂ
50,000 ಕೊಟ್ಟೆ, ಅದು 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೆಚ್ಚಿಗೆ ಆಗಿದೆಯೋ ಕಡಿಮೆ ಆಗಿಲ್ಲ.
ಅದು 44.
ಎಂಟು ಒಬ್ಬರೇನಾ?
ಒಬ್ಬರೇ 40 plus 30 ಅಂತ ಮಾಡಿ
6,500 16,500 ಅಷ್ಟೇ.
ಹೌದು,
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ದೆ.
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಆಗಿದೆ. ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ will be 5,67,000.
ಆಯ್ತು ನೋಡ್ಬಿಟ್ಟು. Yes. ಕಳಿಸಿ ಆ ಫೈಲ್.
Please.
Next 41 notice.
41, my lords. Husband's appeal, your lordship.
Pay expenses, litigation expenses of 20,000. Issue emergent notice.
10,000.
Subject to appellant paying rupees 20,000, depositing rupees 20,000 as a litigation expenses before this court.
A private school ಅಲ್ಲಿ ಇದು 10,000 rupees ಅವ್ರದ್ದು
Husband service ದಲ್ಲಿ ಇದ್ದಾರೆ.
salary
ಏನು ಇಲ್ಲ.
salary 10,000 ಇದೆ ಸರ್.
ಇರ್ಲಿ ಮಾಡಿ 20,000.
10,000.
salary ಏನು ಏನ್ ಮಾಡ್ತಾರೆ?
ಪ್ರೈವೇಟ್ ಸ್ಕೂಲ್ ಅಲ್ಲಿ ಟೀಚರ್ ಇದ್ದಾರೆ.
ಯಾವ ಸ್ಕೂಲ್ ಅಲ್ಲಿ 10,000 ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ? ಪ್ರೈವೇಟ್ ಸ್ಕೂಲ್ ಟೀಚರ್ should get equivalent salary of the government school ಇದೆ section 30.
ಹಂಗ ಅಂತಾರೆ ಸ್ವಾಮಿ, ಕೊಡುದಿಲ್ಲ ಪೇಮೆಂಟ್.
Who is the respondent is entitled to withdraw on appearance.
42 GN Raichur.
Emergent notice, interim order of stay of the judgment and award of the tribunal subject to deposit of 50% of the award amount before the tribunal within a period of 8 weeks. The tribunal shall redeposit ಅಂತ ಇದೆ ನೋಡಿ. Yes, call for TC. ಕಳಿಸ್ಬಿಡಿ ಅದು ಫೈಲ್.
Okay, Baba,